call the Judiciary Committee to order, and I want to apologize to folks for starting late. I know we have a busy day, and we just couldn't be helped. So first, before we begin, I'm going to ask Representative Andrus if she would lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And
Mr. Chair?
yes,
Before you start, could I ask you a question?
of course.
Thank you very much. It's come to my attention that on Monday, when we have a hearing on a bill, that there is going to be an amendment that is of a, I would call non-germane, but apparently the speaker doesn't, that will go to the committee. And I wonder if you will be making that public before the hearing so that people who come to testify will know what is likely to transpire.
Yes, the answer to that question is yes. My understanding was a little bit different than yours, and there that not that the speaker had determined that the amendment was germane, but that we needed that we would have because it was non-germane, we would have a hearing on the amendment as well as on the bill, and we will do both of those on Monday. But the answer to your question is yes. I think the rules require that there be if there's a an amendment that is non-germane, that it be available. I think 24 hours in advance, and yes, it will be available.
And so that will appear also in the calendar that comes out
It
tomorrow?
will appear in the calendar. Yes.
Thank you very much. I appreciate that, Mr.
Yep.
Chair.
Thank you. So the first bill we're going to open the hearing on is House Bill 66, and since I'm the prime sponsor, I'm going to leave this seat and turn it over to the vice chair.
Thank you. I recognize Representative Lynn to introduce the bill on House Bill 66.
Thank you, Mr. Chair and members of the committee. I am the prime sponsor of this bill, and as you will see, this bill is designed to accomplish a couple of things. The primary thing that it is designed to do is to remove the word citizen where it appears in the right to know law, and to replace that with the term any person, so that it would permit any person to make a request for any information that is subject to the right to know law. I should note that although the right to know law, as it has existed for a number of years, in a couple of places, which are specifically, you can see those places in the bill because I replaced citizen with any person in the proposed legislation. But although the word citizen is used at a couple of places in the bill, it's important to understand that until an issue arose a couple of years ago, I think, regarding Rochester, where the the municipality took the position that someone was not entitled to receive certain records because they were not a citizen of New Hampshire. That issue had never, as far as I'm aware, and I think there are other witnesses who may have done more research on this than I have, but that it had never been an issue about who was entitled to request information. And as I understand it, and again, I stand to be corrected on this, but my understanding is that in the past there have been requests made, particularly by business interests who were out of state, requested information from either from the state or some municipality for some purpose, some legitimate business purpose, but they were out of state. At any rate, it had not been an issue. So this is designed to remove the requirement of citizenship. And incidentally, I should just point out that where the current law uses the term citizen, it doesn't say what that means. Is it a citizen of the municipality? Which, that's one possible interpretation. Is it a citizen of the state of New Hampshire? Is it a citizen of the United States? I mean, I suppose some people could say, is it a citizen of the world? If the court were to interpret it that way, then I guess maybe we wouldn't have to have this change. But I think it's not at all clear what the word citizen was intended to mean. The other thing that this bill does is it basically says that if you are requesting information, you as the requester kind of have control over the way you want the information, and as long as, and I'm sort of I'm summarizing here rather than quoting the language of the bill, but it basically says you as the requester have the right to ask that the information be provided in the format that you want it. So if you want it electronically, you can ask for that. If you want it in paper, I guess you can ask for that too. The only restriction is that the municipality or the respondent governmental body does not have to provide it in a format that they don't have, or that is kind of unusual, or if the request would be unduly burdensome or would somehow pose a threat to the integrity of the record of your record keeping system. So if any of those situations exist, then the municipality can legitimately say no, where you've asked for it in this format, but we can't do that for legitimate reasons of security, or it's unduly burdensome, or whatever. But unless they can say that, then they have to comply with your request. And I think the concern there is it shouldn't be the case that a governmental body can kind of discourage you from a request by basically saying, well, you can get this information, but you have to come to the municipality. You can't ask for it electronically. You have to come to the municipality to make the request, or we're only going to give it to you in a hard copy, and we're charging you whatever the charge can be per page, whereas it would be a lot less expensive and a lot more convenient if they could just request it electronically. So that's what the other thing that it's designed to accomplish. And then the third thing is, and this is at the I included this at the suggestion of my colleague behind me, Representative Edwards, to specifically put in the sections that you'll see it in, a specific reference to that among the documents that have to be provided are preliminary drafts that are circulated to a quorum or a majority of the public body. Now, I should point out there that this is not really even if we didn't have that, even if we didn't put this language in, there's other language in the right to know law, even at present, that basically would require that to be provided anyway. But apparently it has, there's been some question about that. And so we wanted to have it placed in in a spot where it would be very obvious that this is specifically covered. And I think that makes sense because my understanding of the law is that it is covered, but we just want to make it absolutely clear. And so, maybe in some sense we're being a little repetitive, but in this circumstance, I think it makes sense. With that, we have a busy day, and I'm going to shut up, and I'll be happy to take any questions that anyone might have.
Thank you. Any questions? Representative Birch?
Hit the button. Thank you, Mr. Chair, and thank you, Representative, for taking my question. Actually, I have two. My first question is just to be clear on the any person and understanding that under current theory, corporations are persons and the like, there's no limitation then on anyone worldwide, anywhere, making a request. Person doesn't have to show up. Could be as much a bot farm in Russia. It could be, somebody anywhere. There's no limitation. Is that right?
No, that's true. And that you're sort of touching on a discussion I had with my colleague behind me just before we got started this morning. It's true. I mean, and I suppose that could be a concern. I guess what I would say in response to that is this. If we were to say instead, citizen means citizen of New Hampshire and only a citizen of New Hampshire or a domiciliary of New Hampshire, I wonder whether that would really be much of a restriction. In other words, if you had, the bot farm in the bad actors in Russia or China or the Middle East or whatever that wanted to request some information from some municipality in New Hampshire, would they really be deterred? I mean, would they really not be able to find some dupe in New Hampshire to be able to make the claim for them? It seems to me, would that be a real restriction, a real limitation, a real protection against those kind of bad actors? I tend to think not. More importantly, I think this is the other thing I think is really important is, even though the only time that this issue of citizenship was raised was, as I said, was in this Rochester case, I'm not aware that over, however many years the right to know law has been in effect, we've had that kind of problem that, bad actors in Syria or China or whatever have been requesting information from, municipalities. So that's probably too long an answer.
Yes, go ahead.
Just a second quick question, and related to that is the funding. There's no limit on the cost of this bill, which I gather will be borne by municipalities and towns rather than the state. Do you have, since the fiscal note kind of shrugs and says we can't even calculate how much of this is going to cost, do you have any sense of what additional tax burden will be placed on municipalities and towns?
I guess again I come back to given that there has never been, as other than this Rochester case, there has never been an issue about limiting the requesters. I'm not sure that there really is a basis to say this is going to cost, either municipalities or the state more money. In fact, in some ways, it may be that it would be by making it more, by allowing municipalities to respond in more efficient ways. It may be that it actually saves money. I don't know. The short answer is I really don't know.
Thank you.
I'll save it for the next.
Representative Alexander?
Thank you, Mr. Chair. Thank you, Representative, for taking my question. My question is around the impetus of adding on page 1, line 17, the preliminary draft circulated. Can you speak to that? I guess I want to give an example. Like, I'm chair of the Goffstown Budget Committee, and we might have circulated a draft of like the presentation we are going to distribute during a public hearing, and we may not want to have disclosed it right away, seeing how it might have incorrect information or, it was a working document. So my concern is that it may add to confusion for members of the public to have these working documents disclosed. So I'm wondering what the impetus was behind adding that part into the bill.
I think that it may be that Representative Edwards can give you more detail than I can, but my understanding is, and I think he's correct on this, that those materials would already be included under the existing language of the right to know law. Please understand, I'm not saying that there's some language that says preliminary drafts circulated to the majority, but I think there is language that says if documents that are provided to the majority of a committee are covered by the right to know law. And so I think, could there be I don't suggest that there couldn't be some people who might be confused with a preliminary draft if it was later changed, but I guess that's it. The burden is on them to make sure that that it's a final version before they if they're going to take a position on it or something.
Any other questions? None? Seeing none, thank you very much.
Thank you.
Representative Edwards, do you want to speak on this bill? I don't have a pink card. I have one for...
No, I'm going to speak on 74. They're so close anyways. I can talk to 74 and it'll be relevant to 66.
Okay. Thank you. So you're speaking on 66 right now?
Then I'm going to sit down because I thought you were.
I thought you wanted to speak
74
on
next.
66. I have
I'm
other...
just biting at the bit.
Okay, I have other speakers here that have pink cards in on 66, so...
I could, if you wanted me to, answer
Thank you. The chair recognizes Cordell Johnston. Thanks so much. Yeah, no problem.
Thank you, Mr. Chairman. My name is Cordell Johnston. I'm an attorney in private practice. I represent a small number of municipalities. My law practice is limited to representing cities and towns. I also represent the New Hampshire City and Town Clerks Association, although I am not here on their behalf. I am not their lobbyist. They have someone else who does that. I'm speaking only for myself. And I oppose most of what's in this bill. My concern is not so much the part about changing every citizen to any person, although I would prefer that stay the way it is. My concern is the part about having to deliver governmental records to anyone who asks for them. Because right now, and there's been a few references to people out of state making requests for governmental records. And when they do, it usually has nothing to do with the purpose of the right to know law, which is open government. Usually it's some business entity that is trying to drum up business. The dog food company wants a list of the people who have licensed dogs, or the real estate company wants a list of real estate transactions. Sometimes it's a political thing. I've seen requests from both the Democratic and Republican parties, sort of on fishing expeditions, with a law firm from Washington asking for all kinds of election information. And under the current law, the response is, what I tell my clients is, you are welcome to get this information. It is available at the town hall. And you can come and get it. You know, these are our hours. That almost always puts an end to it because it really is a fishing expedition. The local residents who are actually interested in open government, want to know what their town is up to, they have no problem coming to town hall and getting the records. And in fact, in most cases, or in a lot of cases, the town will just email it to them just as a courtesy. But they are not required to do that. The current law says you can come to town hall and get it. And my concern is that under this bill, lines 27 to 28 on page 1, I think it's page 1, yeah. The public body or agency shall provide such records electronically or by mail. So, Mr. Chairman, you talked about making it easier because they can send it electronically. If I'm the bad actor in Russia or wherever, I can say, I want you to mail these to me. I want the selectmen's minutes for the last 20 years. And the town clerk is going to have to make hard copies of those minutes, box them up and send them to me in Russia or Burkina Faso or wherever I am. That's a huge burden. And those requests from out of state or even out of country, they don't come in every day, but they come in fairly often. I've seen that for all of the towns that I represent. So that is a huge burden, and I urge you not to do that. As I said, you know, the purpose of the right to know law, and the Supreme Court has said this on many occasions, is to enable citizens to know what their government is up to. It's not to be a research arm for a business or, you know, a doctoral student who's working on his thesis and wants to do research about town meeting law in New Hampshire for his PhD at the University of Oregon. When those out-of-state interests are, as I say, on a fishing expedition to see, oh, what's the law in New Hampshire, please don't make local government workers, don't make the town clerk or the town administrator go back into their documents and pull those out and make copies of them and send them to these people who have no interest in the actual town government. I would also comment, if I'm a citizen and I want these records and I want them electronically, I already have the right to get them electronically if they exist electronically. The Supreme Court has said if they exist electronically and it's reasonably possible to provide them electronically and the person asks for them electronically, you have to give them electronically. So I don't think that's a problem. The last thing I would say is I agree the part about preliminary drafts, I think it's very clear those are already subject to disclosure if they went to a quorum or a majority of the body. Representative Alexander's concern, I understand it. When one of my towns asks me about that, I say, don't send it. If you don't want to disclose it, don't give it to a majority of the body. As long as it's just a draft and it doesn't go to a majority, it's not disclosable. But if it goes to a majority, it is. So I don't think you need that. It doesn't really hurt to put that in there, other than I think it clutters up the law. And I'm not in favor of adding stuff that you don't need. It wouldn't be the end of the world if you had that, but I just don't think it's necessary. And that's all I have, and I'd be happy to answer questions.
Great, thank you. Questions for, yes, Representative Smith.
Thank you very much, Mr. Chair. Welcome, Mr. Johnson. It's good to see you again. We haven't seen you for a while here
you.
since you've left the Municipal Association.
Nice to see you, those of you who I used to know.
I think you've had enough experience here to want to know that one thing we do not do is ascribe to others their motives as to why they are doing something. And a lot of your testimony was based on ascribing the motives of others. Excuse me. I am particularly interested in knowing, were you still at the Municipal Association when the Rochester case unfolded?
No, I was not.
And do you have, could I just ask one more question?
Of course, yes.
Do you have any opinions on the decision of the court on the Rochester case?
Actually, did that go to the Supreme Court? Okay, so I don't know that much about it, but what I heard is, I think it was a newspaper maybe based in Maine that wanted the information, and the city said, you're not a New Hampshire resident, so you don't get it. And I may be wrong about that. People behind me may know more about it than I do. I'll tell you, if I had been advising them, I would have said, just give it to them. You know, it's not a big deal. And I mean, I don't have any problem at all with the idea that the Boston Globe or the Burlington Free Press or the Maine, Portland, whatever it is, should be asking information and getting it about government in New Hampshire. They cover New Hampshire, and that's fine. So, as I say, my concern is not so much any person, it's you have to deliver it to them. And if I got, one of my towns got that request from a newspaper in Maine, I would probably say just send it to them. But if they want, I'd say, tell them it's here, you can come and get it. But I wouldn't deny the request. And going back to motives, I agree, we don't need to ascribe motives. My only point is, if you're going to require town employees to send stuff to anyone who asks for it anywhere in the world, that's a big burden.
Thank you.
Other questions? Yes, Representative Petronell, and
Thank you, Mr. Chairman, and thank you for answering my question. My concern is I live on Lake Winnipesaukee, and not on the lake, but near the lake, and in a town on the lake. And we have a lot of people who have second homes and things like that. Would there be a definition of someone who could request information from a municipality that would include someone who owns a residence or a business in New Hampshire, but is not necessarily a citizen of New Hampshire? That's where I'm having a hard time with this, because it certainly needs to be broader than somebody who's just living in New Hampshire or a resident of New Hampshire or a voter in New Hampshire, because there are other people who have property rights in New Hampshire.
I think that may be addressed in the next bill, House Bill 74. And again, if you want to say anyone who is a resident of or owns property in or is a taxpayer in the state of New Hampshire, that's fine. And again, even if you don't limit it to that, my concern is not so much requests from out of state, but the obligation to deliver the records.
Thank you very much.
other questions? Yes, Representative Bergeron.
Thank you, sir. Thank you, Mr. Chair. I had a question on D. I believe that's page 2.
Okay.
It said the public body or agency shall not require to provide records electronically if it lacks the technological capability. And I'm just wondering, is there any responsibility on the part of that particular business to either classify themselves or inform somebody that they're not technologically capable, or how does that work?
I think under this bill, and I don't think that really changes the law, because again, as I said, the Supreme Court has said if you have it in electronic format and can provide it reasonably, you have the obligation to do so. So whether under current law or under this, if a town receives a request and the requester wants the information in electronic form, and say it's, I don't know, something from the 1850s that exists only on paper and it's a very small town, they don't even have a scanner, or they're concerned about damaging the document or something like that, they would just say, we don't have the capacity to do this, or it would present a risk of harm, and therefore we'll provide this in paper form only. And it would just be a statement like that, I think.
Follow up, sir?
Yes.
So at this point, people don't have to report the fact that they're not capable or anything of the such.
Currently, again, if someone requests something in electronic form and the town can't provide it in electronic form for whatever reason, they would have an obligation to say, we cannot provide this in electronic form because we don't have the capability, or for whatever reason.
Thank you,
Other,
sir.
other questions for this witness? Seeing none, thank you very much, sir.
Thank you.
Next, I'm going to call on Gilles Bissonnette. Mr. Bissonnette, welcome.
Welcome. Thank you, Mr. Chairman. Thank you.
No, red it's on.
Okay.
There you go.
Thank you. Thank you. I've been doing this long enough, you would think. Thank you, members of the committee, Mr. Chairman. My name is Gilles Bissonnette. I'm the legal director of the ACLU of New Hampshire. We're here in support of HB 66, and I just kind of want to walk through the reasons why we think this is a very positive bill for transparency, but also a very modest and reasonable one. And so those are the things I'd like to talk briefly about. First, I do want to just address Representative Alexander's comment on the preliminary drafts piece. That is not going to be the focus of my testimony, but we are not opposed to the language here, mainly because I think the language dealing with preliminary drafts here in the meeting context roughly mirrors the exemption language for documents in 91A5, which does exempt preliminary drafts. I actually think it makes some sense to create parity with respect to exemptions in the public meeting context and in the documents context. And I also just want to echo and thank the committee and Chairman Lynn especially for his work on this bill. This bill does have some history. This committee dealt with a similar version of this bill last year with respect to 1069. I do just want to kind of get a couple things out of the way. I think there's been just some discussion of Russian bots, or foreign agents doing document requests to our cities and towns. I am not aware of that happening in New Hampshire. So I just want to highlight that. I know there are always concerns, with respect to fishing expeditions, with respect to individuals and entities making requests. But of course, I think one city or town's view of a fishing expedition is another person's view that they're making legitimate efforts, right, to try to learn what their government is up to. And I always operate under the assumption that people are engaging in good faith requests. And that has been my understanding and what I've witnessed in the 12 years I've been in the state, and myself have been making requests for information for government entities. First, I want to get to the question of citizenship, or that change that's being made here from citizen to person. This is clarifying. This doesn't actually, in my view, change the law at all. So it is not going to add any cost to cities and towns that are not already born. So I just really, I think, want to make that very clear, that I think the notion that it is person, not citizen, is already reflected in case law and how RSA 91A has traditionally been interpreted with respect to who is eligible for making requests. And that's because you need to look at this statute in its full context. So in other provisions of 91A, there are phrases with respect to any person aggrieved. There are phrases that talk about the public or people. That's in Part 1, Article 8, our constitutional analog to the right to government transparency. And so when you look at that statute in context, until recently, it has really always been viewed as any person could make a request, is eligible to make a request. Now, until recently, we've seen, I think, what I view as an outlier interpretation by one city and town that that's not what it means. And fortunately, the courts have resolved that. It said that isn't what it means. But I do think, I always respect and appreciate, let's clarify the law if there's any ambiguity so any individual can read a statute and understand what their rights are. And I think that's what this clarifying language does. But in my view, it doesn't expand 91A or really in any way change the law and how we have all kind of historically viewed who is eligible to make a request. Again, with respect to the citizenship question in this change, I have heard some comments, some concerns about burdens. We actually last year, I think, made some accommodations to address the concerns that cities and towns had about burdensome requests. So that is the lens, that I think is the vehicle if cities and towns have concerns where they can have those concerns raised. And to be very clear about that, that bill was HB 1002. And what that did was impose certain costs on voluminous requests with respect to communications that were in excess of 250 communications. So I think that was very reasonable. And in return, frankly, I think we should be making reasonable changes here, not only with respect to the clarifying language concerning person and eligibility to make a request, but also with respect to what I think has become, I think, an unfortunate practice, not all towns, but some cities and towns, when it's really easy for them to mail or email documents to say, nope, you need to come and show up. This has happened to me and others, including media outlets. We identify in our testimony some cities and towns that have done this. So I'll give you an example, a very clear example. I or anyone wants a 2-page police report. It's not memorialized in an email file. It's a document that's electronically maintained that is or can be converted into a PDF. Hey, can you just send me the police report so I don't have to travel 50 miles? Or if someone wants a disability, they don't have to, get out of their house to get access to it. And cities and towns, many, I don't want to say many, some, are saying, nope, you need to show up. That is our policy because we have that legal authority to do so. I just don't think that's fair. And frankly, I don't think that's consistent with the spirit of 91A, which is a transparency statute. It's not a secrecy statute. It's not a burden statute. It is a transparency statute. And so that's what I think the second part of this bill really does. Frankly, I think in a very reasonable way, because of course there are going to be concerns about burden from cities and towns. But this bill, I think in many ways, accommodates that. They're not required to provide records electronically in a format other than the format in which the body regularly maintains that information. The bill adds that the public body or agency shall not be required to provide records electronically. It lacks the technological capability to do so. So there, what that language is dealing with is the capability of the public body to produce it. And if it's burdensome for them to do so, they're not required to do it. So if there are burdens with respect to the dissemination, they're covered under this particular statute. So I think, and again, as well, if they're concerned about the burden on scope and the volume of production, again, HB 1002 allows for costs in certain circumstances to be produced in that particular case. So I think this law really addresses many of these concerns with respect to, again, further burdens on municipalities. They're already going to have the documents printed out, right, in many instances. So we're just talking about how the documents get to the person. And if the person wants it by mail, they're the person who's making that request gets to pay or has to pay for the mailing as well. So again, I think this is totally fair and totally reasonable, and I think addresses a concern that we've seen with respect to some municipalities. So with that, I'll kind of close my testimony, but I want to thank the chairman and members of the committee for considering this legislation.
All right, thank you. Questions for this witness? Seeing none, thank you very much.
Thank you, Mr. Chairman.
Next, I'm going to call on Barrett Christina.
Thank you, Chairman Lynn. Thank you, members of the committee. My name is Barrett Christina. I am the Executive Director of the New Hampshire School Boards Association. We are opposed to House Bill 66, and just so it's on the record, I won't be testifying on the next bill, but we do support House Bill 74. I did sign in support, but I'll save the committee time by rediscussing the same issue. I think Mr. Johnson, who spoke before me previously, touched on all the salient points that the School Boards Association has and the concerns that NHSBA has with opening up the right to know law to any person, potentially nationwide. When NHSBA speaks to our members and we hear about out-of-state individuals requesting information from local school districts, most of the time, or many of the times, it's an out-of-state requester. It's a commercial enterprise that is looking for information about students and parents to market particular items. I've gotten questions from school boards or superintendents primarily in the past about out-of-state driver education programs, out-of-state companies looking to sell software platforms and programs to parents and students, private tutoring companies that are looking to sell their services to students, and all private entities that are assisting with college recruiting. They're seeking names, addresses, phone numbers, email addresses of parents and students to actively market information, and are not necessarily asking for information about government proceedings. So that is why NHSBA would have concerns with opening this up to any person, as opposed to putting some level of restriction to an individual who has a nexus, if you will, with New Hampshire, whether or not that's taxpayer status, whether or not that's a resident of New Hampshire, whatever language might come out of this. The other concern that NHSBA has that Mr. Bissonnette talked about as well too is the emailing of the records. The emailing of the records and providing them in electronic format in and of itself is not problematic when it's a person in your community or a person in your state seeking actual government records rather than information that is maintained or held by the government, such as names and addresses and email addresses and phone numbers and things of that nature. But as I believe Mr. Johnson said, when we would get when NHSBA would receive a phone call or an inquiry from a superintendent saying, I got a right to know law request from a company in California asking for these things, our response would be the same. Happy to provide them to you. They're at the central office. Office is open until 4:30. Come pick them up. And we often would never hear from that corporate entity again that's looking for these materials to market their wares to New Hampshire citizens. Likewise, I'm not familiar with all the facts of the Rochester matter, but perhaps a little bit of common sense could have prevailed, and the documents could have been provided rather than having to go through bill after bill after bill and many hours in this room. So the emailing themselves again is not the problem. The problem is when we're coupling that with out-of-state entities who have no connection, no nexus to New Hampshire, don't pay taxes here, don't have any connection to the state, but are seeking not even governmental information, but rather personal information that is being held by the government and in databases and student addresses and things of that nature. So for those reasons, the School Boards Association opposes House Bill 66. We do support House Bill 74, and I'm happy to answer any questions that the committee may have.
Thank you. Questions for this witness, Representative Alexander?
Thank you, Mr. Chair. Thank you, Mr. Christina, for being here. I struggle to see, honestly, the difference, really what it would do to further define it as a citizen of New Hampshire, a taxpayer, because hypothetically, you could just, find somebody in New Hampshire to request the documents. So I don't understand why you'd be opposed to this version in support of the other version when they practically do the same thing.
Sure. Thank you for the question, Representative. So, I will tell you just anecdotally from my own experiences answering these questions from school boards and school superintendents over the years. If that driver's education company or that private tutoring company in California really wanted that information, they would do that. They would contact somebody from New Hampshire and say, contact the Concord School District and request this information for us. I have not seen that happen. When the advice that I've told the superintendent has been to tell the company, we'll print them off for you, 25 cents a page, they're at the central office, we usually get no further response from that out-of-state private company. If they really wanted the information and was that important to them, I think they would do exactly what you're asking, Representative. But in my experience, they have not done that. Thank you.
Other questions for this witness? Representative Smith.
Thank you. It's a minor question. Is there a particular tax that you believe someone has to be paying in order to be eligible?
Thank you for the question, Representative. Representative Petronell, I was thinking of your comments about you have people who don't reside in New Hampshire but may own a home in New Hampshire. If you were to just say a taxpayer, that might be a little bit too broad, because my thought, using Representative Petronell's circumstance, you may have somebody from Anchorage, Alaska, who is vacationing in Wolfboro and rents a hotel and goes to a bar and buys a burger and a beer. They're paying a room and meals tax somewhere along the way, aren't they? Is that a sufficient enough nexus to New Hampshire for us to open them up to, make them, allow them access under their right to know law? I don't have a specific question to that to answer to your question, Representative, but maybe taxpayer would not be the proper language to use in whatever comes out of these bills.
Other questions for this witness? Seeing none, thank you very much.
Thank you.
Sir. Next, I'm going to call on Catherine Coco, please. Coco, welcome.
Good morning. Thank you, Mr. Chair. Good morning, Judiciary Committee members. I'm going to apologize in advance. This will be my longest testimony of the day, and I promise after this, it's all going to be very, very short. I represent Right to Know New Hampshire, which is an all-volunteer grassroots group of individuals concerned with transparency and effective implementation of 91A in keeping with the spirit of public access to public information. We've been involved in the formation of Right to Know related legislation since approximately 2012, and we have a broad base of members and interested participants with real-world experience in nuanced applications of the Right to Know law. We strongly support HB 66, which clarifies the standard for allowing individuals to request information under New Hampshire's Right to Know law and introduces routine 21st century business practices, notably the use of electronic communications, imagine that, in the implementation of RSA 91A. We very much appreciate the sponsors of this bill bringing this back to the table. This is an issue that was discussed at length and last year, and I'll go into a little bit of the history on that later in my testimony. The need for this language to now be added and clarified in statute appears to stem largely from applications of the law being put forward by a particular municipality and also the New Hampshire Municipal Association. Regarding replacement of the term citizen, I will assume most of the committee is now familiar with that ongoing case. There are multiple other reasons that a non-citizen may be reasonably considered to have an interest in that information. And I think Representative Petronell hit on that. Mr. Bissonnette hit on that as well. They may have children in a different school system from their community of residence. They may be a property owner. They may pay taxes in a jurisdiction but not reside there, etc. They may also have a vested interest in issues related to transit or health. What members of this committee may not be familiar with, and I'm going to get a little into the weeds on this, is the fact that under the Attorney General's 2015 memorandum on the Right to Know law, on page 39, the AG noted that RSA 91A4 refers to citizens, but the Right to Know law does not define this term and uses it nowhere else. Instead, the statute emphasizes accountability to the people, accessibility to the public, and the goals of a democratic society. An agency should not, therefore, require persons requesting access to public documents to demonstrate that they are citizens of either New Hampshire or the United States. That was the interpretation of the law as it is now currently written. That language in the reissued memorandum from the AG's office is notably absent, and it was issued just last year. However, historically, that is the interpretation that we have been using in the state of New Hampshire until we ran into this situation with Rochester's interpretation. Since the U.S. Supreme Court case of McBurney versus Young in 2013, some public bodies in New Hampshire have been applying findings also relevant to the State of Virginia Freedom of Information Act to bodies in New Hampshire. NHMA is one of those who recommended that approach, stating in their training materials that there is no definition of citizen or statute in relevant case law, but presumably should be a New Hampshire citizen. In part, we believe that is why some of these issues are now arising. Verbally during that training, counsel referenced McVerney versus Young. Right to Know believes this interpretation is being used in error, and the AG's footnote from 2015 confirms that. I won't go into some of the details about that particular case, but it is very specific to Virginia state law, which clearly defines who does and does not have access to information, and it cannot cleanly be extrapolated to New Hampshire statute, and I'm happy to discuss that offline with anybody that has questions about that. Despite this fact, McBurney and the idea that communities might deny records based on citizenship has worked its way into at least 2 right to know policies that I am aware of, and into the heavily used right to know training that's given by NHMA, and that needs to be corrected. This bill also allows for the use of electronic communications to be used to transfer records when the public body has the technological capacity to do so. There has been some discussion previously about the need for this language in the case that was previously presented to this committee last year. A right to know training that was put forward led to the conclusion by communities that they could not transfer information electronically and must require individuals to appear in order to request that information. That is not the case. They do have that option. We have also been surprised to hear concerns that anyone anywhere could request records from municipal governments via an emailed request. That is largely already the case. In addition to 91A not being limited to New Hampshire citizens, it does not require that a person submit a request in a certain format. An emailed request can constitute a formal request for information under 91A, and many, if not most, public bodies already accept those. We have also heard concerns about municipal governments being obliged to send records electronically. Most communities are doing that as well. When that is not possible, electronic transfer using a thumb drive or a data device is fairly routine. The real need for this language stems from public bodies who have chosen to adhere to very specific language in the statute and require that requesters show up in person and on time. It is usually, and you have heard it here in testimony prior to me, used as a deterrent and to decrease the volume of the requests received. That is not in keeping with the spirit of the right to know law, which is the only law that guarantees public access to public information. In many cases, the use of an electronic transfer is actually more efficient. It uses less labor than the production of hard copy documents, and the idea that they are more costly or troublesome to the public body is really a difficult argument to believe. There also seems to be a focus on knowing who the requesters are and having them physically come in to the office. The most recent legislative bulletin put out by NHMA states that any individual anywhere could make a request without ever setting foot in the state of New Hampshire, let alone in your town hall, as if that is expected and required. Right now, it is not. However, to extrapolate on that, in Sensabella, the New Hampshire Supreme Court stated that it would not be unreasonable for a requester to desire anonymity in the early stages when making a right to know law request. Such requests may implicate political, policy, or public interest considerations, particularly when the request is pursued by a whistleblower or an advocacy organization. We would recommend that the New Hampshire General Court respond in keeping with this finding whenever the question of identifying individual requesters and physically having them come in comes up. Finally, we have also heard concerns, and we heard them today, about Russia, AI bots that's been put out to the municipalities as a concern. As the Superior Court ruling in the City of Rochester case states, during the oral argument, the city identified practical concerns and difficulties that come from lengthy records requests from people outside the United States or the country. Whatever the merits of those concerns, the court could not, and it then went on to say it can't tailor the language. The legislature does need to do that. But I would extrapolate on that to say that when creating law, this committee should be dealing with realistic and carefully detailed examples rather than hypothetical scenarios that postulate unlikely outcomes when the right to know law is being discussed. This is what happened last year when a version of this bill came before this committee, passed the House, passed the Senate, went to committee of conference. It was sunk by claims of an unreasonably large right to know request that purportedly asked for all police records from an entire police department. In reality, that request turned out to be a specific request for internal affairs reports for a very set period of time. I do not want to see this committee misled by hyperbole again. If NHMA feels that AI bots are a concern, as I've seen in their legislative bulletin, or others are concerned about Russia, I would like to see examples of those attempts and a working group established to come up with a solution. The same is true of the aforementioned bad actors and costs, and I do want to take a moment to address the issue of large requests and costs. We spent quite a bit of time last year on HB 1002 trying to negotiate a solution that would allow municipalities to navigate difficult requests from requesters like the corporate ones that have been presented to this committee during prior testimony. Communities have the ability to say no to those requests in a variety of different ways. They are not required to compile information that is not already compiled. They are not required to release personally identifiable information, such as the school board was noting about names, addresses, and email addresses. There are ways to work around those large requests, and now there is a process in place for managing them and potentially charging. I want this committee to be very clear that that is something that we put into place to try and alleviate those concerns and those excuses. I will conclude my testimony.
All right.
Thank you.
Thank you. Questions for this witness? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on Sarah Cohen, please.
Good morning. My name is Sarah Burke Cohen. I represent the New Hampshire Municipal Association. As you may know, the New Hampshire Municipal Association is a member organization of all New Hampshire municipalities. NHMA opposes HB 66 for several reasons. First, this bill, as you've heard, will broaden the definition of a requester to any person anywhere in the world. No ties to New Hampshire. This seems to go counter to what is laid out in both Article 8 of the New Hampshire Constitution, stating that the government be responsive to the people who formed it, and statutory language in RSA 91A, referencing the right of every citizen to access governmental records. Although the New Hampshire Supreme Court has never ruled on the definition of citizen within RSA 91A, it can reasonably be interpreted to mean the statute gives rights only to residents of New Hampshire, which we believe appropriate. This interpretation seems to be supported by the New Hampshire Supreme Court repeated use of the statement that the purpose of the right to know law is to provide the utmost information to the public about what is going on, what its government is up to. Further, the right to know ombudsman has interpreted in his capacity that a requester under RSA 91A must have ties to New Hampshire to make a request under the statute. Taken together, the New Hampshire Constitution, right to know statute, New Hampshire Supreme Court case law, and the right to know ombudsman demonstrate that a requester under RSA 91A was meant to reference citizens of New Hampshire's, not residents of California, Florida, or a foreign country, as those persons who have no need to know what the government of Milford is up to. This interpretation allows municipalities to not waste their time and New Hampshire taxpayers' money fulfilling requests from business, political organizations, reporters, and college students who have no connection to New Hampshire, but want a municipality to do their academic, political, or industry research for them. Secondly, HB 66 will require municipalities to both accept record requests by mail or electronically and affirmatively send records by the means elected by the requester to include mail or electronically. Given the proposed expansion of the definition of requester, this bill will require that government agencies send records by mail or email, requester's prerogative, to any person anywhere in the world. This bill would, for example, require a municipality to locate, copy, and mail thousands of pages of meeting minutes or other government documents to a person outside the country, or require every town in the state to email a Colorado corporation information on registered dog owners so that the corporation could market pet products to them. Moreover, this bill creates significant privacy and safety concerns for New Hampshire citizens. It will allow out-of-state entities to have unfettered ability to demand and receive any type of public information they can think of from public agency. Although each piece of requested information may not alone constitute personally identifying information, a bad actor could acquire and put together enough pieces of public information on a resident, permits, blueprints, registration, addresses, tax payments, etc., to create a so-called targeting package on that person. And with the increasing use of the artificial intelligence and bots, these types of requests will only become more frequent and onerous and paid for by New Hampshire taxpayers. Electronic delivery will also mean there will be limited or no assurance that the record is received by the requester. With no assurance, it would be ripe for complaints to the ombudsman or lawsuits in Superior Court alleging that the government failed to deliver records within the statutorily specified time. When it turns out that the requester's email address was wrong, the requester's handwriting was ineligible, or some other factor outside of the government's control prevented the records from getting into the right hands, it will be too late as significant amounts of taxpayer money will have been spent. Electronic delivery of records also opens governments to security risks by accidentally providing metadata in a common file format, and fulfilling these requests can often take additional hours or even days to complete, which means that the cost of sending responses to out-of-state or out-of-country requesters will be borne by the New Hampshire taxpayer through expending the resources it takes to fulfill the request and the diversion of resources from other possibly more urgent tasks with no recoupable costs. In sum, HB 66 will create an immense burden on municipalities and the state. In which online profiles and email addresses from entities that have no ties with New Hampshire can be used to mislead or misrepresent who is requesting records from municipalities. Municipalities will be required to provide the requesting information electronically, which may create security risks to both the municipality and potentially citizens of New Hampshire. NHMA supports RSA 91A as it is currently written, and that the citizens of New Hampshire who appear in person at town halls, attorneys licensed in the state, well-known advocacy organizations, and news organizations who report on New Hampshire, and others who allegedly act on behalf of the people of the state of New Hampshire are reasonably entitled to information from its municipalities. NHMA urges the committee to reject this bill. I'm open to questions.
Questions for this witness? Representative Smith.
Thank you, Mr. Chair. Mr. Chair, before I ask Ms. Cohn a question, could I ask you if the ombudsman is on the list of people to testify? Because since a stated position of his was mentioned, and it doesn't really jive with what I understand has happened, I just want to know if we're going to be able to address that.
He is not on the list of witnesses.
If it is-
I noticed that he's here, and if he wanted to be, he could be, but
I wonder if at the appropriate time we could hear from him to just make sure. I'm not sure if this is a reference that maybe I'm of the wrong generation, but I don't know if, Ms. Cohn, if you have ever read about Henny Penny and the Sky is Falling, because it certainly seems to me to be a basis of all of your testimony. I know your predecessor was involved over many years of really working hard to have 91A do what we all hoped it would do. And yet now I guess I'm not quite speechless about all the things that you alluded to, alluding to something about the ombudsman, and alluded to all these people who are out there to get us or to get the municipal association. And I wonder if you could give us just the facts, ma'am. Could you give me a list of where people from other countries, always countries with political philosophies that differ from ours, have asked local communities to give them information? Could you give me a list of all of the businesses that have made life difficult for municipal associations? Could you, in fact, document all of the claims that you have made so that you could assure Henny Penny that indeed the sky is falling?
I can certainly look into that, Representative Smith.
I
you
would
like-
appreciate that, because I would imagine you, I don't know what your professional training is, but whatever it is, I assume your own personal standards are such that you would not want to say things that you could not factually document.
I can certainly contact the municipalities and have them, put together a list for me.
I would be ever so grateful. Thank you.
Other questions for this witness? Yes, Representative Manos.
Thank you, Mr. Chair, and thank you, Ms. Cohen, for taking my question. I wanted to know whether you're familiar with the order that was entered in the Superior Court in the City of Rochester case.
I am familiar that there is an order entered, yes.
And does the association disagree with the order and how 91A was interpreted in this particular case?
I would need to reread the order right now, but my understanding is that there needs to be ties. My understanding is that there needs to be some ties to New Hampshire for that the records were that the records were released to the person requesting them from Maine as he was reporting on New Hampshire news.
Would you formally let us know what the association's position is on the order?
I can.
Thank you.
Other questions for this witness? Yes, Representative Andrews.
Thank you, Mr. Chair, and thank you for taking my question. For years, I have been receiving electronic information from my school district, from the town, from a lot of places, and I have never had any that I didn't receive. Can you give us a list of specific cases where electronic was sent out and never received by the person that requested it?
I can look into that.
Other questions for this witness? Yes, Representative Federer.
Thank you. If you have written testimony, I would appreciate. Thank you.
Other questions? Seeing none, thank you very much, ma'am. And before I call on the next witness, can I just ask, if you have written testimony, we certainly want to receive it. Please do not hesitate to give it to us. But I think it is generally not helpful for someone to come up and just read their written testimony. So if you have, please give us your written testimony, and we're happy to hear you testify orally, but it's not particularly helpful to us if you just sit there and read, your written testimony, because we can do that just as well as you can, right? With that, I'm going to call Lori Ortolano, please.
On? There it is.
There you go. Thank you.
Okay. Good morning. I have no written testimony. So, and I want to thank the sponsors of this bill. I'm representing Right to Know New Hampshire and myself to some extent. I'm very appreciative that this bill was brought forward. I listened carefully to the last presentation, and I don't think that the situation is the problem that was presented, the way it was presented. Nashua receives lots of rights to know requests. Last year, they had about 350. A certain number of those, maybe a dozen, were from outside the state organizations seeking records. The city has always complied and given information to those requests. I can tell you that I have gone just after the ombudsman meeting last week that I came up and testified on. I submitted some requests to other states to get their ombudsman and right to know policies and procedures that they have in their states and their reporting requirements. Essentially, I made a records request as a New Hampshire citizen to other states. And I think that's very reasonable. I also get requests myself and information all the time from FOIA groups that are seeking information from our state. And I notice FOIA requests that come into Nashua seeking records on how New Hampshire handles certain right to know issues, to look at it from the perspective of the country responding to information requests. And I think that's all very reasonable. So the concept of a person in having to be a citizen of New Hampshire, I think we're blowing that up too much. And that I had written down the Henny Penny Sky is Falling story too, because that is exactly what I felt I heard. And I think a lot of times you get this presentation that it's going to be a disaster, it's going to open Pandora's box, and it doesn't. And to give you an example of that, in Nashua, when I was trying to get records off a backup tape, the city said, oh, this is going to be a disaster. Everyone's going to flood us. That was in 2021. They have never had a request for records off a backup tape again. It was one isolated incident of records that were moved to backup in just a month, 30 days, which was very quickly. And the judge said, you can have those. It never happened. It didn't open Pandora's box. It didn't create the problem. So as far as, I really think that I like the way the definition of a person is in here. I don't think you're going to create this huge problem for municipalities. Nashua has not complained at all about requests coming in from other states or countries, and they do come. They complain about their citizens doing them. That's their focus, not other people. So I think that's not as big an issue. Electronic media and taking records in electronic format, big supporter of that. Nashua really only does electronic format and has only for 5 years. This is the world we live in. It's far more efficient and effective. I don't think you're going to have all these technology problems that they're looking at. You're going to encounter some, but you are able to move the records without compiling, much less inexpensively. And the whole purpose is getting information out as quickly as you can to the requester. And this is a way of doing it. And, I can't imagine these municipalities that are demanding you come in face to face, take their copies that they're copying, pay a fee, that's even necessary anymore. I mean, so much is in electronic format. And I ask you to consider RSA 33A for municipal record retention. We certainly permit our paper files stored that need to be stored for years or forever to be put on electronic media. That's part of the law. Paper doesn't last for ever. The agencies are allowed to create electronic media for all of those records, and they do. And the only requirement is that they have to update it periodically. You can't leave information on a floppy drive for 30 years and then go to retrieve it and no one has the drive anymore. So you do have to move it to the proper storage format. But they do that to consolidate, to minimize vault space, and to get a handle on the records. It's available. It's the world we live in today. And I think that is just perfect, and I really appreciate this bill. Thank you very much.
Questions for this witness? Seeing none, thank you very much. Next, I'm going to call on Representative Jess Edwards.
I think they put the big one for me. That way I can stand up without the seat sticking to me. But I'm Representative Jess Edwards, representing Rockingham District 31. That's Auburn, Chester, Candia, and Deerfield. I'm not speaking in my role as a state rep right now. I'm speaking as an experienced risk assessment, risk manager, both in the IT area and also in physical defense with the experience in places like Afghanistan. And I just want to speak on defense of the Henny Penny comments. Professional risk managers are obligated to follow solid risk assessment practices. And that basically means that you're supposed to be able to take a look at any kind of a risk that may occur that will damage the integrity of your operation or your system, and do two things. You perform a probability assessment, how probable is something to happen, and what would be the impact. And if you take those two factors, you can figure if it's highly probable with a huge impact, you definitely want to put it into your risk mitigation strategies. And if it's not at all probable or it's not going to have an impact, then you can ignore it with some comfort. But it seems as though we're trying to anticipate a serious risk assessment on what might happen if this law gets opened up. And I don't think you should forestall a serious professional conversation on that. Things that maybe that have occurred, that there were people who said, oh, that'll never happen. Only Henny Penny would come up with that. The Titanic hit an iceberg. People should have been thinking, might we hit an iceberg in the winter in the North Sea? COVID came up. We hadn't had a pandemic in 100 years. It might have been a good idea to have a risk management strategy that was better to deal with the pandemic. 9/11 occurred. That had never happened before. We probably should have had a good plan, or at least some sort of a risk mitigation to try to prevent that sort of thing from happening. The South California fires, that had never happened in 100 years. It probably would have been a good thing to have a risk management strategy to anticipate something like that. Just dismissing and demeaning the possible reality is not a professional way of going, in my view. And so when these folks come up, like the Municipal Association, and share with us as a legislator from their experience the kinds of things that they've been seeing and what their professional instincts are, I think we should be listening to them instead of demanding they produce data that no other witness is being asked to produce. So I'm perhaps reacting a little bit, but I'm kind of offended the way Ms. Cohen was treated and how she was dismissed out of hand when she was sharing with the legislature some serious concerns. In the IT world, we're constantly worried about things like denial of service attacks on our IT infrastructure. What is being described by the Municipal Association is a type of a denial of service attack where if we open up the number of opportunities for somebody to present a right to know request, we should anticipate the possibility of a large number of attacks happening to overwhelm our systems as a political denial of service attack. So I like the idea earlier of somebody saying that there should be a working group put together so that these kinds of things can be discussed and agreed to. Oh, and one other thing. It's been said a couple of times that we can just use email or something to email a PDF. I don't know how many of you have ever applied for a mortgage, but if you or apply for a mortgage, there's a very formal process, an IT system set up so that any electronic document, they send you tons of them. Every electronic document that they send you comes with a DocuSign. So you have proof that the transfer took place. To say, oh, we can just email that, you still have to then have the obligation to maintain a record that you've provided that document. And currently, if you're just using email, that system to assure that you've met your obligation to provide the electronic document then is done in parallel and is fraught with mistakes and errors. So I think if we were to go to a wholesale cross the state effort to do electronic transfer of all these documents, we probably need to look at a serious investment in something like a DocuSign system so that there's a valid legal record that we've met our obligation to transfer the documents. That's really what I wanted to say relative to HB 66.
All right. Thank you, Representative. Questions for this witness? Yes, Representative Birch.
Thank you, Mr. Chair. Thank you, Representative. I was intrigued about your wish that we do predictive thinking as well in addition to simply talking about what's been in the past. So I want to ask you whether, in terms of the new usages of algorithms, the new usages of AI,
Right.
We've heard references to commercial aggregation of data.
Yep.
Do you think those concerns with respect to right to know should just be dismissed?
No, I think we really need to take a serious look at, well, thank you for the question, but I think we should take a serious look at the rapidly changing landscape. Just yesterday, a $500 billion deal was announced in order to massively develop AI capabilities. Now, this is not a press release we would have heard 2 years ago. So things are changing very rapidly in the AI world. There would be nothing to preclude under saying that any person anywhere located in any place, when any person could actually get immediately interpreted to be a corporation, which, you know, legally corporations are people, for an entity anywhere in the world to be set up to use AI to generate commercial requests on a massive scale. And given what we've seen, I think, in the last few years about using lawfare to slow down our legitimate political processes, I think we could anticipate an entity considering a massive denial of service attacks using AI-supported engines in order to bog down government so much it can't operate, and then we start to fall into violation of our legal obligations to transfer the documents. So now is going back to the idea of probability and impact, is that highly probable? Well, not today. Should we be thinking 3 years from now, 10 years from now? How far into the future do you want to look? I think depending on your time horizon, it's a legitimate threat. And what's the impact of that? I think the impact would be pretty serious because the legislature couldn't respond to provide the legal relief quickly, and then we'd end up in court a lot. So I don't know if I answered your questions or I went too far, but depending on the time horizon you give the threat becomes more likely.
Other questions for this witness? Seeing none, thank you very much, Representative Edwards. Representative Lauren Selig, please.
Thank you, Mr. Chair, and thank you, members of the committee. I just wanted to read an email I received from our town clerk who expressed grave concern about this bill based on the impact. And before I get into that, I should just say earlier this year, around the time of the election in Durham, our town clerk's office was subject, I believe it was to almost 1,000 I've lost track, but it was some obscene number of right to know requests demanding records that were not actually legally entitled to the person who was requesting them. But it was taking, as you can imagine, hours of time for legal processes to occur.
Yes, certainly.
If I could just interrupt, Representative, would you make clear that we in fact knew where those were coming from, and they were all coming from the same person who was a resident of New Hampshire, of Durham?
The right to know requests that were coming were in fact not from someone who was a resident of our community. As far as I know, they were coming from or at least their attorney who was submitting them was not a member of the community and was
On behalf of a member.
on behalf of someone who was claiming to be a member of our community. That's
Right.
correct. It's not. Yes. So, but it was taking hours and hours and preventing them from being able to do legitimate business during that time. So, sorry, let me
where was I? Okay. So if passed, HB 66 would create significant issues for the town of Durham, particularly the Durham Town Clerk's office. The clerk's office is minimally staffed with 2.5 employees, a town clerk for 40 plus hours, a deputy at 35, and an assistant at 20 to 25. We are currently responsible for multiple duties, serving dual roles as clerks and collectors. Our duties of property tax collection, water sewer collection, and all clerk responsibilities like motor vehicle registration, licensing, and elections. The current roles are already more complex and difficult with new laws passed in 2024. If this law passes in 2025, staff could be faced with requests for large volumes of information, putting a strain on an already busy and minimally staffed office with no recourse except to charge for photocopying costs and postage. After a grueling season of right-to-know requests in November 2024, and a series of trying First Amendment audits in December 2024, the Durham Town Clerk Tax Collector's Office and the New Hampshire City and Town Clerks Association believe these bills will continue a concerning trend that targets municipalities and local government officials. And further, by changing this from citizen to person, and also mandating that bills be sent electronically or by mail rather than being made available, allows for electronic requests with the requester choosing the method of delivery. The organization opposes the bill because the use of person could lead to a flood of requests from non-residents, including administrative burdens and costs for municipalities. And it could aid in fraudulent activities and identity theft, including but not limited to AI bots posing as individuals for the purposes of harvesting personal information from municipal records. So for all of those reasons, I agree with our town clerk. I don't support this bill. I think that there are way too many challenges with it, and it needs to stay more limited.
All right. Thank you. Questions for this witness? Yes, Representative Paterno.
Can you submit that letter as written testimony for the committee, please?
So I do know that the town clerk has also sent it to Representative Smith, so that if I forget to do that between the two of us, we should hopefully remember. But Representative Smith most assuredly has a copy, as does Representative Horgan, not still on this committee? Oh, and Representative Horgan received it as well.
Well, can you please send it so it's
I will
part of the permanent record? Thank you.
do my best to make sure we get that to you. Yes.
All right. Thank you.
Thank you.
I'm sorry. Other questions? No. Thank you.
Thank you.
All right. I don't have any other pink cards. I'm wondering if I could ask the ombudsman to come up for just a moment, please. I think Representative Smith may have a question.
Good morning, Tom Kerr, Right to Know Ombudsman. Thank you for calling me up, I guess.
Recognize
Thank you, and you know my question before I have to
Could
ask
you
it.
repeat it again, Representative Smith?
Well, one of our earlier testifiers from the Municipal Association quoted you as to, I believe, the use of the word citizen, and I wonder if the quote accurately represented your views.
I believe we're talking about a case 2023, RKO 2023 if I recall, 018. It was a case in which...
Can I just interrupt? I assume the case you're going to tell us about is now over.
It's over in my office at this point. I know the case was taken to the Superior Court. I have no idea what happens after a case comes out of my office. I only find out if cases are appealed by people telling me they've been appealed.
Okay.
I'm not going to go into details of the case other than to say that my opinion in that matter that was appealed to the Superior Court and affirmed by the Superior Court is available through my website, which gives a link to the New Hampshire Supreme Court Law Library, which has a lot of my decisions there, or I could provide you with a copy of 2023-018 if you would like.
If you could just tell me, do you agree with what was said as to what your position was?
The opinion was specific to the facts of that case. In that case, one of the main things that I did was I deferred to the court and the legislature in regard to some of the definitions. And in that case, on the facts of that particular case, I found for the claimant.
Thank you very much, and it was very kind of you to agree to.
All right.
And Representative Lynn, I don't think that anything has gone any further in that case, but I don't know.
That's fine. Thank you very much. As I said, I have no other cards. Oh, God. Yeah, sure. All right. So I'm going to close the hearing on, oh, wait a minute. Yeah, all right. Mr. Yukela. Former Representative Josh Yukela.
Hello, thank you for taking my testimony. One of is going to be very, very short. One of the things that I didn't hear mentioned about the issues with citizen and clarify, making it required to be a citizen or a taxpayer or something like that, is that a municipality could require proof of citizenship or taxpayer status or some other residence or tie to New Hampshire or some other thing before they consider it a valid request under 91A. And so we could get tied up in, is this a expired license, or how long ago was this lease, or whatever the case is that someone needs to prove that they have some tie to New Hampshire. And so using the language of person means that you don't need to prove that you are a real person and not a computer program or something like that to the municipality before they accept your request and start that deadline, right? They have a deadline to meet those requests. And if they, go back and forth with you saying that you should prove that you are, have this tie to New Hampshire, I think that this bill would eliminate that potential hurdle. So something to consider. Thank you.
Questions for this witness? Seeing none, thank you.
Absolutely.
I have no other cards on this bill, and so I'm going to close the hearing on HB 66. All right, so I'm, as is obvious, we're running quite a bit over. I guess what I would say is, as we get close to the lunch hour, if people, we don't have to have a quorum for hearings, so if people want to take a break to have lunch, we'll make sure. I mean, I'm going to be here until people, at least until people return. And I think we should have, at least a few representatives here at all times. But if people want to take a break for lunch, that's fine. I'm now going to open the hearing on the next bill, which is HB 74, and I would recognize Representative Edwards to appear as the prime sponsor of that bill.
Thank you, Mr. Chair. And as I stated earlier, I'm Representative Jess Edwards, representing Rockingham District 31. That includes Auburn, Candia, Deerfield, and Chester. House Bill 74 was intended over the summer months to be a method to which we, between the sponsor of the prior bill and this bill, to provide this policy committee with a couple of different ways to handle the Rochester case. This bill attempts to address the issue of citizenship that was brought up in the case and resolve it, I think, in a much more narrow way. And I think before we get into it, I don't know the history on right to know. Apparently, it goes back to 2012 and earlier. It sounded as though the purpose of the right to know law is to provide our citizens, our voters, an opportunity for them to have the transparency into what we do so that they can get involved. we are a very decentralized government in New Hampshire. That would be consistent with the idea that we want to be able to decentralize all the way to the individual in our state so that they're able to get involved and get engaged in the school boards, the select boards, all of those things. So if that's the intent or the purpose of Right to Know, the question then gets to be, is it also the purpose of Right to Know to provide support for potentially international commercial enterprises trying to scrape data together in order to figure out how to market or sell it? And I think that fundamental determination of what the purpose of this law is kind of fundamental to which way you may want to go. But let's touch stone here on where we're at today. Where we're at today is, if you look at the definition of governmental proceedings in current law, it means the transaction of any functions affecting any or all citizens of the state by a public body. So in that language, it implies to me that the original purpose was to support the citizens of the state and not a broader category of all persons living anywhere in the world or corporations that may represent them. So I think if we want to stay more narrow, what you see is in lines 6 and 7 of HB 74 is citizen gets defined as meaning any person having a legal status in and relation to New Hampshire by virtue of domicile. Now, why was the word domicile chosen? Well, domicile ties one of the definitions in our statutes that I think I understand is critical to all of our voting laws. Domicile is fundamental. So that word was chosen to build on and to leverage the idea that we want an informed public. Also, the or statement connects it, or any press acting on informing the citizens. Well, a well-informed citizen is important. So having press act to inform the public is also important. Now, I didn't define press. I could have, but I didn't, because personally I would define it as any entity that is trying to take information and make it available to the public. So that could be a 12-year-old writing a book report that gets published in the local newspaper. That kid would be press, in my view of that definition. But I didn't go that far. So what HB 74 does, it offers the committee sort of a way to just make a bare incremental change to the law, a small incremental change, so that the issue found by the Rochester court can be resolved without opening it up to everything, everywhere, at any time in the world. So I commend line 6 and 7 as an alternative. Now, HB 66 shares with this one the idea of taking the words preliminary draft circulated to a quorum or a majority of the public body. That does not change the law. That is perfectly consistent with the law. What it does is it takes from the deep bowels of the bill that obligation to share those kinds of documents, cleans up the language to make it an affirmative instead of a negative, and brings it up and elevates it higher in the bill so it's just easier for the public to interpret. I think it's kind of interesting that this is a transparency bill, and what this language does is it just makes it transparent what the purpose is. Now, why did I think that needed to be done? Last term, I had a reporter come to me, I think a credible reporter, and she reported to me that in her experience, some of the more bureaucratic public bodies used this technique where they would hide the ball. They would keep something in a draft status, even though it was known to have gone out to the people of the public body, and just say, no, it's a draft. We don't publish drafts. And then talking to the ombudsman about that situation 3 years ago at this point, it was clear to the ombudsman that a draft after X days, I think it was 10 or something like that, becomes accessible, and that the entity that was hiding the ball, if a formal complaint had been filed, would have been told to share the documents. But that sort of process slows the whole thing down. So if you have a public body that doesn't want to be transparent, a technique that seems to be possible is to play dumb and say it's a draft when a technical analysis of the situation would indicate that it's a draft whose time has come and should be made available upon request. So this was meant to just bring it up higher so that it would be tougher to deny the obligations of all public boards. And I said things in my previous testimony that I would carry forward in here. You know, email management's a huge challenge. You know, that's why mortgage companies go to a much tougher system. Those cost money. Maintaining email management records in parallel from email and stuff is in fact additional workload and creates additional risk for the entity. So the testimony that said there's no more work involved in just emailing and it's simple, that's not true. That's not the full story. That's it. That's my testimony. I didn't think it was going to be this complicated, Mr. Chairman. I just thought this was going to lay it out. Pick A or pick B like a Chinese menu, but man, I learned a lot today. So
No, I think we both did. I mean, I think, you know, I think we both had a sense that that we understood the issues, and we both kind of, I mean, we're both supporters of both bills. So I very much appreciate it.
And to add, I'd add that we're both big supporters of public transparency, that we want an informed public engaged in their government.
Oh, for sure. Questions for this witness, Representative Horgan?
Yes, I remember from my work on other topics that there is a definition somewhere in the RSAs, and I apologize for not remembering exactly where it is, but which says a citizen of New Hampshire is a citizen of the United States. And of course, I guess we're having a nationwide debate about definition of citizen, but that's, you introduced the bill before that happened. But anyway, it's a citizen of the United States who's a resident of New Hampshire. So why do we need a separate definition in this bill? I may understand you may want to include other people who aren't citizens of New Hampshire, but like, why redefine the word citizen when it's already clearly defined who's a citizen of New Hampshire?
Is there a question there? Do you want me to?
Like, well, why? Yes. Why is it necessary, given that citizen of New Hampshire is already clearly defined?
So I'm not a lawyer. It sounds to me like you have a good point. The point I'm advocating for is to go back to first principles. What's the purpose of this bill? The purpose, or this law? The purpose of this law, to me, seems to be we want a well-informed public that can be engaged in their community, and so. If this isn't if redefining citizen in this context isn't the right way to do it, it still may be worth it to come up with a word that we carve it out so that all of the effort our hardworking civil servants put into feeding this bill are really going to the ultimate purpose, which is a better informed, more engaged New Hampshire population.
Okay, fair enough. I apologize. I was probably doing something I criticized a lot, which is like asking a question to make a point, which can always be raised at a work session or executive session, both of which we'll probably have shortly.
Right. Other questions for this witness? Thank you very much, Representative Edwards.
Thank you, Mr. Chair. Thank you to the committee.
So what I want to say is, given the, obviously we're going way over. I have not a tremendous number, but some other witnesses who I think have appeared previously to testify in HB 66, and I would appreciate it if, as you come up to testify, if you'd confine your remarks specifically to HB 74, and also I'm going to impose a 3-minute time limit. So next I will call up Catherine Coco, please.
Red means go. Good morning again. I'm going to keep my comments very brief this time. You understand our position. We oppose HB 74. I did want to touch on 3 points that I think the committee may not be aware of. The first is that with HB 1002 last year, I'd just like to clarify that the purpose of addressing that was the most costly and most time-consuming requests, which are electronic communications, are now restricted to 250 of those before a community can start charging for those. So just to be clear, when we're talking about excessively large requests from what Representative Edwards referenced as international commercial enterprises, they would have to be beyond that size in order to, they would have to be that size or bigger in order to be able to charge from, but that is the thresholds that we set for large requests. The second is that Representative Edwards was talking about the history of right to know and the idea that it is set up to be available to citizens. I'd just like to quote Article 8 of the Constitution, which says, "To that end, the public's right of access to governmental proceedings and records shall not be unreasonably restricted. The public also has a right to an orderly, lawful, and accountable government." It does not reference the word citizen. It does later use the word taxpayer, which, as suggested earlier, can be pretty much anybody that is paying a form of tax in the state of New Hampshire. So I wanted to clarify that as well. And finally, I do have a copy of the Superior Court ruling from the Rochester case in front of me. And while I can't speak for the ombudsman, I can say what the court had to say about it. At issue was the fact that the individual who was not a resident of the who was a resident of the state of Maine was being refused information, and what the ombudsman and the Superior Court both clarified was that that individual, though a resident of Maine, was representing an entity within the borders of New Hampshire. And so it says, and I'm quoting from the finding, the ombudsman found as a matter of fact to the contrary, identifying the Rochester voice and not Mr. Thorpe as the claimant. That was the issue that was settled. There was no determination that someone had to have a tie to the state of New Hampshire in order to be eligible for information. They simply made that distinction and moved forward with the idea that the claimant was already in New Hampshire, and that claim that they were not a citizen was not relevant. Thank you.
Great. Thank you very much. Questions for this witness? Seeing none, thank you. Gilles Bissonnette, Mr. Bissonnette,
Thank you, Mr. Chairman. Gilles Bissonnette with the ACLU of New Hampshire. I do just want to say, with respect to HB 74, we want to articulate our appreciation for the sponsors. Again, attempt to try to address the citizenship issue that has percolated because of one town's interpretation. I do think that HB 74 is too narrow, and our strong preference with respect to how this should be resolved is in the language of HB 66, which again doesn't expand 91A. I think just reflects the status quo that has been the case for decades, with the exception of this one town's interpretation. So I just want to reiterate that because I think that is incredibly important from my vantage point. But I do think HB 74, its attempt to resolve this is too narrow. This definition in HB 74 would potentially exclude, for example, people that have second homes in New Hampshire, may even pay property taxes here, but they wouldn't be domiciled here because you can only have one domicile. But of course, they would have a significant investment in New Hampshire as well, and I think should be able to make public records requests. I do think that this could be construed as potentially excluding them from making requests. And so I think at its core, I think what HB 74 could be doing in making this change. I'm not saying intentionally, but it would narrow 91A, and that's just not something that we can support here. I think in many ways we should be expanding our public records laws. So I just wanted to convey that feedback and appreciate the committee's time in trying to resolve this issue. Thank you.
Thank you. Questions for Mr. Bissonnette? Seeing none, thank you
Mr.
very
Chairman.
much. Next, I'm going to call on Sarah Cohen, please.
Hello, my name is Sarah Burke Cohen. I represent the New Hampshire Municipal Association. The New Hampshire Municipal Association supports HB 74. We believe it codifies what the New Hampshire Constitution, RSA 91A, and the New Hampshire Supreme Court have pointed to, that the transparency of government in New Hampshire is for those who have ties to it or are governed by it. We urge the committee to support this bill. I'm open to questions.
Questions for this witness? Thank you.
Thank you.
None? Is there anyone else who wishes to testify? Is there anyone else who wishes to testify on HB 74? Seeing none, I'm going to close the hearing on HB 74. I'm now going to open the hearing on HB 80. And I would recognize the prime sponsor, Representative Turcott. Representative Turcott, welcome.
Thank you very much. Good to be here. I think in my 5th term, this is the first time I've ever testified before Judiciary. I am Representative Turcott. I represent the towns of Barrington and Stratford, Stratford District 4. So before I get into the actual changes to the RSA I'm proposing, I'd like to go through just a little bit of the history of why I'm here and what I'm trying to do. In Stratford County, our delegation pre-COVID, as long as I've been there, no member vote had ever been taken by phone or video. During and post-COVID, that became an occasional issue, a continual issue, actually. I see we have a couple members of the Stratford delegation on here besides myself. Each time a vote has been taken since that time, I have raised objections to that vote for those who are not physically present, including one of my own votes, where I was out of the country and I voted, and then I said I object to my own vote because I don't believe that's what should have been done. Over these past few years, I've had several back and forths with our previous county attorney and the current county attorney. And unfortunately, their opinions did not, I don't believe, were correct. So I'm going to give you a real example of why I think this is important. About a year ago, during a December meeting, scheduled meeting, a member of our delegation, instead of coming to the delegation meeting, chose to go to his girlfriend's house rather than attend our delegation meeting. And when I made it my objection to allowing the voting by Zoom, which I always do, he said, well, if I would have known Rep. Turcott was going to object, I would have come there. This clearly indicated that his attendance could have been, quote unquote, reasonably practicable, as the current RSA says. He simply chose what was more convenient for him. So what I'm trying to do is to set a higher standard. There are a couple things in the bill what I'm trying to change. One is to set a higher standard needed for attendance and then voting only by those at the meeting. I think those who make the effort to actually be present have taken the responsibility for their office responsibly, whether they were appointed or elected. Conversely, those who choose to participate remotely when they could have been present, they shirk that responsibility. As I said before, prior to COVID, this wasn't even an issue. So we should not be permitting now the I'll say ridiculousness rather than insanity that it surrounded that period of time to upend decades of precedents and to be used that arbitrary precedents going forward. Here are some of the reasons why I believe these changes are needed. Anybody not in a meeting room cannot have a full sense or view of all that is going on. I can tell you specifically as a negotiator, I would never hold a negotiating committee session with any of my team members not being present. I would not even allow them to participate via Zoom because there's so much you can gather from watching the people in attendance at a meeting. Another thing, you can't take, and again, for me, a lot of this revolves around the Stratford County delegation or delegation, but if you're absent and you're on Zoom, you can't take part in any caucus, which may preclude an important vote. That was the case for myself on the one time I missed a vote and I had to, there was a caucus taken, I couldn't be part of that. Audio and video can be, and at least in Stratford County, is very poor compared to being in person. Well, we've experienced very poor two-way communications. The public has a lot of times difficulty hearing delegation members who are not physically in attendance. I know I've had trouble when people are absent figuring out what they're trying to do on Zoom also. As I was researching or getting further into this, I noticed that what we have done in Stratford County in delegation meetings is you have to somehow positively confirm the individual who is on Zoom. And it was interesting to me to learn that the actual member does not even have to be visually confirmed, only by voice. And I'm not sure that's the best thing we should be doing. The last thing I'll say is the determination of current reasonably available is made by the chair of the delegation. It can be extremely subjective and can also be, in some cases, politically motivated. Subjectiveness, where we can, has to be removed so we can provide consistency. So to the actual bill, two parts. The first one, I'm removing the words not reasonably practical and inserting the word unavoidable. And the reason for that is it creates, in my opinion, a higher standard or a higher hurdle for that person who chooses not to participate in person. Again, the example I gave you of the individual saying, oh, I could have been there is a great example. The second part of the RSA that I'm trying to change is to disallow the voting by anybody who is not physically present. I know that goes a little far for many people. In speaking with someone earlier, there might be a way to maybe amend it to add like another part of the RSA in cases of an emergency situation. So I'll conclude by saying that in-person participation is essential for fully transparent communication between the members of the body. Those elected or appointed to our public service positions must shoulder the responsibility of their positions 100% of the time, not only when it's convenient. New Hampshire should not be cheapening hundreds of years of the way we participate in public meetings by gradually excusing ourselves from actually being there. It's the old camel's head under the tent issue where you start chipping away a little bit by little. The camel throws his head under the tent. Before you know it, the whole body of the camel is in there. I say, what's next? Representatives stay home, rather than make their way to the State House chamber on session days. And don't forget, we actually had some of this being tried during COVID. And finally, I'll leave you with a couple semi-rhetorical questions. Would this committee here ever allow somebody in executive session to vote via Zoom? I think the answer on that is no. And one that our chairman or the chairman of this committee might appreciate. Would you ever allow jurors in a trial to listen and participate in that trial while not being physically in the courtroom and then vote on the defendant's fate? Again, that's a no. So with that, I'll be happy to take any questions that you might have.
All right. All right, questions, Representative Rombo, please.
Thank you, Mr. Chair. Thank you, Representative, for taking my question. I just wondered if we have a definition of unavoidable versus not reasonably practical. Perhaps there was not previously either, but who would make that determination? Would it still be the chair of the body?
Under current RSAs, yes, it would still be the chair.
Okay, thank you.
Representative Smith, you had a question.
So my question was the definition of unavoidable. I agree with you, as you well know, in principle, but I don't quite see how unavoidable answers the concern.
Sure. As I said, I think the word unavoidable is a higher hurdle than reasonably practicable. And I'll say this. I tried to find the best definitions of the words I could. The one I came up with that I think best describes unavoidable was impossible to prevent. I think that says it pretty clearly for me. Whereas when I looked up reasonable, I just couldn't find, for me, something that hit the definition of reasonably the best. The word that kept coming up was feasible. So what I'm trying to do, and the sponsors, co-sponsors are trying to do, is just to set a higher standard. Now, I've asked our attorney through multiple letters over the years, give me some, and even our chairman, give me some examples of what you would determine as reasonably versus, I've never asked about unavoidable because we haven't got there. But to give me some examples, where is your line? Where is that gray line that above is reasonable and below is not? And nobody wants to answer it. And I understand why, because then you set a precedent. That's why I want to make it unavoidable. Unavoidable is different than reasonably available, in my opinion.
All right. Other questions for this witness? Yes, Representative Birch.
Thank you for allowing me to ask this question. Thank you, Representative. I did miss the first few minutes of your presentation, so forgive me if you covered this. I'm concerned about the definition of public body, what this includes. I know the right to know law has its definitions and the like. I assume you're not covering any local municipal bodies?
As I said, most of this developed because of the Stratford County delegation. I am not changing the definition or intent of whatever that means. That's not what I looked into, the definition of public body. I'm looking into the ability to vote and what's deemed unavoidable.
Could I follow up?
Yes.
To follow up then, since I'm not sure what your definition is, it's certainly not in the legislation, let's talk about a small town zoning board. Am I correct in suggesting that I come from a small town and we have a reasonably hard time getting people to serve on local boards and the like. So you're suggesting that it's the proper role of Concord, to use the generic, to decide for our town what the attendance rules should be and not?
Under the RSAs, I am saying that anybody who accepts the responsibility or is elected to that, accepts a position, appointed a position, be elected to a position, that yes, indeed, you should take the responsibility to actually show up. And I think when we get down to it, when you're talking about local, I would say the more local you get, the easier for the individual to actually be there. I mean, we could let's take a delegation up in Coos County. A meeting for that, you could be coming from, I don't know, 100 miles, 80 miles? Your town of Concord, if that's where you're from, I guess? No? Okay. Well, Concord.
Westmoreland, it's a small town where we know how to handle our affairs more or less without Concord telling us how to run our boards.
And then that would be up to you, I guess. But under this change, it would require, if you want to be voting, you need to be physically present.
All right. Other questions for this witness? Representative Perez.
Thank you. Thanks for taking my question. It's my understanding that a member of the public body may participate. That's already in the law. You're not changing that at all, are you, Representative?
I am not, no.
Okay, so that is existing, and this bill does not change that at all.
That does not change the participation other than when you're changing the definition from unavoidable to reasonably practical. So no, it doesn't change the attendance. What it does change is in order to vote on an issue, you must be physically present.
Okay, thank you.
All right. Other questions? Representative Tripp and then Representative Ward.
I know that in the municipality of Derry, our town charter defines how people can participate in a meeting without being there. So I assume that this would change that or override that charter condition. It's this the same thing with our zoning board. People will call in and participate in the meeting and in fact actually vote on the case that's being discussed. So I think the change that you're suggesting is a little more far-reaching than you anticipate. Oh, I should have a question, right?
Isn't that true?
Isn't that so?
Well, it would depend. You talked about people calling, and it does not change the public's participation in anything. What it does is it specifies the individuals. I mean, your town may have rules on participation in meetings, but this doesn't change that. This is already in the RSAs. The only thing that we're talking about is participation being unavoidable versus not reasonably practical. That's all.
Representative Horgan.
Yes. Well, first of all, it's just full disclosure. I myself am a member of the Stratford County delegation, and in fact, a member of the executive committee. So, the member in question, we don't want to get too much into the example. We probably should choose a hypothetical.
How about limiting it to questions?
Yes.
Questions.
Why that we had people who either zoomed into meetings, and we had some cases of members who consistently missed meetings altogether. So why is it worse for someone to zoom into the meeting than to not be there altogether? As at least we had problems with some members of the delegation not showing up for anything. So why is it worse for someone to zoom in than to not be there? So I don't get it.
Sure. Thank you for your question. I covered that, I thought, pretty well in my testimony. What I'll be happy to do is give you a copy of my testimony, and the answer to your questions would be in there.
Right. Thanks.
Other questions for this witness? Yes, Representative Bertrand.
Thank you, Mr. Chair. My question, my wife works at home and she works for a large hospital in Boston. So her whole day is on Zoom, so are you just concerned about the security of the information in the non-Zoom preference? Or in the-
Not really. I'm more concerned with the, you're talking about private business. This here pertains to the public, and 91A. That's what this is about. And as I think I said in the testimony, I see a lot of problems with, and again, I'll give you a copy of this testimony so you can review it and see it. I'll send that to the chair or the committee. I got to declassify a couple things on here because I don't want certain names mentioned. That was in my notes. So, but yeah, I'll be happy to send that to you.
All right, other questions? Yes, Representative Alexander.
Real quick. Thank you, Mr. Chair. Thank you, Representative. I understand the bill is now in our hands, but let me ask, would you be opposed to an amendment that would remove everything after Section 2 of the bill and just update the bar that's needed to be absent from a public meeting or electronically?
I would be opposed to that. I think if you have issues with that second part, as I said, I spoke with somebody earlier, and in the RSAs, let me see if I can find it real quick. It's in the 91A2, I believe, 3B, and it talks about except in an emergency, a quorum of the public body, blah, blah, blah. I think maybe in that section 2 that I'm adamant that I believe we should not be allowing people to vote on Zoom because of the issues that I brought up before, that maybe that sentence could be changed to except in an emergency and then continue down. That I would not be opposed to.
All right, other question, Representative Perez.
Thank you. Thanks for taking my question. Would you be concerned with, was one of your concerns possibly who might be influencing a vote if a person was there by Zoom? Because there's no way to say that if I'm on a Zoom and it's an important vote, that someone's not holding a knife out a camera to me and telling me how to vote.
While I don't think that extreme example might happen, I don't discount what you're saying. And again, I mentioned in my research for this that current RSAs only require that the person be able to be identified basically by voice. There is no visual confirmation of the purpose. Is that a possibility? Absolutely. Yeah.
All right, other questions for this witness? Seeing none, thank you very much.
Hey, thank you, guys.
Thank you. All right, next, I'm going to call on Karen Rosenberg, and other than the sponsor, Representative Turcotte, I'm going to ask that people please limit their testimony to 3 minutes. Ms. Rosenberg? Oh, I'm sorry, I didn't. Representative Selig. Sure. And again, please limit your testimony to 3 minutes.
Absolutely. Thank you very much. For the record, I am Representative Lauren Selig, and I represent the town of Durham, which is in Stratford County. And I would bring up a few points. This is an issue that has been a countywide debate for a long time. And my experience is fundamentally that we've had a member of our coalition who's requested an attorney provide an answer. The attorney's provided an answer. That person hasn't liked the answer. So they've asked the attorney to provide a different answer, except the answer hasn't changed because it's still the answer. And so they continue to seek different ways of trying to get the answer they want. I object to this bill for a number of reasons. One, I'm someone who had to miss county meetings because at one point I had COVID. And rather than exposing the entire county delegation and members of the public to my very active COVID and my fever of 101, I chose to participate remotely to the best of my ability. And I was on camera per the RSA. I had to stipulate that I was home in my room by myself, that I had COVID, and that's why I was not participating. To be not allowed to vote because I was protecting the public from catching a very contagious illness, I thought was probably the more responsible choice, was to not, to be able to vote as best I could and participate. This is really a bill that I think despite the sponsor's intention, would in fact also impact all of the town boards and meetings. And at town boards and meetings, again, there are lots of different meetings that happen. People can't necessarily attend every one in person. They may have to travel for business. They may have personal reasons. It may be a childcare issue for them to not be able to be there in person. And as long as they're visible on Zoom and identifying, or on whatever method is being used, and you can identify who they are, there is no real justification for not allowing them to have an active role in participating in those duties. All of those votes happen by roll call, so that you know exactly, and the public knows exactly how that person voted. It's not different from them being in the room participating in a roll call vote. And it makes it actually more accountable than if it's in a room just by voice vote. So I would encourage you very strongly to vote to inexpedient to legislate on this bill.
Question, Representative Perna.
Thank you, Mr. Chair, and thank you for taking my question. So I just want to see if I'm summarizing your testimony correctly. So are you saying that even if the absence of the member is unavoidable, and you listed several instances where that would be unavoidable, that you should still be allowed to vote? I just want to clarify that that's...
I do believe that. And in fact, it's currently listed as not reasonably practical, and just in terms of the incident that the previous, that the sponsor mentioned, that was a person who had left the state to go participate in a family event over a holiday time when we ended up having a meeting. And rather than leaving a family event to get back for the vote, he was choosing to participate remotely. It was only because the meeting went on for 6 hours that he said, had he known it would be that long, he would have driven back to be there in time for the vote. But, you know, a 6-hour drive to be there for a vote might not be practical for most people, or avoidable.
Other questions for the Representative Perez?
Thank you. Thanks for taking my question. I see a Pandora's box. Do you believe that we as legislators should be able to participate and vote remotely?
I believe that for committee meetings where our vote is advisory and not definitive, that yes, we should be allowed to vote remotely if possible. It would certainly, given the fact that we get paid so little, for those of us who are working to do so many different things to be able to be successful here, or in the cases when I had COVID and couldn't be here in person, I would be open to that. However, that's not how the legislature has chosen to move forward with things. That's not how we do things here. So I respect and honor the tradition of voting in person. I believe on full House session days, we should be here.
Follow up?
Yes.
So are you saying during executive sessions, we should be able, you personally feel that we should be able to participate and vote remotely?
If there were a way to ensure that we had full video coverage so that both the public and all the members in the room could fully hear and see the person participating remotely, I would not object to it. I'm not saying I'm promoting it, but I would not object to that if that was something that we as a House voted to accept.
Thank you.
Any other questions for this witness? Thank you. Seeing none, thank you very much.
Thank you.
Now, Ms. Rosenberg, Karen Rosenberg, please.
Thank you. Good afternoon, Chairman Lynn, representatives, members of the committee. My name is Karen Rosenberg. I'm the policy director at the Disability Rights Center, New Hampshire's protection and advocacy system for people with disabilities. We oppose this bill because we think that it's potentially discriminatory against people who experience disability who may not be able to attend meetings of public bodies, but whom we want to encourage to be full participants in our communities. And I think, as Representative Edwards mentioned, one of the purposes of 91A, our right to know law, is to encourage civic engagement and public participation. And for people with disabilities, or people caring for people with disabilities, it may be difficult at times to be able to attend a meeting. Is it completely unavoidable? Well, some people might need specialized transportation to participate in person in a meeting. And maybe if they knew 6 months in advance that they were going to be scheduled to attend a meeting, they could arrange that specialized transportation, but perhaps they're not going to know that. And so it, theoretically might be unavoidable, but as a practical matter, it might not be unavoidable for someone with a disability to be able to get to a meeting. And then what this would do, if person was in a situation where they didn't reach this higher level of unavoidable in order to participate remotely, it would create like two categories of individuals who are members of public bodies, members who are able to attend meetings and members who, because of their disability, are not able to attend, and make them second-class members of bodies by not permitting them to do what public body members need to do: vote, have a voice. When people participate in public bodies, whether it's at the local or county level, or it's a statewide body that meets in Concord, it's to enable people to have a voice and make recommendations about really important issues like education of children with disabilities, or quality of services for people who have developmental disabilities and receive services. And so for those reasons, we think that this would be discriminatory. It would take a step backwards in terms of encouraging civic engagement and participation, particularly among people who experience disability or care for people who experience disability and may not be able to get away. And I'm happy to answer any questions. Oh, one thing I did want to mention, Representative Perez, there is a requirement in current law that if someone participates remotely, first of all, the body has to allow that to happen. So bodies can determine that they are not going to allow remote participation. From a disability rights perspective, of course, we would hope they would. But if someone does participate remotely, our current law requires that they identify anyone who's in the room with them. So I can understand it'll be awkward to say someone's holding a knife at me, but they would have to at least acknowledge that there's another person in the room with them.
Other questions? Yes, Representative Tripp.
Thank you. Do you happen to know which RSA that is in?
Yes. Which one? About the person announcing that the person who's in the room with you?
People being the group, the public body, being able to determine that someone can participate remotely.
Yes, it's in 91A Roman :2 Roman 3. That's where it says a public body may, but is not required to allow one or more persons to participate.
All right, Representative Paterno.
Thank you, Mr. Chair, and thank you for taking my question. If I recall correctly, we had a bill last year about the membership of a specific commission or committee, and the membership of that committee, and that was a significant concern with parental participation that was required. And we talked about whether or not people would be able, we talked about different options for participation for those members. I can't remember, did we agree
I
that
think
they
what
could
you're remembering is
Yeah,
that
thank
it
you.
was a couple years ago, actually. And I mean, there's all these numbers floating in my head. I think it was HB 308, but don't quote me on that. But it did involve the reduction of the in-person quorum requirement. Is that the one that you're referring to?
It was
No.
HB 147, and it was the.
Oh, that one. That
that
had to do with that.
SAC?
Yeah,
Yes,
but that didn't
okay.
really address remote participation so much. That addressed the membership of the SAC and who ought to be on it, and how to encourage participation by parents for whom it would be difficult. So certainly allowing remote participation does enable parents who may have childcare responsibilities and other responsibilities to attend, but it wasn't just spot on exactly what that was about, but it touched on it some.
Yeah, thank you. I remember that it wasn't about how they could participate, but I remember that being a discussion in the hearing. So thank you very much.
I think your memory's correct.
Other questions for this witness? Seeing none, thank you very much, Ms.
Thank
Rosenberg.
you.
Next, I'm going to call on Sarah Burke Cohen, please.
Hello, my name is Sarah Burke Cohen, and I represent the New Hampshire Municipal Association. The New Hampshire Municipal Association opposes HB 80. Currently, the statute, lost my train of thought, I'm so sorry. Currently, the statute states that the public body may participate. That's what we've been talking about. So the public body has to agree to electronic participation, which we concur with Karen. We would hope they would do so. Unreasonably practicable right now is set by the chair, but generally we find it to mean illness, scheduling issues, transportation issues, and disability. Though a person wouldn't be able to participate in person, they're trying their best to participate by electronic means, so their voice and their voice of their constituents can be heard. HB 80 sets the standard for in-person attendance to unavoidable though undefined, presumably, according to the sponsor, is a higher burden, so that it would make it so that it would prevent a person from participating electronically who may be very ill but feels like they can still make it, and they do, and maybe they infect the public body. If the public body allows participation electronically, it seems counterintuitive, as this bill would allow, if passed, to take away that person's right to vote. Currently, 91A requires roll call votes for when a public body has a member participating electronically, to ensure that the votes are on record and the public has access to them. Likewise, when a person participates electronically, that person needs to be, the public needs to be able to hear that person, as well as whoever is clerking or taking the minutes for that meeting, to ensure that their voice is heard. Instead, HB 80, by taking away the person's right to vote who has to participate electronically, seems to punish that member who is trying to balance their other obligations and participate in person. To conclude, in essence, HB 80 endorses silencing votes and silencing voices that otherwise would have been able to participate electronically, to ensure that they can be heard. I'll take any questions.
Questions for this witness? Seeing none, thank you very much. Next, Barrett Christina, please.
Thank you again, Chairman Lynn. Good afternoon, members of the committee. Barrett Christina, New Hampshire School Boards Association. I will be brief. I understand I'm probably the last thing between many of you and a warm bowl of soup on a cold winter's day. School Boards Association is opposed to House Bill 20. In our experience, the electronic, the provisions in the statute that allow members of a public body to participate electronically have been used without issue, have been used sparingly, and have been used properly. You know, most of the time it is a parent at home with a sick child, or the babysitter fell through, or a board member maybe called away to work. They're in California for work obligations. We also think that the existing law still provides sufficient transparency for the public. For example, you know, the member of the public body may only meet when attendance is not practicable. Each part of the meeting has to be open to the public and shall be audible or otherwise discernible. Should the meetings held pursuant to the terms of this paragraph shall comply with all other requirements relative to RSA 91A. So we don't think that the changing the language from not reasonably practical to unavoidable is necessary. I don't know where that line is, what makes something not reasonably practical unavoidable, but we think the not reasonably practical language meets the needs of our local school board members, many of whom are parents, many of whom have kids at home that they may have to tend to, maybe not for the full meeting, but you may need to get the kid to bed before you can hop on the Zoom and join the meeting. NHSBA would also oppose the language that would restrict a board member participating electronically from voting. The language of the bill says that the person is deemed present for purposes of the meeting, but not present except for voting purposes. Well, if you're present at the meeting, we would think that you should be able to allow to vote on whatever matters come up before the public body. And last, I want to respectfully address 2 points that Representative Turcotte made. One was already made by the speaker from I believe it was the Disability Rights Center, relative to the concerns Representative Turcotte has with how the Stratford County delegation is choosing to proceed. Paragraph 3 addresses that. as was previously stated, a public body may, but is not required to, allow one or more members of the body to participate in a meeting by electronic means or other means of communication. So if there are concerns with any county delegation, that county delegation does not have to allow a member to participate electronically. Likewise, a town board does not have to allow its members to participate electronically. A school board would not have to allow its member to participate electronically if the school board said.
Mr. Cortina, you're kind of, you run up against your 3-minute limit. If you have something very briefly you want to sum up.
I do not. With that, the School Boards Association opposes the bill. Thank you, Chairman Lynn, for allowing me to go on, and I'm happy to answer any questions.
Questions for this witness?
Thank
Seeing
you.
none, whoops, Representative Peterno.
If you have written testimony, could you
I do
submit it?
not. Thank you, Representative.
Thank you.
All right. All right. Thank you, sir. Thank you. So does anyone else wish to be heard on HB 80? Seeing none, I'm going to close the hearing on HB 80. And that's fine. Representative Alexander, I'm happy that you're here to introduce this bill. I'm going to open up the hearing on HB 164, and I will recognize the prime sponsor, Representative Alexander.
Thank you, Mr. Chair, members of Judiciary. I'm really hoping to catch us up on this bill. I'm trying to be as brief as possible. For the record, my name is Representative Alexander. This is my 4th term on Judiciary. I'm serving the town of Goffstown. This bill should be familiar if you have served on this committee in the past. There are some new members of the committee, but this bill was one that last year we had adopted as a non-germane amendment to enable municipalities the option of transitioning their records to an electronic version. This makes a small appropriation that I'm hoping we can absorb in the budget. And like I said, this would allow the opportunity for accessing public records electronically, provided the municipality provides a computer or some way to access it for free. So there's no additional tax on somebody that would like to access this data electronically. I think for the appropriation that's given, the amount of money that towns will save on not having, should they choose to do this, not having to store their data in paper copies, and the printing costs, the storage costs, I think will hopefully very much make up the cost of this bill. I really hope that the committee will consider supporting it, as former Judiciary committees have. And I have the state archivist is here to weigh in on this, as is the Secretary of State's office should needed. But I'm happy to answer questions, but there are people here to answer questions as well. So
Questions for this witness? Yes, Representative Perez.
Correct me. Didn't we pass last year that cities and towns were able to put it in the archives?
Yes. So this bill passed Judiciary, it passed the House, went to the Senate, passed the Senate. I believe it came back to the House, and there was a funding issue with it because it was the 2nd year in the biennium. So I'm reintroducing this so that we can hopefully absorb this into the budget, the very, very small appropriation.
Other questions for Representative Alexander? Seeing none, thank you very much.
Thank you very much.
Alexander.
Oh, I have one other thing to add. So the archivist in the Secretary of State's office is going to indicate that the appropriation is a little bit off, like a few $1,000s. I believe it's like over under. I have an amendment drafted that will fix that appropriation, Section 6 of the bill. I'm happy to either do it during this executive session, or if the committee would like to send it to Finance, they can also hopefully adopt that amendment. So that's up to the committee. But I want to let you know I have an amendment in drafting.
Sure. Just question. This is going to have to go to Finance anyway, isn't it?
I believe it's an early bill. Yeah.
All right. All right. Thank you. Next, I'm going to call on Aaron Hennessy, please. Hennessy.
Good afternoon, Mr. Chair, members of the committee. Nice to see everyone. My name is Erin Hennessy. I am the Deputy Secretary of State, and with me today is Ashley Miller, who is New Hampshire's State Archivist. Ashley is going to tell you a little bit about the bill and what our department would do with it, and then we are happy to take any questions that you might have.
Good afternoon,
Hi.
My name is Ashley Miller. I am the New Hampshire State Archivist under the Secretary of State's office. I support House Bill 164 relative to local records retention. As the Director of Archives and Records Management for the state, our division is often sought out by municipalities to answer their records-related questions. As you know, New Hampshire is home to over 200 municipalities, each with their own unique challenges. A local government records manager plays a crucial role in ensuring efficient record keeping. This role will allow us to reach every municipality to promote and implement systematic organization, preserve the historical records they do have, train them on digitization and metadata standards. And this not only streamlines our record keeping processes statewide, but it allows for quick retrieval of information. This bill does not create any new positions under the Secretary of State's office, but it does fund a position that is currently unfunded. With the funding of this position, we can better serve all of our municipalities by providing outreach, training, best practices, and a convenient repository where their records can be both preserved and accessible to the public. Archives are arsenals of accountability. We strive to preserve the historical record to promote government transparency. Increased access to records for the public allows citizens to monitor government activities and exercise their rights as informed citizens. This bill is a step towards access. Thank you to the committee for the opportunity to speak, and I'm happy to answer any questions.
Questions for this witness? Yes, Representative Ronbo.
Thank you, Mr. Chairman. Thank you for taking my question. As I am a new member of this committee, I apologize if something was covered when similar bill came through last year. And maybe it's better directed to Representative Alexander. Is the idea that the cost, obviously, of implementing this might be offset in part by not needing to maintain the same paper records in the same manner going forward once they are in an electronic format and available to the public?
Thank you for your question. That is correct.
Okay, thank you.
Other questions for either of these witnesses? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on former Representative Yukela. And Mr. Yukela, I just ask you limit your testimony to 3 minutes, if you would, please.
Not a problem. Thank you, Mr. Chair. For the record, my name is Joshua Yukela, former representative. I sponsored this bill last year, and the bill passed this committee and finance, and it passed in the Senate and was tabled by their finance committee because there was insufficient funds. The idea behind this legislation is to provide an option for municipalities to address some of their concerns about the overhead and their liability for maintaining the records often in boxes up in the basement or in the attic, and also that we have this concern earlier today about massive voluminous requests and the cost that imposes on municipalities, where this potential solution is to have a website that is accessible by anyone at any time, that if those records are uploaded to there, they no longer need to store them in the attic, those municipalities. They don't have to maintain that. And if someone requests that information, they just have to provide them a free way to access that website if that person is unable to do so on their own. And also, the main cost of this is for the employment of a person at the state to help assisting and answering questions from municipalities on the best ways to move, keep their records and keep them accessible to people. And I am happy to answer any questions.
Thank you. Questions? Yes, Representative Bergeron.
Thank you, Chair. I guess I'm just curious if you think that'll bring on any more IT expenses for companies that, may either need to digitalize or whatnot. I don't know. I figured you might have come across a few.
Thank you for the question. In my research of this bill, I am one of those people that requested a lot of documents from my town. I have scanned probably 100,000 documents of my town's records. So I know what it takes to put in the effort to scan that document and upload it. And there could be, if the municipality wanted to get rid of all of the documents in the upstairs and just be like, we're done with that, there could be a one-time expense that maybe would be a warrant article or something at their local town. But generally, the ongoing, if they chose not to do that, that those records could stay there and they would be requested the old way. And most records nowadays are already created in PDF format or whatever, and so that they would be able to be uploaded, the current documents, right away. And so even if they were like, we're going to forego the expense of digitizing what we already have, we're just going to move forward, then they would at least limit their liability going forward, right? Over time, it would reduce. And so, but you've heard, I think, some municipalities, they have gotten requests that cost them a significant amount of money. And I would definitely posit to my town that, you know, the $5,000 or $10,000 that it costs to scan all of those documents and put them on the website is a good investment for the you know, the 70th time that same piece of document gets requested, right? And in addition to the man hours that it requires to go get that and provide it. So I think it's a good investment of the state.
Other questions for this witness? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on Catherine Coco, please.
Thank you, committee members. Right to Know New Hampshire supports HB 164. I just wanted to make a couple of points that in many cases, the difficulty that communities have providing information when they feel that something is a larger burdensome request stems from the fact that they are not able to get those records electronically. They're not already in a format that's easily accessible. And that makes the availability of records uneven over the geography of New Hampshire and over time. We do see this a lot when people come to us for assistance, especially if they're looking to research an issue that has significant history in their community. This bill was created, and I don't think this has been discussed yet, with a lot of input and support initially last year when it first came before the committee from both the New Hampshire Municipal Association, the New Hampshire State Archives, and Right to Know New Hampshire. This is at a time was supported by all of them. If it is passed, we are committed to encouraging communities to take advantage of this option. And I just wanted to share something that hasn't come up in discussion yet today, which is New Hampshire is unique because we do not have an independent oversight body for transparency issues. We have no requirement that local officials provide record management, a record management entity, and we do not require training in RSA 91A. So even for people who are responsible for compliance with that law. And so in reviewing other state laws regarding access to information, I am consistently struck by the fact that most of those include a requirement that there be a responsible party, and we don't have that in New Hampshire. It's so grassroots that we need a solution like this to at least make it equitably available. We rely on citizens entirely to access and question information as the only enforcement mechanism that we have for transparency. And so without that kind of support, we're not surprised that public bodies are beginning to feel overburdened. So we feel that this is a solution that will help to navigate those issues. Thank you.
Thank you. Questions for this witness? Seeing none, thank you very much. Next, I'm going to call on Sarah Burke Cohen.
Hello, my name is Sarah Burke Cohen. I represent the New Hampshire Municipal Association. As you may guess, the New Hampshire Municipal Association supports this legislation, creation of a publicly accessible website for the retention of public for the retention and public access to electronic records would immensely help be helpful for municipalities as it would allow requests under RSA 91A to be processed more effectively and efficiently, as an individual could be pointed to the publicly accessible website to retrieve requested records. We continue to strongly to support the local, the hiring of a local government records manager to help guide municipalities with their record retention policies, and so again, we support this legislation and urge you to do the same. Questions?
Questions for this witness? Seeing none, thank you very much. Is there anyone else who wishes to be heard on HB 164? Seeing none, I'm going to close the hearing on HB 164. And I am happy to say that we have at least a few minutes before we have to start the hearing on the next bill. And so I'm going to encourage, I know some of you who are at the table have not eaten lunch. And if you want to do that, go, we don't need a quorum, so don't hesitate to go. Don't hesitate to take a break if you want to, or grab something. But just for the people that are here, I do plan to start, very shortly after 1. So if you're going to be here, don't go away for a long time, because I'm starting pretty quickly after 1. All right. Thanks. reopen the hearings on the, from the Judiciary Committee. And we're now on to HB 265, and I'm going to recognize Representative Caitlin Katab.
Thank you, Chairman Lynn and members of the committee. My name is Representative Caitlin Kutab. I am here to introduce HB 265 for the prime sponsor who couldn't be here right now. I'm a co-sponsor of the bill. So this bill simply just requires that minutes now contain the start time and the end time of the meeting and the name and the signature of the person who wrote the minutes. And the reason behind the bill is there's been some instances where we would have meeting minutes and somebody would be referring to them and it would be argued, well, we don't know if this is an official copy of the minutes or anybody could have taken it. We don't know if it's an official record or not, because some bodies do not vote on accepting their minutes or not. And so it's become problematic in those scenarios. Happy to take any questions.
All right, questions for this witness? Seeing none, thank you very much, Representative
Thank you.
Katab. Next, I'm going to call on Lori Ortolano, please.
Lori Ortolano, representing Right to Know New Hampshire. This is a piece of legislation we wrote, and it's pretty straightforward and simple. And thank you, Representative Katab, for assisting us. The issue we found, and what I found in Nashua, is if I went into court with minutes, which I assumed to be certified records under rules of evidence, the city was challenging those minutes because they had not been attested to, and then, you know, I didn't bring in witnesses to speak to those records. So putting in a start and end time and putting in a signature of those records will go a long way to make them certified evidence for the judges to use in court and not get us weighed down in trying to bring in city employees to testify to them. And in one instance, I had minutes that I thought were done by a board that had a recording secretary, that when I got into my trial, there was no discovery permitted. Through a series of questions, it turned out the city was acting as the recording secretary and not even the board itself. So it would have made it very complex for me to even bring the right people in to figure out who had done the record. The start and end time is really important, I think. In our city, we have, of course, our Board of Aldermen, which is our main board. We have standing boards of the Board of Aldermen, which is 8 or 10 boards, and those meetings are all televised. So you can easily watch a meeting and look at YouTube, and you can see when it starts and when it ends and how long it is. But there are approximately 30 other committees of appointed, largely with volunteers and some liaison board members, that are not televised. And some of them are running pretty lengthy meetings, and you're getting minutes that can be all of 2 sentences. It would be nice. I started wondering, especially committees that are dealing with tens of millions of dollars of money, and the records are coming out with just a couple sentences. They seemed too brief. But then again, I don't have anything to go on to say, how long did they meet? If it's a 5-minute meeting for whatever reason, then okay, maybe 2 sentences is fine. But if they met for an hour or even 30 minutes and the meeting and the notes are that short, it's a good indication for citizens to go to those meetings and listen and be aware of what's going on and follow up. So I think the start and end time would be very beneficial. We also have a member of Right to Know New Hampshire who lives in the North Country. Some of the smaller towns are more lax in posting their notices for meetings that are going to start at 7 o'clock, but they start at like 10 of 7. They start 10 minutes early. And so the public comes in and they've already voted on the first 2 agenda items and they're just rolling. So by actually writing down the start time you will try to get them to align with their notices and the requirements of the law. And I think it's a pretty simple change, and I think it would be hugely beneficial. So I would love to see your support. Thank you very much.
Great. Questions for this witness? Yes, Representative Perez.
Thank you. Thanks for my question. I live in Londonderry, and last year we had yes, there's a question. We had a citizens petition to have all meetings recorded. And yes, it was just advisory, but it did put pressure on them so they don't have to. But I don't think we have any that are not recording. Literally, we have someone going in with their iPhone and recording them being done. Have you thought about doing something to that?
Have done it, have asked. I mean, we have good television capabilities and we have the chambers opened, but some of these boards I think don't want to be televised.
But I
and
mean,
so they
putting
go.
in something that would make it, the citizens decided that it had, oh, you're in a city. Sorry.
I'm in a city, so we'd have to do it via petition. It's a lot of hauling for
Yeah,
10%
yeah,
of a population, but we've asked the board to do it. There's been resistance. They could be doing a lot more to televise, but they're pushing back on that. So, so the next best thing is getting a start, an end time, and an attested record that we know who we can go to should we have a question on the record.
Perfect. Thank you.
All right. Other questions for this witness? Yes, Representative Bergeron.
Thank you, sir. Thank you, Chair. I just wanted to make a comment that on another board that I'm on, we definitely televise everything and we have quite an audience. I'm really shocked by that. So yeah, so if you have a good system, should work well for you. So.
Yeah. Oh, I'd love to see it used more, and the television station has offered to televise more and to have people there to televise, but these boards are sticking in these little side rooms that aren't hooked up, and that's where they're comfortable. So yeah, it's just a little bit of a fight. That's all.
Thank you. Other questions for this witness? Seeing none, thank you very much.
Thank you.
I don't have any other pink cards on HB 265. Is there anyone else who wishes to be heard on HB 265? Seeing none, I'm going to close the hearing on HB 265. And again, we are fairly lucky. We have about 12 minutes before we start our next hearing. So we'll take a brief recess. Again, if you want to, slip a little bit of food or whatever, this is the time to do it. Thanks.
Where do you get coffee in this place? No, I mean like really.
Oh, well, it's after you get the basement of the state. Oh, you have to go across. That's the It's now beyond 1:30, so I'm going to reconvene the Judiciary Committee, and we'll open the hearing on House Bill 114 FN, and I will recognize the prime sponsor, Representative Louise Andrus.
Good afternoon, everyone. I hope you had a quick lunch like I did. Okay, I'm introducing House Bill 114, and I know there's a lot of controversy over it. The reason I submitted this bill is because I represent the citizens. And the citizens, when this bill became law, many may not realize it, they were unhappy all over the state. In 1976, the right to know was added to the Constitution. And I realize there's problems with right to know and what we need to do and what we don't need to do. Personally, I think we need to keep everything as simple as possible. Unless absolutely necessary, I don't believe in charging fees. There are people that can afford fees when they ask for much information, but then there's ordinary citizens that can't afford fees, therefore they cannot ask for the information. And the question I keep asking myself, and I'm not trying to say anybody's guilty of anything, but some of the places, municipalities, etc., that were saying they got too many requests, they got too many big requests, etc., etc., my question is, were they guilty of anything? And if a person cannot obtain the information that is theirs, nobody will ever know. And I firmly believe there is a balance, but the citizens have a right to know. Everything is their government. And the employees of all public entities work for the citizens, and it's not the other way around. So I'm just going to give you an example of excessive information. Back in 2015 that I had, an individual came to me and said that our school district was going into non-public and discussing things and then come back out and vote on things, et cetera, et cetera. Me being me, I started investigating. I bet in the end, I obtained and read between 10 and 15 years of minutes of meetings. Now, if I had had to pay for them, I mean, that's 150, 200 pages. If I had had to purchase those, I would never have been able to find out the truth of the matter. And the truth of the matter was, over a period of years, our school board was going into non-public, and they were discussing things that they shouldn't have been, and then they'd come out and vote on them. So then, this other individual and I, as pro se's, once we get all our information, took the school district to court for violation of right to know and having gone into non-public and discussed things that they shouldn't have. We went as pro se, which is, I have respect anybody that goes into court for pro se because we had no idea what we were doing. But we won the case. Now, if I had had to go again and pay for that information, we would never have stopped the school board from discussing things they shouldn't have. And I mean, one of the things they did, if there was a vacancy for a school board member, they would go into non-public and discuss all the candidates, and then they'd come out and vote on them. And that's a no-no. And more recently, I know that under the current law, policies need to be set up, and they haven't been, so everybody's kind of doing what they have normally been doing. And recently in my school district, again, we ran into problems, so I've been asking, instead of asking for a whole big bunch of information, I ask one question at a time so that they won't charge me. And what I found in the end was that we had a business administrator that resigned, but it was never recorded in any minutes anywhere. We have a school district, which I don't know what's going to happen. We got too close to knowing the truth of what was going on in our school district when they suddenly came out with a paper and posted it that we had a deficit of $1 million in our school district at the end of June 2024. So I'm going to go back to the same thing. I believe no fees should be charged, and I know people disagree with me, and that's okay, but I stand for the citizens, and I would like to see the current law repealed. Thank you.
All right. Questions for this witness? Representative Birch.
Thank you, Mr. Chair, and thank you, Representative. When you speak of speaking for the citizens, I want to ask you about the citizen taxpayers, because none of this is free. So do you have any sense of how much additional taxes the taxpayers will pay if the users don't contribute anything towards their requests? Do you have a number?
No.
All right. Other Representative Perez.
Thank you. Thanks for taking my question. Would you consider an amendment that said that citizens of a town or business in a particular town did not have to pay fees, but entities outside of the town would have to pay fees? Now, I know the thing is, well, then, they'll just get someone in town to submit it. Well, we can't be police. A lot of that happens. But would you consider that if we made it for your town and any business owner in your town, there were no fees for them?
Yeah, that would be something to consider, because many times when people request information, it is within their town. Most people don't go to another town and ask for information. And I think it's something, if we could come up with the right amendment, that within your own town, citizens and businesses wouldn't have to pay, but anybody outside of that, they ask for information, yes, they would have to pay.
Other questions for this witness? Seeing none, thank you very much, Representative.
Thank you.
Next, I'm going to call on Representative Colomb, please. Representative Colomb? Colomb, I'm sorry.
No.
So, Colcom, sorry. I'm sorry.
Thank you, Mr. Chairman. For the record, I'm Rashay Colcom from Hillsborough District 30. I would like to speak in favor of this bill, but I would like to also suggest maybe considering a couple of amendments, such as the one that Representative Perez suggested, except for there's a little bit of a conflict with just being the resident of the town, because as a representative, I actually represent 4 towns, and there are times that I'm asking for information from one of the 4 towns. So I have concerns over the fact that just because I don't live in a town, you know, and I'm asking for information, I'm going to now have to maybe pay for information from that town. So maybe if we're a New Hampshire citizen and we pay taxes in New Hampshire, as most of us citizens do, that we could be open to this. One of the problems I do see, and I think is a legitimate problem, in talking with our police chief, is that, you know, the police department in my town got hammered with right to know requests, and he does not do anything through email. Everything is paper requests. He fulfills only with paper, so he does incur an awful lot of money for that. And what happens is often people will send in the requests, they occupy their time, and they never come and pick them up. So I do understand that there is a real problem to this. However, we have a problem on the other side as well. I actually identified an issue with a new greenhouse that was put up in our town. The greenhouse actually never had an inspection, the final inspection. The unit heater on it was actually installed incorrectly. So there were many issues. I then started to ask for some right to know information while I was addressing the problem with them as far as this unit is not installed properly. And what I noticed on their right to know sheet is that they calculated that it took them 14 hours of time to address my right to know requests, which is absolutely absurd for the information that I was asking. And what I found out was that the superintendent was holding meetings within the school district with the person who asked for the greenhouse, with the facility maintenance team. And they were trying to solve the problem about how did this unit heater get turned on. It was a propane unit heater. How did it get turned on without somebody with a gas license or somebody knowing that there was not a propane retrofit into it? So anyways, there's abuse at our school district, and that she put 14 hours of time was needed to fulfill my right to know request, which was false information. So if we allow them to just build up that time and charge us for time, then we have a problem, because now I've got to try and fight it, which I did try, and they still didn't make an adjustment. But we also had the problem on the other side with our police chief legitimately getting requests that are taking up time. So where's the balance between the two, and how can we make that work without charging us taxpayers more money to ask for the information that we have a right to know, because our tax dollars are actually funding these things? So I don't know what the right answer is as far as the amendment. I like the idea. My thought while I was listening was that maybe we allow the New Hampshire residents to request right to know information for free, and we try to encourage them to send as much as they can electronically, and that it doesn't have to be done on paper. Or, you know, we go in and we make our own copies with our phones. I mean, most everybody has an electronic device where we can scan documents now, which is often what I do when I go to another town and they don't email me stuff. I just go in and I scan it on my phone, and then I print my own PDF when I get home. So I like the idea of not charging us fees. Don't like the idea of our police departments in other areas getting, you know, unreasonable requests and asking for a lot of information. And I don't like the idea of other departments inflating the number that they need so that they can meet the requirements in our law that will allow them to charge.
All right. Thank you. Questions for this witness? Yes, Representative Katab.
Thank you, Chairman Lynn, and thank you for taking my question, Rep. Colquhoun-Bay. I wanted to ask, are you aware that in current law that there is no charge for an amount of time? And in fact, what the current law has is that if you're requesting more than 250 communications, meaning emails, that you could be charged up to $1 per communication, and that's not per page, that's per communication. Anything that's under one subject is all considered one communication, as well as any attachments, so that it is a static price for the number of records and not by number of hours.
Thank you for the question. Yes, I'm aware. I'm aware that we had made this change in the bill that was passed in the last session. However, it concerns me that through the conversation and the amount of bills that we have coming up, that there may be an attempt to try to go that direction again, and I'm hoping that there isn't. So I am aware of that. So thank you for the question.
Other questions for this witness? Representative Perez.
Could we think about, what are your thoughts on if we had it for citizens, but then because we're not we don't make money, citizens, but businesses had to be charged, because what happens, like I know what happened in Londonderry when we had our town manager running actually for Senate a few years ago. We had newspapers in places from all over the United States requesting everything about him. So maybe if we could make it so citizens weren't charged, but companies or businesses that were, for profit, as we're not for profit, would be charged. Would that cover what you're trying to cover as far as, going from town to town?
Thank you for the question. That sounds like that could be a reasonable solution as well.
Other questions for this witness? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on Catherine Coco, please.
Hello again.
Hi.
Right to Know New Hampshire struggled with this bill. We spent a lot of time last year negotiating HB 1002, and we felt that we came up with an effective compromise that took number of hours out of the equation and focused on what we were being told were the most burdensome types of requests, which were having to go through electronic communications and having to perform redactions. Having this language that is now in statute in here was a hard fought negotiation. Right to Know New Hampshire opposes HB 114. We think that strategically it can do more harm than good to go back and try to renegotiate this scenario. We will say that generally what we have been hearing is that this rule is not being implemented in municipalities. They are required to have a policy in place before they are allowed to charge anybody for records, and we are aware of only a handful of communities who have actually done that. We also feel that by addressing this major concern of public bodies, we are removing barriers to making progress on other issues, such as getting more timely responses. Communities now have no excuse to come back to us and say, well, the request might be too long, be too hard, and we have to have our attorneys go through them. We've removed liability. They can have it automatically redacted. We feel like we've made significant concessions in the interest of moving Right to Know forward in other ways. And we expect that we'll be able to do that moving forward if this stays in statute. That was not an easy decision for our group to come to. I want to make that clear to this committee.
Questions?
Yes, Representative Perez.
Questions, Representative Perez.
Thank you. Thanks for taking my questions. Are you aware that what towns are doing now, as they did to Representative, they're saying how many hours it took them, and they're equating the hours that it took them to how much it's cost the citizens, which really, I mean, it really inflates a lot, and I don't think that's in passing at what people would have to pay. I mean, my town says, oh, this took so many hours, and it seems to appear, and whether they want to do it or they don't want to do it, I can't prove that, but sometimes it appears that way. So to the citizens, it makes it look like this is outrageous. So
I am aware of that, and I appreciate that question because it gives me the opportunity to point out that nowhere in statute is there a limitation on that number of hours. It's very common for communities to come back and say, we've spent X amount of time addressing this issue. They do account for that in those ways, and the city of Nashua has made claims about the expenses associated with their requests, which are fairly outrageous. But that does not come back. That's a PR issue. It does not come back to the individual who's making the request. They are not being charged on that basis.
All right. Other questions for this witness? Seeing none, thank you.
Thank you.
Brandon? Brandano, sorry. Mr. Brandano, please come up.
Thank you, everybody. My name's Al Brandano, and I'm from Kensington, New Hampshire, and I speak in favor of this bill. I have 3 specific points. One is first to talk about the memorandum that the Attorney General produced on 91A in March 24th, 2024 this year. A lot of people are not aware of it. It's the first rewrite in 15 years, and it's very inclusive, 254 pages or so. The second thing I'd like to bring up quickly is I feel like sometimes when it's 91A, I should be on the milk carton for this because of my experience. I want to just briefly tell you what's happened to me, and 3, why I'm supporting this bill. First, New Hampshire Attorney General, March 24th, was the first time in 15 years that someone addressed 91A. The introduction, New Hampshire Constitution provides the public the right to access government records. Proceedings and records shall not be unreasonably restricted, Part 1 and Part 8 and 38 of the New Hampshire Constitution. The basic philosophy is underlying the statutory process is simple. Openness in the conduct of public business is essential to a democratic society, 91A. The New Hampshire Supreme Court has made clear that it will resolve questions regarding the right to know law with a view to providing the utmost information in order to be best effective and statutory and constitutionally objective. Second part is I'd like to share with you a brief experience of the 91A process before I get to the other part. It's what an individual can expect in New Hampshire. I was involved in 2022 in a case that went all the way to the New Hampshire Supreme Court on 91A. It almost bankrupted my family. It was a bad decision. We believed at a lower court level, had to appeal and went all the way, and it was horrible, horrible. The second part of it was I had the pleasure, and I say the pleasure of working with Ombudsman Kerr and that next process, having going through the first process legally, there was another legal process that you provided, which is through the Ombudsman process. The first one was, it's really a kind of a misnomer when you say Ombudsman because it's not the traditional thing. He's an administrative law judge. So when an individual like me goes there, or any individual, any citizen, you have to really almost have a law degree. There is a full, it can be a trial, witnesses, a statement of facts, all kinds of things that regular people would not be aware of, nor was I. I had 2 sessions, 2 different issues. They were both, one was resolved and one was really, we were able to work through that allowed for, there was HB 154, and that was a bill that had 22 election law issues brought up in it. But the chairman of that committee used his private email. And that's the problem for that is that when someone uses their private email for public business, when they leave, they take those records with them. So with the help of the Ombudsman, we were able to negotiate a settlement with the House and allow all House representatives now to use their government email rather than private email. And so what brings me to the end here is why I support HB 114. You recently passed HB 1002. To me, it was a pay-to-play. You have further placed an unfair and unjust tax burden on the citizens that, in essence, these burdens is simply exercising their constitutional duties to hold exact oversight. Part 1, Article 38 is very clear. It says exact for a reason. I don't think a lot of people understand that word. The term reasonable, as defined by the Attorney General in March 2024, clearly speaks of restrictions. But yet it has no standing in contrary in 1784, as the Constitution has never been amended. So we're making laws that conflict with the Constitution, in my opinion. And our inalienable rights give us this right. It's not a tax right. It's not something that I believe that we have to be taxed for, or I have to adjudicate in some way or pay something. That's part of our inalienable rights. These are ours not to be taken away. And last, therefore, this body must find and pass legislation, actions that are unjust of the violation of the spirit and intent of the Constitution. And I think overturning HB 1002 at this point with this bill is the right thing to do. I'm open for any questions.
Questions for this witness? Seeing none, thank you very much, sir. Next, I'm going to call on Alvin C., please. I'm sorry, Representative. Representative C. Sorry about that.
Thank you, Mr. Chairman and members of the committee. I'm Representative Alvin C. from Loudon, and I serve Loudon and 7 other towns. I feel that the right to know for citizens shouldn't be hit with fees or taxes or whatever anybody might want to call them. Even if there's a minimum of free requests before the fees hit in, because sometimes it takes numerous requests to dig down to find out the information that you're looking for, and you've already heard people testify to that. So, you know, it gives a situation where the town or city itself can stonewall and, you know, drag things out. So you have to request more and more things just because you're not getting everything at once, to the point where you're hitting the minimum. You've hit the minimum and now you're getting billed for things. And that is something that can inhibit some people's ability to use the right to know, to understand what their government is doing for them or to them. And while there have been abuses discussed, it may be that the thing to do is to carefully analyze what the abuses are and take some sort of action to deal with those specific types of issues. Maybe also you might be able to consider charging for out-of-state research firms or law firms when they're doing working on a case or something like that, because that is something that would be billable to their client. Those are the sort of things that I think might be useful there. And I've heard reports of people requesting lots of stuff and then not picking up the information. That is something that should be addressed as to why that happened. And I don't know what kind of penalty there should be, especially if it's just a citizen. Also, one of the other things I heard a couple people mention of just being able to research stuff in your particular town or city, especially for representatives who represent several towns. I represent 8 towns. But also there's several different school districts in the various towns that I represent. So there's almost as many school districts in my town as there are schools. So it's just one of those things to watch out for if you were to narrow it down to a person can only get something from their own town. For me, my school district, the district headquarters is not in my town. So that would be a different thing to look at. With that, I'll conclude, and I'll take any questions if there are any.
Questions for this witness? Seeing none, thank you very much, sir. Sarah Burke Cohen, please.
Good afternoon. My name is Sarah Burke Cohen. I represent the New Hampshire Municipal Association. NHMA opposes HB 114. As you're aware, HB 114 eliminates the ability for both municipalities and the state to recoup costs associated with voluminous record requests. The bill asks public bodies, many with limited staff, to use precious resources compiling, redacting, scanning, or copying documents to fill a request. That can take hours or days. due to the sheer volume of the request. It further tells that limited staff it cannot attempt to negotiate a modification with the requester to help narrow the request. And finally, it tells that staff that if they forget to redact something in the thousands of pages just produced, that the town or city could be liable for that mistake, which of course will likely lead to a lawsuit. Instead, the cost of fulfilling, oh, sorry. The fee schedule in place prevents this from occurring and instead allows the public body to recoup some of the costs of responding. Without the fee schedule, imagine being a small town in which the staff made up of 1 or 2 people has to fulfill a voluminous record request. What gets sacrificed? Does the staff get paid overtime to allow for the response to be completed? And there are other duties to be completed? Probably not, because there may not be funding. So what does get sacrificed? And after taking the time to ensure every document has been redacted, but missing something, then what? A lawsuit, which means something else gets sacrificed because of a simple error. Perhaps the fee schedule currently in place isn't perfect, but eliminating it before municipalities have had the opportunity to adopt and utilize it will require towns to sacrifice their resources to cover the costs of voluminous requests made by a requester who may not even be a resident of that town, who instead is angry with goals to punish and with no way to recoup the costs. It will serve its purpose and truly punish a municipality. The intent of RSA 91A is to allow for transparency, not allow an individual to punish the public body. I'm open to questions.
Questions for this witness? Do you have written statements?
I just have my notes.
Okay, no, that's fine.
Okay.
All right, seeing none, thank you very much.
Thank you.
Next, I'm going to call on Lori Ortolano, who indicates that she supports and opposes the bill. So we'll be interested to hear what you have to say.
Lori Ortolano, Nashua. Okay, so I'm wearing my Right to Know New Hampshire hat. As Catherine explained to you, we had a difficult time coming to agreement on what to do with this bill. We didn't want to jeopardize seeing the situation or create a situation where it could get worse. We knew when this went forward to the Senate last year, some of the Judiciary senators felt very strongly about this language and even pushing more into it. So we were concerned going forward to the, the next branch that we would encounter difficulties trying to push this change. We want to make, Catherine just handed me a little piece of paper. We wanted to make it clear that the $250 cost covers a 30-day time frame. So if you're trying to not pay the fees, you can just draw it out over a longer period of time so you're not charged. And also, the group as a whole would not support trying to distinguish between who's eligible and not eligible to avoid fees. And the only reason is because it was something that was negotiated when HB 1002 was handled last year, and it's being addressed in 66 and 74, we kind of feel, HB. So now if I speak to you as a citizen of Nashua, I like this bill. And because Nashua's been so difficult. Nashua was a force behind asking for these fees to be imposed. They wrote letters and they had 27 representatives take the position that a few people have cost us, and the city, upwards of $1 million in processing the right to know requests. And then last year, and this legislation passed. Before it passed, a year prior, I had asked the city to look into redaction software. If they really felt that redactions were causing the problems on emails, consider doing that. And they said, we will. We're going to research that and investigate. And they proceeded not to do anything for 12 months. So at this year's budget hearing in June, where there's an open mic to ask questions, I followed up. And once again, they have not moved forward on that. So this legislation, HB 1002, becomes active, becomes law, and the city of Nashua never wrote a policy to charge fees. So there's no policy defined, there's no redaction software, and in fact, they're not charging anything. I feel like it was a lot of complaining for nothing. And the concept that you pay $1 per email above 250 disturbs me a lot, because I just finished a request. I want a Supreme Court order to get emails that were on this backup tape. The city in October got the mandate from the court and was supposed to start producing them. Well, they downloaded them. They told me there were 1,300 emails, and then all of a sudden they started batching them out, and the first batch was over 3,000 pages. I looked, and there was an attachment that was 3,100 pages long. That was a database on the computer, a public record. So I said, hey, I don't want attachments. Don't even give them to me. These emails are basic assessing emails. They're very simple. I know I'm not going to need the attachments. A lot of it is all public record. Just don't bother reviewing those. I don't want you to review and redact. And they wrote back and said, we have to review and redact them all. You don't have an option. This is the way we do it now. Now, 2 years ago when I filed to the Supreme Court the appeal, had this order been filled, the legal office did not do it that way. They would give you emails. If you said, I don't want the attachments, they wouldn't even bother looking at them. They just get the order done. But somewhere between 2 years, they implemented a new unwritten policy, not publicized, only in the legal office. Other departments in Nashua would not give you, didn't have to give you attachments. But the legal office said, you're getting every attachment. It took 8 months to finish the order. There were over 7,000 attachments. I ended up with, 8,200, 8,300 records. And it just was ridiculous. And most of those emails above, if you get charged $1 a page, they're simple emails, like a single sentence. Can be 3 words, 5 words, 10 words. And that's the email. So each one is distinct. And I have to pay $1 for every one of those. That if you put them on one page, 100 of them would make 1 page of text. It just seems absurd. So the whole process in Nashua is really done to not be transparent and to be very destructive to citizens. And they were the ones really pushing to get this legislation through, and and have never used it. So from my personal perspective, I don't like the way it went, and I don't think citizens should be paying fees. I think and I would work with my city anyway. It isn't that I don't pick them up or I'm not willing to work with them. I would work with them any way I could to reduce the burden, but they will not permit it. It is not permissible to do that. That batch of emails, I received my own personal abatement application at least 10 times in the records across 8 months. I didn't need my own 12-page application sent back to me and reviewed 10 times. And the way the email costs are done, threaded emails you're not charged for. So if an email is sent and there's a response and there's a record of 6 or 7 emails that tie to one, you're going to get charged for 1 email. The problem in Nashua, and I think in other municipalities, is when they conduct email searches, these emails are coming up as single threads. It's the same email, but they're coming up over and over again. What I see in my batches from Nashua is I'll get the same email 10 times, spread out over 8 months, or 15 times. I have to be paid. I have to pay for each one of those because it's not on a common thread. Same record over and over and over again. And there's no way to work to reduce the burden on that. They're not willing to work with us. So it's a painful piece of legislation. I haven't been charged. I mean, if they had produced those records quickly for the Supreme Court order, I could have paid upwards of $900. I think that's a lot. And it would have bothered me to pay that amount of money. Thank you.
Questions for this witness? So, I just want to make sure I'm understanding. Am I correct? I think I am, but you tell me if you think I'm not. That in order even for the charge of above 250 email communications, the municipality can't do that unless they've adopted a policy.
Correct.
And you're saying Nashua has not adopted a policy.
No policy in Nashua.
So I mean, to the extent you're saying, and excuse my using the colloquial, but to the extent you're saying Nashua is kind of out to get people that want to file right to know requests by charging the money, Nashua is not doing that. So I guess I'm a little confused. What, if we're to think that Nashua is this like evil entity, why aren't they doing what they could be doing?
Well, that's a really good question. Why would they disparage citizens at the microphone in public meetings for years, rip us apart, and then turn and write to all the legislatures, all of the 27 people supporting Nashua to get up behind this bill and send information to the state saying we need this because our citizens are killing us, and then do nothing and still complain? That is an evil government. That's an evil government. Okay, what is with that? What is with that? Why do our reputations not matter? And they could implement it at any time. I don't know what they're doing. Honestly, I don't understand what they're doing. Supposedly, they're reviewing redaction software. They did 2 companies. There's a third one. There's no update. It's taken 2 years. How hard is it to pick a software package?
Okay, all right. Other questions for this witness? Seeing none, thank you very much.
Thank you.
Right. Is there anyone else who wishes to be heard on HB 114 FN? Seeing none, I'm going to close the hearing on HB 114, and it's after 2:15, so we can open the hearing on HB 313, and give me just 1 second, please. Where is 313? 32. Okay. Okay. So, Representative Alexander is here. All right, Representative Alexander, please.
Thank you, Mr. Chair, members of the committee. For the record, my name is Joe Alexander. I represent the town of Goffstown. I filed this bill on behalf of a constituent who I believe will be testifying today. This bill will do 3 things. First, will give the public the right to attend a meeting where they are being spoken about in non-public. It would make a change in non-public sessions to give a citizen the right to attend a meeting in which they are being spoken about. It will give them the right to request an open meeting, and then if the person requests an open meeting, that shall be granted. So allowing a person to have transparency in how they're being spoken about. I filed this bill with those intentions. I think doing a little bit of more research, I think there are some changes that I think I'd like to make, including notifying members of the public when they're being spoken about in non-public, and treating members of the public the same way as members of government would be treated in cases where they have a non-public session where they are being spoken about. So currently under state law, a member of, for instance, the town of Goffstown that is being spoken about in non-public has the right to waive that non-public hearing to allow the conversation about them to be done in public. I'd like to consider that really as an intent of this bill. So I filed this bill. I think I would like to see some work done to it. So I'm happy to hear feedback from other people as they testify, but because it's in our committee hand, I would request that we would get together and hopefully hash out some further details on it.
All right. Questions for Representative Alexander? Yes, Representative Birch.
Thank you, Mr. Chair. Thank you, Representative. Just to start out with, how do you know, or how would a body know in advance that somebody's name is not going to come up or is going to come up in a non-private session, so that that person would have a right to come in ahead of time? Let's say the idea is to talk about person A and person B's name comes up. What happens to person B's right under your bill to have attended the hearing where his name came up or her name?
Well, thank you, Representative, for that question. I would say that there's clearly outlined specific X amount of instances in which the member of the public body can go into non-public. So my anticipation is they would know the general idea of the reason why they're going into non-public, and then be able to notify the officials or members of the public that they're speaking about. I think that adds a little, like, an extra layer to it, but by saying they know ahead of time if they're going into non-public more often than not, because you have to state a specific reason to go into it. So at that time, they can then notify those members of that are involved in a certain situation and allow them to attend the meeting.
Follow up? Go ahead.
If I could follow up. So let's say you've got a non-public meeting where 3 people are being discussed. One wants the meeting to be public and 2 do not want the meeting to be public. What happens?
Well, I think that's a good question for the committee, and I invite you to maybe sit on subcommittee with me to hash that out.
Thank you, Representative.
Other questions for this witness?
We don't spend enough time together over there.
All right. Thank you very much, Representative Alexander. Representative, I'm sorry, not Representative, Ms. Coco.
Turned it off. Thank you again. Right to Know New Hampshire generally supports this bill. I do want to make a few clarifications. Our interpretation is a little bit different than what Representative Alexander just presented. He is talking about the ability to participate in a non-public session as a member of the public. When we read this bill and discussed it with Right to Know, we interpreted it to mean that the individual who is being spoken about has the ability to not only request that the meeting be open, which is already in statute, but to be given information that that is about to happen, and that there be a requirement that that request that it be public be granted. So that is a slightly different interpretation of the language, and we would support an amendment to that effect. Right to Know New Hampshire has consistently pushed this reputation question. I can submit some written testimony with examples and concerns that we have about how heavily used the reputation exemption is. The one that I like to use, because I find it so shocking and came from one of my local communities, was the example where they went into non-public under reputation to discuss something, and in the course of the conversation realized that they really did not have a basis for using reputation as the reason for this. And so the conversation, as it was then told to me for an opinion after the fact, was, well, we need to say something bad about somebody so that we can stay within the rules and the reason that we went into non-public and go ahead and seal those minutes. Providing somebody with prior notice would prevent that type of abuse. That is an extreme example, but I do think it's very relevant to what Representative Alexander is trying to accomplish. Just see if I've covered everything. So I think the real question is, the language now, as we read it, allows somebody to ask for that meeting to be available to the public, be held publicly so they can hear what's being said about them. In reality, an individual has no ability to exercise that right because they are not told that that is what is going to happen. So whether we want to revise the legislation so that it addresses an open meeting where you're willing to have that reputational discussion publicly stated, or you want the individual to be able to go into non-public session, there are ways to work that. We have worked on this issue before, and we would encourage having a working group to address it.
Representative Horgan.
Yes, thank you. I missed the previous testimony, but you probably have thoughts of, do you have any thoughts about how, if we move forward this, how we'd amend it to cover the situation, well, the situation where multiple persons are involved in something they're discussing, and even if one person thinks this doesn't adversely affect their reputation, the open discussion might might adversely affect the reputation of other parties involved in whatever the matter it is that's being discussed.
I do, and I appreciate the opportunity to speak to that, Representative Horgan. So I agree that most communities are well aware of what is going to be on the agenda for a non-public session and what that topic will be and what it will likely touch on. In my town, you have to have your information in by Wednesday or Thursday. The agendas go out on Friday, and typically the non-public sessions are planned in advance. I don't think it's unreasonable for a body to say this is touching on matters that we have not previously considered and aren't yet ready to discuss. There's no reason that they can't postpone that discussion. They have lots of leeway for emergency meetings if it really is that urgent. They have the ability to have special meetings. They could move forward with something that's posted within 24 hours. So.
Yes, Representative Birch.
Thank you, Mr. Chair. Thank you. I wanted to follow up because I'm sure you heard my questions to Representative Alexander. You seem to suggest that a board or committee can figure out in advance of the discussion in the private session everything that's going to be discussed or every name that may come up, so that anybody's name who might come up can be notified or would come up might be notified ahead of time. And then if that doesn't work out and the name comes up, everybody can just stop and restart again at the next scheduled meeting. And then if the next scheduled meeting, a name comes up, then presumably you would stop and schedule it again. I'm thinking about personnel matters and how this would work, because you could be dealing with an incident where somebody may have to be reprimanded or let go or whatever, and that person says, well, so-and-so saw this. Well, nobody knew that in advance. Then you just stop everything. Is that the method you're suggesting?
It is not. I think there are a couple of things being conflated there. The first is an assumption that the session would have to stop because it's a non-public. The person could request that it be held openly, and that wouldn't be an issue. But you're speaking about employees, and employees are covered under other exemptions under the law that they either do or do not have a particular right to be part of a discussion about them. And what we are talking about is Joe Q, member of the public, who the Board of Selectmen decides that they are going to discuss because something has happened in town or there is some suspicion or something. We're not talking about employees and hearings. They have their own processes, and that's what my written testimony will speak to. I can submit that to the committee as well.
Other questions for this witness? So I want to make sure that I'm understanding one thing. You said that if I'm understanding, I want to make sure I have your position correctly. You're saying that you believe that if a person is going to be talked about in some adverse way at a meeting, they should get notice, and then B, have a right to request that the meeting be open, and that request would have to be granted.
We believe that the language that, as we understood it, proposed would do that. What we understand is that right now, an individual already has that right. It says anything that would, other than a member of the public body itself, unless such person requests an open meeting. The challenge we run into is
There's no notice.
There's no notice.
Right.
So how do you make that practicable?
Right. So I guess the thing that's one thing, and at least speaking personally, that might be something if it's, you got to give notice and the person has the right to demand that the meeting be public. That's one thing. And I might be able to, I want to think about it a little bit, but I might be able to support that. But are you saying that the person also should have the right to be notified and be present even if the meeting is not going to be open to the public?
I think that's a separate issue, and we didn't think that's what this legislation was addressing. We have pushed for that in the past.
Right, so you would support that also?
We would support that, but I think we thought that This was taking a simpler approach, which is enabling a right that already exists under statute. And the presumption is that if that person asks for that meeting to be open, it will be granted. But explicitly stating that is also helpful. We weren't going down the non-public participation and non-public session conversation when we came into this hearing.
All right. Other questions for this witness? Saying none, thank you.
Thank you.
Next, I'm going to call on Phil Giroux. And Mr. Giroux, you've submitted written testimony, which will be distributed to the members of the committee, or has been. So I guess what I want to say is, I don't want you to, please don't just read your testimony. I want you to, if you have something you want to tell us, that's fine, but we can read as well as you can.
Yeah, no, I'm not going to repeat that. I'm just going to hit the highlights of it, because from this discussion here, it sounds like this whole thing's been twisted around now, because it almost sounds like you're talking about giving notice regardless. No matter what, if you're going to talk about a person, you're going to give notice. And this is one of my complaints, because in Volble versus Town of Bridgewater, they stated that Johnson versus Nash stated that basically, unless such a person requests the meeting open, that requires advance notice. So that's how the law is right now. But in 2005, so now, first off, it sounds like no matter what, according to the law, the way the law is written, and according to Johnson versus Nash, if you were to talk about somebody, you're supposed to give them advance notice, to give them an option to exercise that right to keep it open. Now, in 2005, I was before the Supreme Court, and I was arrested and prevented from attending a closed session, which some of you might have remembered that testimony in 2023. I mean, I know you hear a lot of them, but I was arrested, prevented, told to small town politics. Okay? So now you got Johnson versus Nash that says I needed advance notice, and now you got a court case that says, oh, wait a minute, no, you don't have to give anybody advance notice. So it's kind of contradicting themselves. And you could say, and you could present this argument that since the legislative failed to amend Section C when they amended Section A after the Johnson ruling, that the legislative intent was to give us all notice before you talk about us. But then in the 2023 legislative session under House Bill 652, this committee said, no, we cannot give you that because it's going to interfere with investigations. It's going to interfere with other statutes and all that. You did not want to give regardless clause. So now I'm kind of confused, because now it looks like we're still hindering here, but you still have a statute here that says this thing and a court ruling that says notice must be given all to everybody. But then you got a court ruling, which you can't use in a court because it was a 3-judge ruling. But a Supreme Court says, oh, no, you don't have to give notice. It's okay to arrest and prevent them from attending. And you don't even have to give them access to the minutes, because that was the one thing I was asking for, unless such person requests an open meeting. Well, what's the time limit on that? Okay, I missed the meeting. I want to see the meeting minutes. I'm requesting the meeting minutes open. And that's when I was told, no, you can't see those meeting minutes. But that's kind of contradicting to your statute. So I'm kind of trying to clarify the statute here. And that's why I turned around and I just put, because when you go to court and you're going to argue this in court, no matter what, the first thing the court's going to do, which you might be able to relate to this, Rep. Lynn, is they're going to say, first off, do you have a right to that meeting? Because that's what happened when I went to the federal courts. And that's what they're going to ask. Do you have a right to this meeting? The second thing they're going to ask is, in a defamation, what harm actually took place? Just because this board is talking about a person, you have to show harm also took place to the reputation. So, I mean, there's two big jumps there. But my point right here is, if we have a right, a due process right, you should be able to you should be notifying this person. Now, in my interpretation, from what I've been hearing from this statute, it seems most of the violations is because the towns and the municipalities aren't following the law. I mean, you got people talking about people and not, I mean, it's just, they're not following the laws here. So, I mean, it's like, what do you do? I feel, and I know in 2023, you might recall that argument because they were trying to define that word right. What is a right? Well, I ask you at this point, well, if you got people here holding closed sessions and holding meetings, why don't they have any idea what a due process right is? Because when you're talking notification, you're talking due process rights. And maybe it's a good idea for these municipalities and these people holding these closed sessions to stop and think and say, hey, does this person have a right? Maybe they should start thinking. Maybe they should start talking to the municipal association and saying, hey, what is a person's due process right? Maybe they ought to be calling the lawyers and talking to them and finding out before they're holding these meetings. That's my point, and that's why I want this, at least settled somehow. I have no objection if you want to give a regardless clause, that's fine with me. But from your other objections to interfering with investigations and other statutes, isn't that still in effect here? So I'm just trying to protect my due process rights. And it all depends on the circumstances of the case in the Supreme Court and the New Hampshire Supreme Court, I should say U.S. and New Hampshire Supreme Courts, cannot really define it definitively. It all depends on the circumstances. One little change in the circumstance could change if you have a due process right. So, I mean, I would say I'm for this bill. It protects our due process rights, hopefully, and it'll get these people actually talking about what our rights are.
All right.
So, any
Thank
questions?
you. Questions for this witness? Seeing none, thank you very much, sir.
Thank you.
Next, Barrett Christina, please.
Thank you again, Chairman Lynn. Good afternoon, members of the committee, Bear Christina School Boards Association. Chairman Lynn, I know I put 3 minutes on my card. This is a complex issue. I may require a little bit more time at your discretion,
Yeah,
sir.
no, that's fine.
And second, I'm passing around a proposed amendment. I did email this to Representative Alexander yesterday. We have not had an opportunity. I have it. I'll check. I was going to say, I did not have, you don't have it. I was going to say, I did not have an opportunity to touch base with Representative Alexander regarding it. Second, I did check off support on my card. If that, I'm going to take no position on the bill because I think I may have been misconstruing what the purpose of the intent was, and there seems to be some confusion going around the bill, going around relative to the conversation. In trying to decipher the intent of the bill and some of the testimony of the people before me, I think the confusion hinges on whether or not an individual has a right to attend a meeting in non-public session simply by the mere fact that the public body is going to discuss that individual in the non-public session. NHSBA does not interpret 91A3 paragraph 2C to mean that just because you were talking about somebody's reputation, that individual has a right to attend the non-public session where you're talking about them. Related to that, it's important to understand the context when we're talking about school districts, and I know we have at least 2 school board members on this committee. When we're talking about student matters, we always use paragraph C, the reputation, and that may be a hearing. It may be simply the administration or the superintendent having to notify the school board that a student disciplinary matter may be coming up. And you may not always have time to provide notice or put that on the agenda. If the school board meeting is on Wednesday night, January 22nd at 6 p.m., and that student did something problematic at 3 p.m. that afternoon, and the police may have been called, there may have been, some sort of immediate suspension, something relative to the health, safety, and welfare of other students, that superintendent has an obligation to inform the school board that there was an incident at school, the police were called, we caught a student doing X, Y, and Z, whatever it might be. We always use paragraph C for student matters. Doesn't matter what the context is. So there was also some discussion, and I think NHSBA's interpretation that the fact that an individual is being discussed in a non-public session, and the fact that their reputation may be being discussed or come up does not give rise to a right to a hearing. I have, I copied off some pertinent provisions from, this is Sivalingham, Sivalingham v. Newton, 174, New Hampshire, 489, New Hampshire, 2021, New Hampshire Supreme Court, 2021. So here's the pertinent paragraph, if you'll indulge me. Indeed, we question to what extent Johnson has any precedential value, given that it was decided after the legislature amended the language in RSA 91-A:3, paragraph 2A, that we addressed in that opinion. Nevertheless, the legislature has not amended the statute to confer the broad rights of notice to the minority suggests that the, quote, reasoning of Johnson mandates. Here's the important aspect. Nor do we believe that this court, or the legislature for that matter, ever intended to impliedly confer such an expansive right to notice upon an even broader category of citizen, i.e. any person who might seek to prevent a public body from entering into a non-public session upon the assumption that the public body's discussions, quote, would likely adversely affect her reputation, RSA 91A:3, paragraph 2C. So the Supreme Court has said just because an individual's reputation may come up in a non-public session does not confer that right to that individual to attend the meeting. Circling that back around to my proposed amendment, I took language from RSA 91-A:3, paragraph 2A, which states, only the following matters shall be discussed or acted upon in non-public session. A, the dismissal, promotion, or compensation of any public employee, or the disciplining of such employee, or the investigation of any charges against him or her, unless the employee affected, 1, has a right to a meeting, and 2, requests that the meeting be open, in which case the request shall be granted. I copied that language and put it in a proposed amendment to Representative Alexander's bill. Now we have to ask the question, where does the right to a meeting come from? It can come from statute, it can come from employment contract, presumably a school board policy, or perhaps administrative law. So, but again, circling back around, the right to attend the meeting has to be conferred first. We have to ascertain where the source of that right is. In a student context, it would be through general due process. If a student is being disciplined, we have student discipline statutes across the hall in RSA 189, federal requirements relative to due notice and process, and a hearing before a school board relative to before a student is suspended for a certain number of days. So I think that's it. I hope I was clear. I'm happy to answer any questions that the committee may have.
Questions for this witness? So I guess I just have a couple of questions. So am I understanding that all of the things that you talked about, a contract right, policy, that kind of thing, would I be correct in understanding that most of the time, in fact, I guess I would say all of the time that I could think of, and maybe if you have other examples, that are different, please. Doesn't that kind of a right, let's say in a collective bargaining agreement, for example, don't they usually say that the right to be present or to sort of understand applies in the situation where the board is going to take some action?
Correct.
If the board is going to have a discussion, but they're not going to take any action, I guess I'm not aware of any circumstance where, where you would have, unless we decide to grant that, but I'm not aware of any circumstance right now where you would have the right to know that.
Correct, exactly, which is why we think that paragraph 2A of 91A:3, unless the affected employee has a right to a meeting, and that right to a meeting, the other conflict is that the right to know law uses the phrase meeting. We have always interpreted that to mean the individual doesn't necessarily have a right to a meeting, they have a right to a hearing, which is different to some degree. I have a right to attend a public meeting, and if it's a school board meeting, I have a right to engage in public comment through a statute a couple years ago, but I don't have any other specific right granted upon me to attend, other than attending a meeting under RSA 91A. And we often confuse the language in RSA 91A3. It's a non-public session. It is a session of a public meeting. But yet, for purposes that I don't know why this, this language in 91A3, the non-public session statute, ought a right to a meeting that predates my time at the School Boards Association. So I don't know what the legislative conversation was when this was initially drafted, however many years ago. But so, and the other rights in terms of the due process, this is not necessarily pertinent for this committee, but employee right under a collective bargaining agreement or RSA 189-14A, a teacher non-renewal or a teacher dismissal. There is a Department of Education rule, ED2, it's in the ED 200s that lays out what the specific due process requirements are. Notice, right to attend, documents, having to have a representative cross-examine, the typical due process rights.
All right. Other questions for this witness? Seeing none, thank you very much.
Thank
sir.
you.
Ms. Cohen.
Good afternoon. My name is Sarah Burke Cohen. I represent the New Hampshire Municipal Association. NHMA opposes HB 313. I'm not going to try to reiterate what Mr. Christina just said or the previous testimony. The Supreme Court decision, the Supreme Court found that RSA 91A:3 Roman numeral 2C does not require an individual to be given notice and a right to attend the non-public session in which a discussion may occur that may adversely affect the individual's reputation. I think that they realize, and I think it sounds like Representative Alexander also has realized that there are some practical implications of the change that's proposed. How does it work? Does business cease? I think there was a question about what if there's people that are intertwined? If someone wants to go to public session and someone doesn't, what does that look like? There's a lot of questions I think that are open with HB 313 as it is. We think it's not practical and would end up actually adversely affecting maybe someone's a reputation, and that's not what by virtue of if it's somebody else that ends up in an open meeting that doesn't want to be there. So NHMA, we oppose this bill, but we would urge a work session on it. It sounds like potentially maybe there could be some work that's done that makes it more palatable. I'm open to questions.
Questions for this witness? Seeing none, thank you very much. Is there anyone else here who wishes to be heard on HB 313? Seeing none, I'm going to close the hearing on HB 313, and lo and behold, we are actually a little ahead of schedule, so we have about 10 minutes before we can start the next
Mr. Chair,
hearing.
can
Yeah.
I now that the hearing's closed, I know that we have an executive session on this bill next Thursday. Would the chair be inclined on pushing that out a month so that we have some time to work on this and vote on it maybe beginning of March?
Yeah, no, that's
Okay,
I don't
and
have a
I'd be
problem.
happy to serve on a subcommittee if there's any other members that wish to serve with me.
No, I'm just wondering, are there other people that would be interested in serving on a subcommittee with
Representative Birch, you will get mileage if you come and serve on the subcommittee with me.
Representative Birch and Representative Tripp?
Perfect.
Great.
Thank you.
No, that's great. All right. So. Right. So I want to make a note to myself right now, Representative Alexander, that I make sure. Oh. recognize Representative Mazur. Thank you.
Hello, everyone. Good afternoon. Thank you, Mr. Chair and members of the committee. Again, my name is Lisa Mazer, and I represent Hillsborough District 44. I think this will be a pretty quick one for you, but we'll see. So HB 376 is a very simple bill that revises one of the exemptions in our right to know law to include, but not limit to, library cards and library membership status. You see, the term, quote, library users is already mentioned as being exempted in Section 4 of 91A:5. But apparently that term needs further clarification. This exemption amendment came about because of a situation that happened in our town almost a year ago today during our town's local election. The wife of our select board chair decided to file a right to know with our Goffstown Public Library, asking if the 6 candidates running for Library Board of Trustees held library cards. The library director consulted with our town lawyer. I did not mean to say that. Woo! Sorry. Oh boy, it's been a long day. Town lawyer, who in turn directed them to not only answer the question of whether or not the candidates held library cards, but to release the actual library cards via email to the person who filed the right to know. After that person who filed the right to know received the library cards from the library director via email, she proceeded to post the cards all over social media. The cards originally included their patron codes and other personal information. Apparently, the lawyer did not see the right to know exemption that says records pertaining to library user as referencing library cards. Many in our community agreed that this was an egregious invasion of privacy and should never happen again. Some, not all, of the Library Board of Trustee members were very unhappy this happened and said the law needed more clarity. So this is that. People with personal vendettas shouldn't be able to weaponize private library cards and children's private information. I ask you to pass this small but important bill revision so that this won't happen again to anyone. And I will take questions.
Questions for, yes, Representative Perez.
Were these individuals running for library trustee?
Yes.
All of them were?
All 6, yes.
We're all running for library trustee.
Yes.
Is it part of their charter, your library trustees, that you must be have a library card to run for that?
No.
Okay, thank you.
Other questions for this witness? So, I guess I have a question. You said that the library cards, and I don't live in your town, but I just want to see what my library card says. I
mean, the biggest thing on it is has the patron code on it. So it's a code that identifies, that's very specific to the person. And you can actually use that information. Yes.
So, I guess what I wanted to ask you is this. I completely agree. That's a huge concern of that. But is the mere fact that you have or do not have a library card something that you think should be protected?
Yes, and there is someone else who will testify as to why there are other reasons that library cards and membership status should not be a public thing that can be released just because someone asked for it. And it does set a horrible precedent. Even I mentioned it briefly at the end in regards to children. You know, what's to stop this person from digging even more into, let's say there's a family she didn't like and she wants to air in for like, where's the line drawn? So, but there's going to be someone else that's testifying as to,
Right. I guess the only thing I'm thinking is this: if you put aside the information on the card number and stuff that the code and all that, I mean, I'm just thinking. I mean, wouldn't it be particularly the example that was just given? If somebody is running for library trustee, wouldn't it be a legitimate political question for somebody to say, well, wait a minute, this person wants to be the library trustee, but the person doesn't even have a library card?
well, that's the thing though. That's up to you to decide, but they took that one step beyond. That was the original question, is if. I personally don't care if people know if I have one or not. Others do though. And the membership status situation is, again, there's domestic violence situations where that could become a real issue. If you have someone a person who abuses women, his wife, trying to find his wife and starts walking into towns and, this is the first place I'm going to go and see if they have a library card. Like it's no one, I don't see how it would be anyone's business, regardless of whether you're running for office or not, if you have a library card. That you could have one elsewhere, you could have one in another town. So that to me and many others in our town, like I am currently on the library board of trustees now. So, many of them were not happy that happened. So, but to go back, the original question from the person that asked in the right to know that she requested, asked if the people running had library cards. Okay. But then all of a sudden it became hey, not only do they have library cards, here they are. How did it go from asking the question if to, and here's all their library cards? It made no sense. And then, and the person that did that, there's just a lot of things like this that happen on a regular basis. And just to stop, as I mentioned, the weaponization of private information, that's going to prevent people from running for stuff in the future if they know that their privacy is going to be infringed on, and they're going to use it to go after people. I would never vote for someone whether or not they had a library card or not. To me, I want to know why they're running and what they're running for, and that's what I vote for. So, and I don't know that if that person has a library card, someone else, good for them. It's none of my business. So, yes.
Yes, Representative Petter now.
Thank you very much. This really isn't specific to the library card per se, but libraries are free, correct?
Yes.
So it would, in a situation where somebody is running for library trustee in particular, you might go to the library every day but not have a library card because you might sit and read the magazine, the periodicals.
I know many people that do that.
So yeah, you could be a regular patron. So the fact, in the particular situation where you're running for library trustee, it might not matter. Would you agree with that?
Might not matter.
It might not matter that you have a library card, like that you're a regular patron of the library even.
Exactly.
Representative Bergeron and then Representative Alexander.
Thank you, Chair. Mr. Chair. My kids got a library card when they could write. And at this point, they can probably still use that card, but let's say they were under 18, would I have to sort of take, because I always just sort of not took control. They had them all, but at one point in time, are kids' identities, are you suggesting that all of that be not available to the public?
I don't think someone should be able to, like, let's say my sister who has children, that someone could say, I want to see all the library cards of that person's children. They're not my, that, why would you want to do that? Number one. But this sets the precedent that they could. I mean, apparently the current law, but keep in mind, the current law does make a reference to records pertaining to library user. So why would library, their cards, which is part of, I would think, a person's library record, why would that not be part of the exemption? So, but apparently that's why I did this, is to bring clarity to the law, because I was told that the term library user was not good enough.
Follow up?
Yes, please.
I just wanted to ask about, I'm not going to ask you things about restrictions. How long does a card? I just wanted to know if my kids' cards are still good. But, no, but I guess at this point in time, I don't know. I'm just trying to protect them as well. I don't know if there's any protection measures for under 18, under 16.
No,
I don't know what.
No, that's all that you see in that law. And I have it, right here. There's no age limits on anything in the current law. It just says, and these records are exempted from right to know. Records pertaining to library user. That's all it says right now. Now, there is an RSA 201D:11, which references library users and records as well, and I have a separate bill on that. Just to kind of lock this up so that people's privacy. I'm just a huge proponent of privacy, and this to me just took it to a level that I and many others couldn't actually believe that person went to that level.
Other question, Representative Tripp.
Thank you for taking my question. Since the person that made the 91A request simply asked, do they have cards?
Mm-hmm.
So do you know who gave the cards numbers to that person?
Well, when the library cards were emailed to the person who filed the right to know, originally, like the numbers, do you mean patron codes?
Yeah.
They're right there on the cards.
So they were
the actual pictures of their cards.
Oh,
were emailed.
So the thing that I find annoying is that back in 9/11, they started researching people's library history to see if they were terrorists. Do you think that anything like that happened?
Now, there are other exceptions. So you can ask, let's say that person is under investigation for something, or a subpoena is filed, that information can be released. So that falls, outside of this particular section of the exemption. So there are situations where you can, if someone, like I said, is under investigation by the law or whatever, if they have a subpoena, they can access that information. So there are, but this wasn't that. We weren't under investigation for anything. So.
Oh, you were one of the people that had the card emailed to the requester?
Well, I was one of the people that didn't have a card.
Oh.
So, yeah, isn't that, yeah. And it didn't bother me at all, because I used to have a card. I let it go during a certain period of time. And that doesn't bother me at all. But it bothers a lot of other people. When this happened, there are a certain community. There's a community in our town that was really bothered by this overreach of privacy invasion. And number one, no library card releasing, and number two, it's none of your business if I have a library card or not. but I owned that fact proudly, but many others don't and don't want to. So that's up to that person, though. That is information and a status that belongs to that person, and there's no good reason why. It doesn't matter if you're running for library or not. And I still got elected. So, yeah. So it didn't matter to many people. Yeah.
Other question, Representative Alexander.
Thank you, Mr. Chair. Thank you so much to my state rep for taking my question. I am wondering, based on the interpretation of how the Goffstown Library interpreted RSA 91A5, specifically library user, could I take a list of all people in Goffstown that registered to vote and voted in November 5th, and then request a 91A on their library cards to see how many people that voted in November 5th have a library card?
100%.
Thank you. Thank you. It's very helpful.
There's no limits to what can be done with this right now. So, and that's what this is now, is just there's some things that, and you can see it's probably 10 words that I added to the amendment just to clarify that library user includes your library card and whether or not you have one.
Other questions? Yes, Representative Perez and then Representative Horgan.
If I'm running for budget committee in your town, do they check and see if I have a bank account? I mean, what was the rationale behind doing that? Just to be nasty? Is that how you feel it was? And you got elected even though you were one who did not have a card. It's interesting because this just came up at our library trustees, that they wanted to know which one of the trustees had a library card, and one of the trustees said that's nobody's business. So,
yep, agreed.
Representative Horgan.
This probably would a town be able to make a rule that library trustee candidates as a qualification had to be library card holders, and or make a rule that they get a library card if they don't already have one? Because was that
Sure.
yeah. So that would not be disallowed by the current law, or this law, you think?
Yeah.
Okay.
Yeah.
So I guess other questions. So I guess just to sort of carry this through, and I am sympathetic to the bill in the way the issues you raise, but I just to follow up on this. So if I'm running for library trustee, and I have an opponent, do you think that it would not be an appropriate question at a forum, for example, for a voter to say, "Hey, Lynn, you're running for library trustee. Do you have a library card at the library you're running for trustee of?"
Sure, they could do that, but then it's up to them to answer that question. Someone's not going to answer that for. I don't want anyone.
Sure, no, I
answering
understand,
that
but I
for
guess
me.
the point is that my point would be that it is relevant. It is a relevant question if I'm running for library trustee, whether I have a library card. It's not the end of the issue. It may not be. That doesn't mean if I don't have one,
This
I
is
shouldn't be
specific
elected.
to right to know requests. This isn't
Right.
just I'm attending a candidate's night and someone's asking me that question. This is specific to the right to know law, that, so if someone submits a right to know, and you can see, though, even though they asked for membership status, they took it well beyond that.
Right.
So that's why we're pushing the line further back to no, actually none of this is anyone's business. And if they want to ask them that private question or a public question in a different arena, that's up to them. And it's up to that candidate whether they want to answer that or not.
Sure.
No one should be making that decision for them.
All right. Other questions for this witness? Representative Predator.
Do you have any written testimony for the committee?
I can email what I have here to you.
That would be wonderful. Thank you. The clerk would appreciate that.
You better believe I can do that.
Thank you very much,
Okay.
Representative.
You're welcome.
All right, thank you.
Thank you.
So no more questions. Thank you. All right. I hope I'm Barbara Schultz. Is it Barbara or? Yeah. Okay. Thank you.
Can you turn on your mic, please?
Yeah. Oh, yeah. Thank you.
touch it?
Yeah, there you go.
Okay.
Thank you.
I'm Barbara Schultz, and I'm a voter in town in Goffstown. And the library is very important to me. I'm not super comfortable doing this kind of thing. I did have written testimony, but some of the things that were already discussed, I'm going to jump around and address it. I first want to tell you that I'm not a lawyer and I have no legal background. I did read a lot of the documentation around the events. Most of this is posted online, and not online like on Facebook, but on the town website and the library's website, the events surrounding the things that were discussed. And in that, you will see a legal opinion that very much explains some of the questions that were coming up. In my written testimony here, there will likely be discussion here about the actual card being revealed. The attorney, in his response to the library's request for legal counsel on the 91A request, said that it cannot be a yes or no question. The library is not able to say, yes, this person has a card, or no, this person doesn't have a card. They can only, the 91A is only for actual government records, and the actual government record is the card. Okay, so hopefully that will clear up some of the questions that came up. And again, this was one lawyer's opinion, and I'm not a lawyer, but I encourage you to read the full communication that is posted. It's a March 12th, 2024 press release from the town of Goffstown. It's posted on the town website as well as the library website. So hopefully that clears that up. I am not clear on what I heard about being able to access any information with a picture of my card. My card, the front of it just has the Goffstown Library logo. The back of it, yes, it has a number on it, but I have a PIN that goes with that. So I don't know how any information could be accessed with just that code that was revealed. I don't agree with whoever posted it on Facebook. I don't agree with that at all. But the library did comply with the law and sought legal counsel for that. And hopefully I'm not taking up too much time, but the purpose of the right to know is to provide transparency to the public about government agencies and their work. And the library, public libraries, are kind of unique in that they're run by a board of trustees. They're not run by the town. So they elect trustees. And as a voter, yes, that's very pertinent information to me, whether or not the person, the candidate, has a library card or not. And it really should be a very simple thing that someone just mentioned, like, can't we just ask the candidate? Well, yes, we can try that. But I do want you to know that 4 of the sponsors, all of the sponsors on this bill are from Goffstown, and only from Goffstown. And I would hope that would perhaps flag some caution on your behalf and perhaps do some deeper investigation. 4 of the sponsors of this bill had direct interactions over the past year and a half with the library specifically, including requesting the resignation of the board chair, openly and publicly stating that the library had broken the law when it had not. And most recently, 2 of the sponsors sued the library. And that brings me to the point of asking the question. Ross Berry and Keith Murphy sued the Goffstown Public Library because the library was providing a public service that they have done multiple times in printing a candidate brochure. They throw out questions to the candidates respond, they are printed on edited.
Mr. Chair, I'm unsure how this testimony has to relate to this specific bill.
I can get to that because the people decided not to answer the questions. They just didn't answer the questions. So going back to, shouldn't it be a simple matter of, does the trustee candidate have a library card? If they choose not to answer the question, there should be a way for the public to have that information that I think is very pertinent. In addition, the library is a public building, as it was addressed and mentioned, and anybody could sit in the library. And yeah, you might see someone reading magazines and don't know whether they have a card or not, but you will see people check out at the circulation desk and hand their card, and then a person can just sit there and keep track of who has a card. So the library card itself is not a privacy issue because you're in a public library and it's very public. So having the card is not the issue. Releasing information connected to the card, how you use the card, the materials you borrow, yeah, that's a whole different matter, but that was not revealed. And so I just caution you that asking for an exemption under this right to know law is a huge ask. And I hope that you will weigh it very carefully and consider all the perhaps unintended consequences that may fall from that, as well as, you know, a legal thing saying that you are denying government records. I'm a fierce advocate of privacy, but I don't feel this releasing whether someone has a card or not is a matter of privacy. It will open up subsequent legal questions. And I guess lastly, and getting to how this relates, you know, I find it troubling that Lisa Mazur in her candidacy for library trustee in our town emphasized the need to being transparent, bringing transparency to the library. And Mr. Berry...
But I really am not clear on how, you know, sort of getting into the details of a particular thing is relevant here.
Okay, I apologize. I just feel that they have pursued freedom of information requests, feeling that a lot of that information is public, including who submitted the questions on the candidate brochure, but yet they're sponsoring a bill that is trying to limit transparency by not allowing people to know who has a library card. And lastly, I think since Joe was directly involved in much of the above, I think he should recuse himself from the discussion of the vote on this bill before the committee.
All right. Any questions for this? Yes, Representative Alexander.
Thank you, Chairman Lynn, and thank you for taking my question. My question is regarding if you believe that the library card of victims of domestic violence, such as myself, should be disclosed to the public, and if that is a safety concern, is yes or no?
I'm not clear on the connection as to knowing whether you have a library card, how that could possibly connect to domestic violence, and forgive me if I'm not going there and I don't understand the connection.
Thank you.
Other questions for this witness? Yes, Representative Perez.
Are you aware that this is just a clarification of an existing law? The law says, I don't know the exact words, but the law basically says that you can't disclose library users. It's clarification, which is something that we frequently do. We had several bills this morning for clarification on citizen and different things. Are you aware that there is already a law that says this basically should not have been done, and this is a clarification of it?
Well, I don't know if it's clear that it shouldn't have been done because, and again, I'm not a lawyer, so I think the committee needs that legal opinion. The actual card is a government record, and under the Freedom of Information, that's available to the public. So I'm not a lawyer. I just read the legal opinion.
All right. Other questions? Seeing none, thank you very much. Next, Henry Grasso? I'm sorry? Dyson, okay.
Cool. Thank you, Mr. Chair, honorable representatives. For record, I'm Representative Henry Guyson, Goffstown, Hillsborough 29th District. I want to approach this from a safety and security standpoint. So I recognize that the law was applied the way the law was interpreted, and I'm not refuting anything that has already happened. I think that the importance of this law, which has been touched on once by Representative Alexander, once by Representative Mazur, is that this is the only government agency that I know of where I can do a right to request and I can figure out exactly where you are. I can't walk up to the DMV and request your driver's license. I can't go to the schools and request the names of the children going to those schools, but I can go to the library and I can find out whether or not you're a registered member of that library locally. Now, in a domestic violence circumstance where a partner, possibly with children, has relocated and does not want to be found by the offender, an offender could right to know, find out whether or not that family is registered in the library, possibly find out whether or not the kids are involved in any programs in that library. This is the only place where I know, other than that voting registration is public record, but this is the only place that I know where I can do a right to know, and I can find out exactly where a victim is, were somebody trying to find a victim. And that concerns me. I believe that people have an inherent right to privacy, and I believe that it's the government's job to protect the rights of the people. So from that perspective, I think that I would hope that this body would move to OTP this on the grounds of protecting the citizens from errant right to know requests. Pending any questions, I'll conclude.
Thank you, sir. Questions for this witness? Seeing none, thank you very much.
Good job.
Catherine Coco.
Thank you, Mr. Chair. Right to Know New Hampshire supports this bill. I will say that we met as an organization. We were hard pressed to find a single example where personally identifiable information was of this kind was of interest, and we feel that the bill is a clarifying bill. It addresses something that we believed was already the case. I will also add that I took a quick look. I'm a book nerd, so I jumped on the American Library Association website. I would encourage committee members to go ahead and look at their stance on privacy and libraries. It's quite powerful. And I would also state that from a right to know perspective, I find it very interesting that, and I'm hearing about this for the first time here, so if I have this incorrect, I apologize, but it sounds like somebody issued a set of questions, and rather than the typical response from a community, which is, under 91A, we are not required to respond to questions, somebody chose to go ahead, pull records, and furnish those. That is unusual in my experience. Typically, they will come back and say, we can't answer a question, you have to ask for a specific document. It does not sound like that happened in this case. It sounds like this was clearly motivated by something else, and I find that very interesting. It's unusual. Thank you.
Wait, hang on. Questions for this witness? Anybody have questions? All right,
I'm happy
nobody.
to take
Nobody
questions.
does.
Sorry.
Nobody does. Thank you very much. All right. Is there anyone else who wishes to testify on House Bill 376? Seeing none, I'm going to close the hearing on House Bill 376, and the committee will be very happy to know we are on to the last bill that we have assigned for hearing today, which is 273. Fine. House Bill 273. And where's the... Okay, wait a minute. Yeah. Representative, did you fill out a
Oh,
card?
no, I
Can I
didn't.
ask you to do that if you wouldn't mind, please?
Want to do an hour after?
Yeah, no, you know what, as long as you just take a card and fill it out after, you can testify first, but just take the card and fill it out afterwards. Hi.
Good to go?
Good afternoon. Yes, you're good to go.
Thank you, Mr. Chairman, members of the committee. My name is Mike Drago. I represent the town of Raymond, and I am going to introduce HB 273, which gives parents access to their child's library records. Right off the bat, if this bill is passed, it gives two real-world implications, makes it easier for parents and I think for libraries in general. One issue I actually ran into probably 14 months ago, I requested, well, my daughter was reading a chapter book series on horses, and the next book in the series was out, so I had requested that book for her. And at the same time, I was reading a World War II book. Basically, the author interviewed many different veterans about their experience during combat, and they put it all into one book. So I requested that book at the same time. A couple weeks went by, and our librarian emailed me saying, one of your two books you requested is in. I said, oh, great. Which book is it? I was excited to start reading my book. And she said, well, I can't tell you that. It's against the law. I didn't realize that I had accidentally requested both books under my daughter's library card. And because it was under her card, I had no access to what books were requested. She couldn't tell me. I thought that was kind of odd, but under current law, that is how the law is written. And so then on top of that, I started thinking, well, our library charges late charges for any book that's overdue. If my daughter happens to turn in a library card late, a library book late, she has no source of income. I'm the one responsible for paying for it. How does it make sense that I am paying for a book that I have no access to, I can't be told anything about, but I am responsible for? And if you take it a step further, if that book accidentally gets lost, I have to either find it or I have to buy it. Again, I'm buying a book that I can't know anything about. Or two, I'm trying to find a book that I have no idea what I'm looking for because I can't be told what to find. I'm on a wild goose chase in my house trying to find a book. So those are two real world implications. But we can also talk about the elephant in the room, and that is the explicit material that's contained in books, and those books are becoming more and more prevalent in our libraries. And so I approached this subject with our librarian, and the issue is, well, let's go with this. We all remember, we're all the age where we remember movie rental stores, the Blockbusters, etc. And I remember my local one when I walk in the door to the left, were the G movies, the PG movies were to the right. Out by the counter were the R movies, and behind the screen out back, those were the X-rated movies. We all knew the separation between them, and you went to the appropriate area. Books don't have a rating system, so they're just interspersed all through the library. And why this is important is because the American Library Association gives a lot of, I would say, governance, or allows libraries to follow certain rules. And one of the things they put out was what's called the Library Bill of Rights. And part of the Bill of Rights says any person of any age should be able to read any book. So any person, any age, any book. In New Hampshire, children at the age of 6 get library cards, sometimes at the age of 5. Going by the Bill of Rights that I would say most, if not all, libraries follow, gives any person in the library the ability to look at any book. And now we know the types of books that are being bought for our libraries. And so I approached this with our librarian, and I brought up the book Genderqueer, which has kind of become famous over the past few years. And I said, our job, if this is going to be in the library, is to protect kids. And not every kid should be exposed to the material that's in these books, and this one specifically. And her response, for the most part, was, if a child looks at this book and they want it, I think I'm protecting them by giving it to them. And so I fundamentally disagree with that. I think it's up to the parents to decide if the book is right for a child. And by giving them access to see what the child is reading, it gives them one more tool to, make sure that they are seeing what they deem is appropriate. And, some of the people that would argue against this bill will say, well, it's the responsibility of the parent to pay attention to their child at all times. And I don't disagree. I try as hard as I can to always know what my kids are doing, try to take care of them the right way. But I do have 5 kids. So when we go to the library, one kid might be downstairs in the children's section. One might be upstairs trying to get a movie. So at any time, they could technically take out a book, and I won't know anything about it. And if I ask, I can't be told. And on top of that, my library, and I think probably most libraries, have after-school programs, which I think are great. They have a chess club, or they have teen tween book club, or Dungeons and Dragons. Well, these clubs are meant, they have a chaperone who runs the club, or maybe it's one of the librarians, but they're meant for peer-to-peer interaction. And the parent, the kids might bike there after school, or the kids will just drop them off. The parents will drop them off. They're not meant for parents to be there. It's for them to be with their friends and enjoy the club. So there's plenty of times in libraries when kids are not with their parents. And at the end of the day, it's up to the parents to know, or be able to understand what the kids are reading and what they're taking out of the library. And this bill gives them that ability.
All right. Thank you. Questions for this witness? Representative Perez.
Thank you. Thanks for taking my question. Are you aware that there are age restrictions, you said, on movies, games, also have age restrictions. Games that you can play and buy, and Dungeons, all those games. There are also age restrictions. TV has age restrictions on it, and magazines have age restrictions on them. Are you aware that all those have age restrictions, yet we do not have them on books in the library?
Yes, I am, and I don't know why we don't have them for books in libraries. I also don't know if that would be a state or a federal thing, but yes, I often wonder that.
Follow up?
Follow up, yes.
Are you aware that the New Hampshire State Library has withdrawn from the American Library Association because of some of their unique, I don't know the word I want to say, things that have gone on with them? Are you aware that the state library has withdrawn their membership with them?
Yeah, thank you for the question. I am well aware. The American Library Association, for lack of better words, is a political action committee funded by your taxpayer dollars. So last year, myself and Representative, who's actually sitting in the audience, met with the commissioner over the libraries, and we addressed our concerns. And yes, the state is now not part of the American Library Association.
And many towns are no longer part of it as well.
That I can't answer. It's very hard on their website to find out who and who isn't a part of the ALA. I would hope by seeing the state library cut ties, towns would follow suit, but that's up to the individual library trustee boards and individual librarians, and it's tough to tell what each one does.
One more quick question, please.
Sure.
Wasn't this partially and specifically done for the protection of children?
I'm sorry. What wasn't what done?
Yeah.
Approaching the American libraries, the state about the American library, wasn't that one of your issues with it?
Yeah. So as I started looking into this, I mean, I've had issues with them for quite some time, but as I started looking into this, preparing for the meeting last year, the American Library Association has a bunch of subgroups. I kind of call them shell companies, and one of them is every library, which actually one of the directors, the board of directors, actually used to be on the American Library Association board. And basically their purpose is to further the will of the American Library Association. So as I started looking at that group, last year, I forget the bill number, but it was one Representative Cordelli read excerpt from the book on the House floor. They opposed that bill. So yes, this is a way, trying to get the ALA out of the state was a way to protect kids, because they were actively arguing against bills that that I would say would protect kids by not exposing them to this material.
All right. Yes, Representative Rombo.
Thank you, Mr. Chairman, and thank you for taking my question. I see the proposed language says that these records would be available to the parent or legal guardian when requested by the parent or legal guardian whose address matches that on the minor's library account. Does this take into account if there's a disagreement between parents, if there's a non-custodial parent, if there are circumstances, legal circumstances that would prevent one parent from making that decision over another parent?
The way it was written like that is because of problems in the past where actually kind of like the last bill, if there's violence in the family. So it's the parent that has the same address, the ones living with, to make sure that maybe it's not an estranged spouse or something that is trying to catch up on their kids.
I have a follow-up.
Yep.
To the extent there's concern about safety or security of children in a circumstances like that, which we touched on in the prior hearing, expressing our concern for physical safety, right, for folks with a library card or a library patron, and our prioritizing of privacy. Many libraries allow children to be dropped off, like you said, for after school activities, things like that, where they're not checking out books, right? That they may not be taking them out on an account. How does that square with this proposal in terms of librarians being expected to share with parents the materials that their children are consuming at the library or monitoring their children?
It's not the stuff that they're doing while they're in there, it's the books that they're taking out.
What? Oh, okay. Checking out versus reading while in the library?
Correct. Yeah, there's no way a librarian could be the police of everybody that's in the library. It's the ones that they are actively taking out and taking home with them.
Okay. Thank you.
Other questions, Representative Horgan?
Yes, thank you. So, well, as we pointed out, most libraries have open stacks, so anyone, including a child, can basically read anything that's in the collection, unless it's in a special part of the collection. So I don't know, but I guess, so my first question is, you're not favoring like eliminating having open stacks at public libraries. So, because you're obviously very concerned about, especially probably presumably adolescents reading material that you think issues that you don't want them to be reading about. So you're not asking us to ban open stacks in public libraries.
Oh no, this bill has nothing to do with that. It just simply says that if the parent whose address matches the child's requests to see what books the child has taken out, they're allowed to see that.
I'll just follow up.
Go ahead.
Yeah, a related issue with common practice in many libraries is to make at least some of the books that are in the building available for people, including young people, to take home for free. Sometimes it's just books that have been culled from the collection, but sometimes it's also books on topics that they feel users, especially even like minor users, might want to read about this stuff, but for whatever reason they might be reluctant to go up to the library counter and be recorded as checking it out. So you think should libraries be able to continue those two practices of giving away or selling cold books and also making certain materials available for free without need to check them out?
Are they giving them away for free? I don't mean to ask a question, but are they giving them away for free and not intending to get them back? Like free, like take them home and don't bring them back?
I think it's on the, I think some of these materials are on the honor system, so they feel, probably these are not the more expensive materials that are being put out there, but and of course,
What's the question again?
Oh, I was just responding to the question. So like, but I was, because I think I was just not sure if his understanding might understand the issue, and perhaps I didn't phrase the issue very clearly. But so do you think we should restrict libraries from allowing minors to take anything home for free, even from those type of shelves that don't actually have to be checked out, although they probably most cases bring back, and or like allowing children to participate in, taking home cold books for free or buying books at the library book sale? So you think we should restrict that or not?
Well, that really has nothing to do with this bill. But I will say, if a library is allowing people to take out books without any sort of record, I don't think that's a good use of taxpayer dollars, because there's no guarantee you're going to get back, and taxpayer dollars bought those books. So there should be some way of making sure those books come back.
All right. Other questions for this word? Yes, Representative Bergeron.
Thank you, Mr. Chair. I know that we just made some changes to things like libraries, but we realize that kids sometimes don't want their families to know what they're reading, simply because, like for example, students that, so if they express different information when they're at school, we decided, we're not going to tell parents if it's a serious issue like that. Like if they don't want to know they don't want their parents to know, that type of thing. So I'm just wondering how that goes with this law right here, with parents can just go, and I guess not that you know everything about it, but that's just my one concern for this, is simply that if the parents still go and check out the books that their kids are having. But I know that's a different story, but also we just went in the right direction and just said.
I'm sorry, is there a question? What?
Yeah, I asked my question already. I'm just trying to explain what theater and what it looks like when I would go there. So in other words, they might want privacy when they go to the airport to the library when they discuss it with their parents. So.
I still don't know what the question is.
Representative, I guess we really generally ask that you made a statement, and your statement may be, I understand your concern, but we're here.
No, yeah, okay.
All right, other questions? Representative Rambo.
Thank you, Mr. Chair. I do have one more question. Thank you for taking my question. If I understand correctly, under RSA 201-D11, that it would apply to school libraries and public libraries, right? This all falls under the same umbrella?
Correct.
Okay. Are you aware of any conflicts that would create with other school privacy statutory rights for students in schools versus the town library?
I don't. There might be somebody else expert in that area that might be able to answer that.
Okay, that's right. Thank you.
Other question, Representative Tripp.
I don't know. Did you ask about school libraries?
My quick research was suggesting that this would apply to both school libraries and public libraries.
All right, thank you.
But I'm seeing some head shaking, so that may be up for clarification.
No, but would you be open to amendment that would include school libraries in your bill?
I think the intent of the bill is for both. So, it's libraries in
So
general.
the answer is yes.
Yes.
Okay, thank you.
All right, other questions for this witness? Seeing none, thank you very much.
Thank you.
Next, I'm going to call on Representative Catherine Harvey, please.
Thank you, Mr. Chair. Good afternoon, committee. My name is Representative Catherine Harvey. I'm from Cheshire 6, and that means I represent Hinsdale, Chesterfield, and Westmoreland. I'm also the vice chair of New Hampshire Library Trustees Association, and I chair its education committee. I'm here today to speak on behalf of NHLTA in opposition to House Bill 273. We see that there's two problems with this bill, and you've touched on one of them briefly, and that is the wording that the address matches that of the minor. That's problematic because the person who is making that request is going to have to somehow prove to that circulation desk that they actually live at the address that they say they live at. My driver's license does not have my address on it because I get my mail at a post office box. You could not make a request over the phone because the address has to be verified in some way. If the address of the person can be verified, and that's going to have to be decided how it can be verified, there's no way that you know that the children live at that same address. Today's children live with aunts, they live with grandparents, they live in foster homes, they live with boyfriends, they're even homeless. So it's not safe and it's not reasonable to assume that all of today's children live at the same address as whatever that parent or legal guardian is presenting to the circulation desk. And there is no way that the staff at that circulation desk can ascertain whether that information is true or not. The second problem with this bill is that most of our small rural libraries are not automated. So when you check out a book, they're checked out the old-fashioned way. You probably remember the cards and the date stamps, and then the cards are filed by the date that the book is due, not by the person who took out the book. So if I want to request what book someone has out, a staff person is manually going to have to go through 3 to 4 weeks worth of cards as well as the overdue cards to see what books that person has taken out. And then they're going to have to cross-reference that number with the address to see if it is indeed the person that's standing in front of their circulation desk. Now, if a library is automated, that process might be a little quicker. But again, you don't check books out by your name. This is my library card. It just has a barcode on it. So again, somebody would have to cross-reference my barcode to see if it matches the address that I'm presenting at the circulation desk. If that can all be accomplished in all of New England libraries except Vermont, history of the books that you've taken out are deleted when the book comes back in. Vermont deletes history after age 12. So if you go to the computer, the only books that it's going to show that are out of the library are the ones that are actually out of the library right then. It's not going to show you the history of the usage of that person. So if you pass this bill, there are significant costs that are going to be downshifted to the local library and the local taxes. First, if your library is not automated, then you're going to be paying for man hours of somebody going through those boxes of date cards to see who has taken out what books. And that's expensive. If your library is automated, you're going to have to upgrade your systems if you can. Some of our libraries are automated, but we're automated with antiquated computer systems, and you may not be able to upgrade them. You may have to just purchase new computers. You're going to have to write new policies about how this information is going to be shared. Policies are usually given a once-over by an attorney just to make sure that they pass muster. So you're going to be paying for that as well. And the possibility of all of this happening within 60 days after the passage of this bill, if it should pass, is really quite slim. So in addition to the address, the costs, and the time that it just cannot be done in 60 days, I would ask you to ITL this bill. I would, if I could, address just one issue, and I understand I'm talking from my personal library, but the idea was brought up that you might be paying for a book that you don't know that your child has taken out. Libraries issue cards to children, but those cards are linked to an adult card up until a certain age. And the reason they're linked is just for that reason. If a 5-year-old loses a book, then it would be up to the adult whose card is linked to his to be able to pay for that book. Most libraries have a policy that states something like that, and they decide what age cards are not going to be linked to adult cards any longer. Any questions?
Thank you. Questions for this witness? Representative Burton? I don't know. I'm sorry. I don't know. Apologize.
Thank you, Chairman Lynn, and thank you for taking my question. What is the maximum age that a card would be linked to a parent's, that a minor's library card would be linked to a parent's library card?
That's a policy that each and every library writes separately and with their board of trustees. The board of trustees' major job is to write policy, and that would be their decision to make. So I don't know that there is no age appropriate by, there's no state level age is what I'm trying to say. It's an individual library's decision.
Follow up, sure.
Thank you. Who informs the policy of each of these libraries, or are they creating policy of their own accord?
I'm not sure I totally understand the question, but once library trustees write a policy, and NHLTA has a list of recommended policies that every library should have, but once a library writes a policy, it is posted, if they have a website, it's posted on their website for anyone to see it. If they don't, there is certainly a policy manual in every library that you can see. These policy manuals are passed out. I was a trustee chair, and I made sure that all of my members of the trustees got a manual, as well as the friends and so forth. Is that the question? Yeah.
Sure, go ahead.
Thank you. If we have a state library association, what is their job? Do they inform the libraries and the municipalities of how to create their policy? Or for example, the school board association informs policy for the school boards. Is there an organization like that that informs the policy of the library, the individual libraries?
So I'm here representing New Hampshire Library Trustees Association, and that association it does not have a definite jurisdiction over local libraries, but we present all kinds of. We have a manual of things that librarians and trustees should know concerning like duties and that kind of thing. We also are an education organization, so we present workshops. Our conference is coming up May 5th. We have regional workshops that local trustees can attend to ask questions and to meet with other trustees. But we don't go into a library and say, this is how you write your policy. We do have a list of recommended policies, suggest like circulation policy, overdue policies, that kind of thing.
I think I assume the question, I think what she was getting at is, do you, among those recommended policies, is there one that says this is the, up to this age, parents should know?
No, the recommendation is simply you should have this policy, but it is up to every individual library to set that, because NHLTA doesn't know your community.
Okay, all right. Representative Mannion.
Thank you, Mr. Chair. Thank you for taking my question. You mentioned parents are linked, cards are linked, depending on what age, it's 5, 6, 7, 8, the library determines that. So if they notify the parent that the book is missing, and that's why the card is linked, do they notify the parent what the book is?
Yes.
Okay, thank you.
Other questions? Yes, Representative Birch.
Thank you, Mr. Chair. Thank you, Representative. Leaving out the practical implementation problems that you've talked about in this legislation, would it be fair to say that your organization believes that the purpose of libraries is to encourage people to read?
Well, of course, it's the purpose of any library to encourage people to read.
Thank you.
Yes.
All right. Any other questions? Yes, Representative Horgan.
Representative Harvey, would it be fair to attach one of our favorite labels to this bill based on the comments you made about the expense of complying with it, which is unfunded mandate?
Oh, the cost is definitely an unfounded mandate. The hours of searching, when you take out a book by a barcode or by a date stamp, the hours of cross-referencing is just astronomical. Not to mention if equipment has to be upgraded and so forth. Yes, and to do it in 60 days is yes.
Other questions for this witness? Seeing none, thank you very much. Aubrey Friedman, please. And you know what, we have a number of other witnesses, and given the hour, I'm going to ask if you would please, Mr. Friedman, try to limit your testimony to 3 minutes, if you would, please.
Right.
Thank you.
Mr. Chairman, committee members, Aubrey Friedman, I live in Bridgewater. I speak in support of this bill. I didn't even realize that, how this was kind of secretive, that somebody as young as 5 could get a card and the parents don't even have access to that. That to me is ridiculous. And it's your job as a parent to kind of know. I mean, when they're older, it's a little different. You can kind of let go. But certainly when they're young, you kind of want to know what information they're accessing. I mean, this is a busy world. There's tons of stuff out there. There's bad stuff. And as a parent, that's your job to, hate to say, but you're kind of a dictator of your kids while they're young. And so you should be able to access what books they're reading, or maybe they've lost or whatever. You should have total access. And for library personnel to kind of hide this from parents or say, well, we can't, like you're a doctor, like it's a confidentiality with your psychiatrist. This is ridiculous. We're talking kids here. So I totally support this. And also, the only thing I would say maybe could be a little better in this bill is there are no teeth in this. This is one of the library personnel, they don't really agree with that. And they say the parent, like you say, somebody or, kids should let them learn whatever we want them to read. We should not hamstring them at all. And so I'm kind of going to ignore that. And what if they do? Just disregard the law. So there should be a penalty. It doesn't have to be a huge one, but bills that don't have penalties on government officials and employees, they're often ignored. So I think there should be a little penalty in here if they disregard the law. And that would be my only suggestion for an amendment. Otherwise, I agree with it.
All right.
Thank you.
Thank you, sir. Questions for this witness? Seeing none, thank you.
Thank you.
Next, Chris Urschel.
Thank you, Chair. Thank you, members of the committee. My name is Chris Urschel, and I'm an attorney with GLBTQ Legal Advocates and Defenders. I'm a New Hampshire licensed attorney, but I work out of Boston. I'm going to focus in on a narrow issue, which is the reasonable expectation of privacy that even young people have when it comes to sexual orientation and gender identity. Young people look to books to help with the process of self-discovery, looking to see representations of people who have gone through similar experiences as them, who move through the world in similar ways as them. And for LGBTQ young people, it can be incredibly important to have access to novels, nonfiction books that reflect who they are as they're coming to understand how they identify. It can be extremely harmful to take away from a young person the right to decide when and how they tell their parents about their sexual orientation or their gender identity. Young people can be subject to great harm if they are not in control of that process. And there are plenty of examples of horrible things befalling young people who's had that choice taken away from them. I want to call attention to a story from the late 1990s in Pennsylvania in a small town where two young men were caught by a police officer in a car at night. The two young men were out at night in a way that they shouldn't have been, and the police officer had every right to stop them, tell them to go home, and he did. But before he did, he took them to the police station and he threatened them and he told them, "I'm going to talk to your families." That night, one of the young men, Marcus Wayman, took his life.
Mr. Chair, I'm confused at how that story is relevant to the testimony on library information. So I just, point of clarification, I hope that the witness will stay to the matter of the bill.
You may continue, but I just say I had indicated 3 minutes, and you're getting clear. You've got about 45 seconds left. So,
okay. So to answer the question, the government disclosure of private information is at issue in the events I was just describing, and it's at issue when we talk about public or school libraries disclosing information to parents about what books have been read by students. In both examples, we're talking about information that might be very personal, very private to a young person, say a 16-year-old, and that information, when it's disclosed, can result in great harm. And courts have found that there's a reasonable expectation of privacy, even for minors, when it comes to information about sexual orientation and gender identity.
all right. Any questions for this witness? Seeing none, thank you very much, sir.
Thank you.
Anne Marie Banfield, please.
Good afternoon. I'll try to make this quick too. I'm going to cut out some of what I was going to say. So I'm a parental rights advocate focused on excellence in education in New Hampshire. Anytime a parent can stand in the way of exploiting children, that's a good thing. So I do support this bill. I can access a book called Explosives and Homemade Bombs, written by Joseph Stoffel. The book offers the student of police and fire science a guide to such devices. A book like this for professionals may be necessary. A book like this in the hands of a deranged student could be harmful or even deadly. These books are there are books on how to make fentanyl or other harmful content. I'm going to assume you would want a parent to access their child's library records if they suspect their child is reading these books. If a book like this is in the hands of a deranged child, this could be deadly. What if a child is suicidal? Wouldn't you want to know if your child is accessing books that show them how to kill themselves? This could be an indicator that their child is in need of help. In the FERPA law, which is a student privacy law that governs schools, there is a parent's right to review their child's records. I had no idea that you couldn't even access this. I mean, I didn't even know about this. And I'm thinking, you got to be kidding me. What is going on? Why is there such a drive to come between a child and a parent? This is going to impact very few people. I never checked my child's records. Most people don't. But you know what? If I found out my kid's looking at bomb making stuff, I might want to go look. I mean, it just makes sense. And you know what? It could be helpful. Parents also don't have to do this. They don't have to do this. Most parents are not going to do it. So the relatively few people that do, I'm going to guess that there's probably a really good reason. My son could read Harry Potter books. His best friend couldn't. When he came to my house, I didn't hand him a Harry Potter book. I respected that parent. I respected them. Let's show some respect to parents and stop trying to undermine them by trying to keep them hidden from everything that's going on in their child's life. Thank you for listening.
Questions for this witness? Seeing none, thank you very much. Nancy Biederman, please. I hope I'm pronouncing that correctly.
All right. I am just going to do bullet points. First of all, we won't talk about how old I am, but it was the days when we didn't have computers at the library, and the librarians had no trouble keeping track of what books I had taken out and what books I didn't take out, and they knew exactly how much money to charge me if I didn't bring a book on time. So record keeping, they could do it back in the 80s and the 70s, and we're not going to go any further than that. So did we lose that skill in libraries? I don't know why. So you don't need to have a computer to do it because they could do it back then, and believe me, they charged fines back then. As far as your address and not being on your license, you should have your physical address on your license because you need that when you go to vote. Because when you register to vote, you need to have your address matching. Otherwise, you are going to have difficulty voting. You're not going to be stopped from voting, but you're going to have some difficulty when you go to vote. Schools do not allow parents access to their child's library books, so I ask that schools be included on this and not to assume that people will generalize that. Sometimes you need to put specifics. And the expectation of privacy on school property, books are school property, and government property are the books in the public libraries. And we already know that student lockers there's no expectation of privacy. So the expectation of privacy argument doesn't work. All right, that's it. Thank you.
Hang on. Questions for this witness?
Any questions?
Seeing none, thank you. Awesome. Rebecca Leake, please.
Good afternoon, Chairman Lynn and members of the committee. My name is Rebecca Leake and I live in Andover. I am testifying in favor of HB 273. I believe this bill is common sense. A parent has the right and responsibility to oversee what media their child is consuming. This is especially important so that parents can determine the appropriateness of that material for their minor child. Furthermore, this bill is very narrow, only applying to the current records kept of what media the child checks out. As someone who looks forward to someday taking my future children to the library, I would expect to have access to the records kept of what my child has checked out, whether this is simply so that I can find an overdue book or so that I can ensure what my child is reading or watching is appropriate for their age. Moreover, as someone who was a minor not too long ago, I fully expected that my parents had access to the records kept of what I had checked out. Therefore, I urge you to recommend that HB 273 ought to pass. Thank you for considering my testimony. I welcome any questions.
Questions for this witness? Seeing none, thank you very much,
Thank
ma'am. Arlene Torrentello? Yeah, sorry if I've destroyed that, I apologize.
Just say Q. Thank you, Chairman Lynn and members of the Judiciary Committee. It's nice to see familiar faces and be back here. For the record, my name is Arlene Quartiello, and I represented Atkinson in the legislature last term, and I was actually the one who introduced this bill originally. We made some changes to address the counter arguments that had been brought up about the money and about the address. Most parents I have spoken to are shocked. That's the general reaction, to learn of the state law that prohibits them from knowing what books their kids have checked out. They weren't aware that when they took their children to the library for that great American rite of passage, signing up for a library card, that they were also signing away what they should consider a parental right. They didn't know that they might someday go to the library and be asked to pay an overdue fine on a book, but illogically, that they were not allowed to know the title of the book. Who not only pays overdue fines, but as taxpayers actually pays for library material and provides the funds to run school and public libraries? Parents. In numerous library policies I checked, I got numerous, I just stopped looking, they were so numerous. Who is held financially responsible for any lost or damaged materials checked out by minors? Their parents. Library policies, not state law, but most library policies say that. According to the American Library Association, whose role, this is a quote, role is to monitor his or her child's individual reading life? Parents. How can parents possibly fulfill this role if they can't find out what books their children have checked out? Now, to address the two counter arguments, one is the money. This is not an unfunded mandate. This will cost nothing. There is no historical component to this. It is currently checked out. Every library has these records, even if they're not automated. I believe that, with all due respect, that a previous witness really made a very complicated description of how this might work out. So, as another witness said in the 70s, or whatever, when I was a kid, they did just fine without the computers. The other issue was the driver's license. And this was to address the safety concern involving non-custodial parents. A driver's license would be the best proof of the address. There must be some proof of that address. A child, their account should have the address that they're currently at. If it's changed, they should change it. They shouldn't have a library account that has the wrong address on it. And a parent usually accompanies a minor to get a library card, and at that time, they have to show a driver's license. I was a librarian. I've seen the nuts and bolts of how this works. One other counter argument.
You're at your 3-minute limit. So
okay, I was hoping on 5, but if I can't say it in 3, then it probably doesn't need to be said. So yes, please vote OTP on HB 273, and thank you for this opportunity.
Thank you. Question, Representative Mannion.
Thank you, Mr. Chair. Quick question. So, and this is your opinion, if more parents knew that they were not entitled to this information, do you think more parents would not bring their children in for library cards?
I think that what they would do is they would just check all the books out on their own cards, and they wouldn't let their children get library cards. And that would be a shame, because getting a library card is really, I said it in here, it's a rite of passage. If you ever saw Arthur and the Aardvark, and he's saying having fun isn't hard if you have a library card, and to deprive a child of that. But what a lot of parents will do, and I've spoken to some of them, is they'll just put the books on their own card and not have the child get a card, not expose them to that, taking their right away.
Other questions for this witness? Seeing none, thank you very much, man. Appreciate it.
Yep.
Gilles Bissonnette. I know Mr. Bissonnette was here. Pardon? Okay, if,
We've written testimony, I think it was jointly written by Mr. Bissonnette
Okay,
and Mr.
all right.
Urschel is here, but,
Well,
but he did hand in a pink card, so.
he did hand in a pink card. Has he responded? Well, if he's provided written testimony, I'm gonna, given the hour, I'm gonna close the.
He said he's on his way
All right. He's the last one, yeah. No, don't worry. Thank you for coming back. Yeah. I did not. No, I didn't. I mean, no, I don't. I mean, I don't have a physical copy of it. I have the one online, but I think it's been published by now. I think. There's no.
Mr. Chairman, how are you?
Good. You know what?
I'm so sorry for the
No
delay.
problem. But just, I'd ask you to please keep your remarks to 3 minutes.
I'll keep it less
All
than
right,
that,
great.
if that's okay. And I apologize for being late. I'm trying to be in two places at once today. I don't want to repeat the testimony of Attorney Urschel, but just to reiterate, I'm Gilles Bissonnette. I'm the legal director of the ACLU of New Hampshire, and we are here in opposition as well, along with GLAD, to HB 273. With respect to the unfunded mandate concerns that I have heard, those certainly came up last year as well, and I also think formed the basis for then the Children and Family Law Committee to reject this legislation. So I want to just kind of uplift those concerns because they certainly, I thought, were persuasive last year and continue to be persuasive. One obvious correction to that, if this committee as well has those concerns, would be to limit this bill's application to only information that is accessible to the library at the time a parental request is made. That potentially could alleviate the concerns, but I do agree that as written, the shall be available language, I think, could very plausibly be read to mean libraries have to keep and retain all that information, even if it's not information that they routinely keep under their document and electronic management policy. So I just wanted to uplift that if that continues to be, if that is a concern of this committee. And lastly, I just did want to highlight that certainly understand the concern that maybe a parent would have that they would want to have access to this information and they can't get access to this information. One, I think, solution to that, right, is for a parent to not is for a parent to make sure that their child, when they get books, are using the parent's library card, right? And that parent would then have access to all of that information. So I think that is a much more narrowly tailored approach that parents can take in the home rather than enacting a bill like this, which I do think has privacy implications for the reasons that Attorney Urschel mentioned earlier today.
Questions for this witness? Representative Smith.
Thank you. Is there a definition of of age? What is meant when you use the word child in New Hampshire law?
Well, it's I mean, here this would apply to a minor's record. So my interpretation would be that would apply to anyone that's under the age of 18. That's my interpretation of it.
But it's because of the use of the word minor, not the use of the word child.
Yes, Representative. Yeah.
Thank you.
Yeah.
The questions, Representative Paterno.
Thank you, Chairman Lynn, and thank you for taking my question. I believe you suggested that a child be allowed to use a parent's library card if the parent wanted to make sure that they knew what the child was checking out. Would that not be burdensome to the library also, in that they probably would need to receive permission from the parent that this child was allowed to check out books on their card? I mean, what if they just walked in and said, "Yeah, my mom says it's okay"? Then wouldn't they have to follow up with the parent and determine whether or not they were permitted to do that?
I don't think so. I think if a child has their parent's library card, I think it's a pretty safe inference to believe that that child has permission to access those books. And of course, in that scenario, when the books are given, if they are given, and I hope they would, if they're given to that minor, that parent would then have the ability through that account to be tracking the information that that minor is obtaining.
Representative Bergeron.
Thank you, Mr. Chair.
Thank you.
Like I was saying, when my kids went to the library, they had to be able to cursively write their name to get the card. So if you have kids going there, they'll, that's the Manchester one.
Mm-hmm.
But at this point in time, they were so proud of seeing their signature every single time. So I don't see them taking my card. So I guess at this point, I'm just explaining to you that not everybody, as far as the kids, I don't know if I see that parents doing that. So.
I'm not sure there's a question there,
Yep.
but maybe there is.
I think it's a more tailored approach, but I mean, I understand
I'm just
the
saying
point you're
that
making.
the kids are like, when the kids go into the library, they don't have a card yet, but they can write their name. They're going to give them a card, and the kids are going to be happy about it. So that's the way it works in Manchester.
Sure. Well, I think, part of I guess my response would be, again, part of, I think, the way to address this is, right, continued parental involvement, right? And with respect to what the child is doing, be aware and having constant and effective communications with one children. I mean, I think it is not unreasonable in these situations, I think, when a parent does not want their children to have access to information without them knowing, to say, I'm not going to allow you to get a card. You shouldn't get a card. I'm going to tell the library you shouldn't get a card, but here's my library card, which gives the parent all degree of access then with respect to the borrowing history. That would be, I think, my preference rather than what I think is a sweeping law here that has privacy implications from my vantage point.
All right. Thank you very much.
Thank you, Mr. Chairman.
I'm sorry, Representative Tripp.
You raised an interesting point. Are minor children allowed to get their own card without the parents' permission?
It's a great. I actually don't know. I would defer to the librarian representatives here today. Whether they can get a card for themselves without parental permission.
Yeah.
I would defer to the librarians in the room on that question.
The gentleman says no.
Okay.
All right. Great. Thank you very much.
Thank you, Mr. Chairman.
Thank you. All right. Anyone else who wishes to testify on HB 273? All right. Seeing none, I'm going to close the hearing on HB 273. Before I let everyone go, I want to raise this issue. And I know we're late, but I also know we have a lot of bills, and I think executing them all is going to be a challenge. So if we can get rid of the executive on two, which I hope we would all be agreeable on, I'd like to do that. So what I would suggest is, and I'm going to ask just for a show of hands initially, I would propose that we exec now House Bill 98. That's Representative Turr's bill on the assistant managers, which is the bill we passed last year. And I would also propose that we exec House Bill 164 FN, which is Representative Alexander's bill on local records retention, which we passed last year. When I say we, I mean the House passed both of these bills last year. And so, I think, and this is what I'm really asking, I think that these should not be controversial and that we would have strong bipartisan support for both of them.
Mr. Chair, I completely agree with you. I would like to actually see if the committee would be willing to do 376 as well. That was the library right to know. It seemed to me with the public hearing there was broad agreement on it, but I just want to leave that for the committee as well.
I am willing. You know what? Why don't we let's just take these in order. Can I just ask informally? This is in no way a formal vote. Informally, how many would be willing to exec and pass HB 98? That's Representative Turr's bill. Representative Bergeron, or where are you on this?
Yeah.
All right.
I'm just looking for it.
Oh, HB 98.
Yeah. Oh, so I don't have 98 right here. I do.
You should. Right.
Just from today, right? Okay.
Yeah.
I
So-
looked at them all.
All right. So let me just ask: is there anyone here who is opposed to execing House Bill 98? That is Representative Turr's bill from last year, which we passed. All right. Seeing none, then I would recognize Representative Smith for a motion.
Thank you. I would like to move ought to pass on House Bill 98 relative to professional limited liability company assistant manager status.
Right. Do we have a second in that? Seconded by Representative Birch. All right, Representative Smith, would you like to
I'd like to
speak to
speak
your
very
motion?
briefly to it. We had extensive testimony last year, and for reasons that had nothing to do with the merits of the bill didn't make it to the final line. And I would suggest that it is appropriate for us now to pass this bill, and one would hope unanimously, and send it to the floor, absent a fiscal note, to send it to the floor without having any to even debate it on the floor, because it does address a problem that could be easily solved by this bill and should be solved in fairness.
All right. Anyone else wish to be heard on HB 98? Seeing none, then I will ask the clerk to call the roll on HB 98.
Representative Mannion,
Yes.
Representative Alexander.
Yes.
Representative Tripp,
Yes.
Representative Andrus. Good job. Absent. Representative Perez. Clerk votes yes. Representative Smith.
Yes.
Representative Horgan.
No.
Representative
I
Birch.
I'm
Yes.
Okay.
Representative Page. Oh, absent. Sorry. Representative Manos.
Yes.
Ters absent. Representative Rombo.
Yes.
Can I?
Representative Bergeron.
Yes.
And Chairman Lynn.
Yes. And Representative Oregon, did you want to change your vote?
Yes. From I like change it to from no to yes. So.
All right. So
Thank you. So 1, 2, 3, 4, 6,
So that's 13.
10, 11, 12, 13. 13 to 0.
13 to 0.
Motion
And can this go on consent? Anybody object to this being on consent? All right, the bill will be on consent. Representative Smith, could I ask you to prepare
My pleasure.
Who seconded that motion?
Representative Birch?
Thank you,
Birch
sorry.
seconded it. Yep. And
Okay.
all right. Next, I would like to turn to, again, and I'm just informally first. This is Representative Alexander's bill relative to local records retention. Again.
What number?
It's HB 164 FN. This bill was, passed by the House last year. It seems to me it's a very sensible and also very important bill that calls for a modernized and electronic system of local records retention. So again, can I just ask for a show of hands? Is maybe the best way to do that. Is there anybody that would oppose execing HB 164 FN right now? All right, seeing none, then I would entertain a call on Representative Alexander for a motion.
I move ought to pass on 164.
Is there a second?
I second.
Representative Smith seconds the motion. Representative Alexander, you want to speak to the
No,
motion?
Mr. Chair, you said it so eloquently. I can't follow up.
All right. All right. Anyone else wish to be heard on HB 164? All right. Then I would ask the clerk to please call the roll.
Representative Mannion,
Yes.
Representative Alexander.
Yes.
Representative Tripp,
Yes.
Representative Andrews, Representative Perez. Clerk votes yes. Representative Smith,
Yes.
Representative Horgan,
Yes.
Representative Birch,
Yes.
Representative Page is absent. Representative Manos,
Yes.
Representative Rombo,
Yes.
and Representative Bergeron.
Yes, thank you.
And the chair.
Oh, and the, sorry.
It's all right, no problem. I vote yes also.
Thank you.
All right. Now this is we can't do this on consent, right? We can't do it on consent. All right.
Oh, wait a minute. Is there, it would,
It has a fiscal note. There's $150,000
Yes.
cost to be.
This is going to go to
Yeah.
finance. It's
Yeah.
going to go to finance next, but I think we can't even put it on consent. Because
Yeah, we can't.
Yeah,
Because
so
it
we
spends
can't.
money.
So it'll go on the regular
I
calendar.
bet it might end up in the budget too.
Right.
But that's,
Representative Alexander, can you write the report on this? Okay. And you know what, both Representative Smith and Representative Alexander, could I ask you, please, if you could get the reports to me by, say, tomorrow evening? By tomorrow at the end of the day? And I think probably you can both just copy the reports that you wrote last year, changing the date. All
oh,
right.
that would be. Oh, okay.
All right. All right, so let me turn to the last one we arguably could exec, and that is HB 376. I don't know. Representative Alexander believes that there's a consensus on this. If there is, can I ask, would anybody be opposed to execing HB 376 now? And I assume.
I missed the hearing, and so I'm a little behind the eight ball on this one. I'm apologizing.
No, that's okay. I understand. This is the one that would have it would basically say, the current law says library user, and this would say that includes the library card and the
Library membership status.
Representative Manos.
I personally would rather refrain and think about it, particularly given that Representative Smith wasn't here.
All right. And Representative Smith, I take it you have you.
Well,
would
I
wanna-
don't know.
Yeah. No. I think I get. Yeah. No. Listen, I hear you, and I should say, just so there's no misunderstanding. Despite the questions that I had for the prime sponsor, I also will support this bill because I think it makes a lot of sense. But nonetheless, I think given Representative Manos' concern and also given the hour, I think I'm gonna pass on executing that. Representative.
I would just agree. I think it's entirely possible that there will be a broad support. I just think there were a lot of questions, and it might be worthwhile for us to have some.
No,
time
I don't
to
want to.
discuss
I don't
them.
want to.
Thank you.
I don't want to do this if anybody has any concern. So, we'll thank you everyone for a long day. I very much appreciate it, and we'll.
Okay.
I'm done. Yes, absolutely.
As I think excuse me. Yoo-hoo.
Hang on.
Yoo-hoo.
Let's listen to Representative Smith.
It is my understanding that on Monday, well, no, let me reword this. Could you please, Mr. Chair, explain to us what we should anticipate on Monday?
Yes, I will do that. No, that's a very good. So first of all, the amendment is I believe is now public. I mean, under the rules, it has to be public for at least 24 or 40. I don't remember which, but anyway, the amendment should be public. So what I anticipate will happen on Monday is that we will have a hearing on HB 476. at some point when that hearing is over, we will have a hearing on the non-germane amendment to HB 476. And then everyone should be prepared for execing the bill and the non-germane amendment at the end of that hearing. Can I absolutely guarantee that we will do that? No, but everybody should be on board that, that is a very definite possibility that we will do that. And so you should, both caucuses should have all their people present or substitutes.
Okay. Not having seen the amendment, could I ask you if the amendment begins by saying that the amendment completely replaces the text of the bill?
It does. That's exactly what it says. It completely replaces the text of the bill.
Thank you.
And it is an abortion statistics reporting bill.
Okay. Could I ask, could I ask that, and that hearing is to begin at 9:30?
That hearing is to begin at 9. Yeah, I believe we are beginning at 9:30. Yes. Wait a minute. Hang on. I've got my 9:30. That's right. Yes.
Good. Could I ask that the Democrats meet at 9 o'clock to go over the amendment? Because it would either be then, Mr. Chair, or we would have to do it, at some point later in the morning, and I don't want to have to do that. And I will agree for a place where we can meet, so that we can review the language of the amendment.
No, that's fine. So, all right. We'll plan that you're going to be.
I won't be
gonna
here. We're meeting, is it it's in Reps Hall, right?
In Reps Hall, yes.
Yeah, okay, so I'll arrange for us to meet in the State House, so people don't have to go back and forth. What? Yeah, I haven't either.
Okay. Amendment. Right. Okay, as I say, my understanding is under the rules, it needs to be published, it needs to be available. I think it says in the Sergeant at Arms office, it's either 24 or 48 hours.
Yeah, but
prior.
today's only Wednesday, I believe. It might not be, but I think it's Wednesday. We're talking about Monday. So that gives us Thursday and Friday. I would hope that the amendment is in fact in the calendar that comes out tomorrow night. But I don't know that. But meanwhile, if you have a copy of the amendment, Mr. Chair, perhaps you would be so kind as to send that through email to everybody on the committee.
That's fine. I don't have a hard copy, but I do have the.
Don't care about a hard copy.
And I will send that out tonight when I get home, because I don't have my computer here with me, but I'll send it out tonight.
Okay. You, of course, have access to a computer as chairman. It's right on your desk. But you don't have to use it. It's okay.
Yeah, right. I haven't used it in so long, I have no idea what the password is on that computer. I have no idea.
Okay. I understand that. I have trouble enough with my passwords. I can understand you do. Okay,
right.
So I will notify the.
Yeah, and I will get that out to everyone tonight.
Okay, thank you very much.
All right. All right. Any further business? All right, I think we are adjourned. Thank you, everyone. Thank you for hanging in there.